Write your own notes to understand easily.
Okay, law of contract. Contracts are important in our daily lives, not just in business. They are like promises that the law can make people keep. To have a contract, there are two things needed: an agreement and the law's ability to make sure people stick to their promise. Some promises are not meant to be legally enforced. For example, when a husband promises to give his wife a gift on her birthday, it's not a contract because it's a personal promise. Types of contracts. So the first one, express and implied contracts. Express contracts are clearly written or spoken, while implied contracts are understood from how people act. For example, if you enter Matatu, you are expected to pay fare. Valid, void, and voidable contracts. Valid contracts follow all the rules and are legally enforceable. Void contracts are not valid because they break the rules of a normal contract agreement, whereas voidable contracts can be cancelled by one party if something unfair happens. Illegal and unenforceable contracts. Contracts that break the law can't be enforced. Unenforceable contracts are valid but have problems like missing paperwork. Unilateral contracts involve only one person doing something, like offering a reward for a lost property. In bilateral, both people have promises to keep. Executed and executory contracts. Executed contract means both people did what they promised. An executory contract means they still need to do what they promised in future. Specialty and simple contracts. Specialty contracts are fancy with seals and signatures, while others are simple and can be spoken or implied. Contracts of utmost good faith. Some contracts, like insurance, need both parties to share all important information honestly. If they don't, the contract can be cancelled. Quasi-contracts. These are like unofficial contracts the law makes when it's fair to do so. For example, if you find someone's lost stuff, the law says you should try to return it, even if you didn't agree to do so. These contracts of record are contracts made by a court, like judgments or promises to behave well when someone gets into trouble. In simple terms, contracts are like promises that the law can make people keep. There are many types of contracts, and some are more serious and enforceable than others. So let's move on to the, what do we call this? Essential elements of a valid contract. In simple terms, a contract is like a promise that two or more people make to each other, and it's only valid if it has certain important elements. One key thing to remember is that not all promises are contracts. To make a contract, you need an agreement, but just having an agreement is not enough. It has to be a promise that the law can enforce. Here are the essential things for a valid contract. Number one, offer and acceptance. One person has to make a clear offer and another person has to accept it. You can't make an offer to yourself. There have to be at least two people involved. Capacity to contract. Both parties have to be old enough, that is over 18 and older, and of sound mind, and not banned from making contract. For example, minors or someone declared bankrupt can't enter into a valid contract. Intention to create legal relations. In most cases, the parties must intend for the agreement to be legally binding. Business agreements are generally considered to have this intent unless stated otherwise. Lawful objectives. The purpose of the contract must be legal and not against public policy. You can't make a contract to do something illegal like stealing. Lawful consideration. Each party must get something in return for their promise. This is called consideration. Without it, the contract is not usually valid. Free consent. Both parties must agree to the contract without being forced, tricked, or influenced unfairly. The contract must be based on something that's possible to do. If it's impossible, the law cannot enforce it. The contract must follow any legal requirements like being in writing, having witnesses, or paying certain taxes if needed. Let's move on to types of offer. Specific offer. This is an offer made to a specific person or group, and only they can accept it. General offer. This is an offer made to the public at large, and anyone who meets the terms can accept it. Cross offers. When two parties make the same offer to each other without knowing about each other's offer. These don't create a contract. Counter offer. If the person receiving an offer changes the terms in their response, it's a counter offer and it cancels the original offer. Conditional offer. An offer with certain conditions that must be met for it to be accepted. Let's move on to differences between offer and invitation to treat. An offer is a clear promise, while an invitation to treat is an invitation to negotiate or make an offer. For example, displaying goods with prices is not an offer to sell, but an invitation for customers to make an offer to buy. Let's talk about termination of an offer. An offer can end in several ways. By making a counter offer. If one party dies or becomes incapacitated, if the offerer revokes the offer before it is accepted, if the offeree rejects the offer, if the offer has a time limit and that time passes, if the offer is accepted. Acceptance is when the person receiving the offer agrees to its terms. It must be communicated to the offerer, be clear and unconditional. Follow the mode described and be made within a reasonable time. Let's move on to consideration. Consideration is something important in making agreements. It's like a benefit or a loss that both parties agree to when they promise something to each other. If there's no consideration in an agreement, it's not a valid agreement, except for some special cases. There are three types of consideration. Executed consideration. This is when you give something or do something at the same time you promise it. For example, if you get paid money to deliver goods, the money you receive is the executed consideration for your promise to deliver the goods. Let's move on to the second one. Executory consideration. This is when one party promises to do something in the future and the other party promises something in return for the future action. For instance, if one person promises to deliver goods in the future and the other promises to pay for them when they arrive, that's executory consideration. Past consideration. This is when you do something or give something before making a promise. If someone helps you and later you promise to pay them for that help, it's past consideration. Usually for a promise to be valid, it needs either to be executed or executory consideration. Past consideration doesn't usually count as consideration, but there are some exceptions. A. If someone asked you to do something in the past and you did it, and then they promised to pay you for it, that's valid past consideration. B. In some cases, even if someone wasn't legally obligated to do something, their promise to do it can still be considered valid if it's based on a moral obligation. C. If someone had a legal duty to do something and they promised to do it, that promise is valid because they were already legally obligated to do it. D. In cases of involving bills of exchange, promise to pay an old debt can still count as valid consideration. E. When it comes to debts that are past the time limit for legal action, if someone acknowledges in writing that they owe the debt, it becomes valid consideration and the debt is treated as if it's not past the time limit. Let's talk about rules about consideration. So, the thing given as consideration must be real and not something made up or imaginary. It doesn't have to be a lot, but it should have some actual value that can be measured in money. Love and affection by itself does not count as consideration. Consideration cannot be illegal, wrong, or against what's considered good by society. Promises involving illegal stuff do not count. Number 3, if someone promises to do something they are already legally or contractually obligated to do, it's not good consideration because it doesn't add anything new. Like if you promise to do your homework, that's not a valid promise because you are already supposed to do it. Number 4, consideration doesn't have to be the same value as what you're getting in return. It's up to the people making the agreement to decide if it is fair, but it should be something valuable under the law. Consideration should be something that happens either now or in the future. Things that already happened in the past usually don't count except for some special cases. Number 6, the action that's the consideration should be done because the person who made the promise wanted it to be done. If someone else did it without being asked by the person who made the promise, it might not come. Consideration should come from the promisee, or it can come from a third person, but that person has to be part of the contract too. Number 8, the final one, consideration can be an action like doing something, or it can be not doing something you have the right to do, or it can be a promise to do something in the future. Let's move on to doctrine of privity. In simple terms, the rule of privity in contracts means that only the people who make a contract can sue or be sued based on that contract. It's like a special legal connection between them. There are 2 important things about this rule. Number 1, if you are not part of the contract, you can't take legal action about it, even if the contract benefits you or you give something for it. Number 2, a contract can't make someone else have legal responsibilities or rights if they weren't part of the contract. But there are some situations where these rules do not apply. Number 1, if a contract creates something for someone's benefits, like giving property to be held for another person, that person can use the contract even if they are not part of it. Marriage, family, or property agreements. If an agreement is made in connection with marriage, dividing property, or arranging family matters and it benefits someone, they can use it in court even if they weren't part of the agreement. For example, if 2 brothers agree to use some money for their mother's support during a property division, the mother can enforce this agreement even though she was not part of it. Let's move on to number 3, which is acknowledgement or estoppel. If someone's actions or words make it seem like they are working on behalf of another person, that other person can sue them. For example, if someone takes money from the other person to give to another person and then he admits to the other person that they got the money, the first person can take legal action against the person who gave him money as if he was acting on his behalf. Assignment of contract. If someone is given the rights and benefits of a contract and the contract doesn't require personal skills, they can enforce it even if they weren't part of the original contract. For example, if someone holds a promissory note, they can demand payment from the person who holds the money, even if they weren't part of the original lending agreement. Contracts through agents. If an agent makes a contract for someone else and has the authority to do so, the person they represent can enforce the contract. Contracts related to land. If land is sold and the new owner knows about certain agreements related to that land, they have to follow those agreements even if they weren't part of the original contract. So let's talk about when the contract without consideration is void. So most agreements need something valuable. So that something valuable is what we call consideration. But there are some special cases where an agreement can be valid even without consideration, which is something valuable. So, number 1, love and affection. If family members agree in writing and register it out of natural love and affection, the agreement can be legally binding even if there is no valuable exchange. For example, father promises to give his daughter money because he loves her, and they put it into writing and register it. The father won't get any benefit, but the child will get a benefit. so there is no consideration for the father. Compensation for voluntary services number 2. If someone promises to pay another person for something they did voluntarily in the past, it can still be a valid agreement. For instance, if you find someone's lost wallet and return it and they promise to pay you afterward, this promise is enforceable even though you didn't expect payment when you did the good deed. Number 3, promise to pay old debts. If a debt is considered too old to be legally enforceable, but the debtor writes and signs a promise to pay it, that promise becomes legally binding even without new consideration. For example, if someone owes money for a long time and they write a promise to pay it, that promise counts even if they didn't give anything new in return. Let's move on to the 5th one. Agency contracts. Creating an agency relationship where one person acts on behalf of another doesn't require consideration. It can happen even without a formal agreement between the parties. Number 6, specialty contracts. Some contracts are considered special and can be legally binding even without consideration. These are usually contracts made under seal or deed. When a contract is under seal, it means it has an official seal or mark and is legally valid without needing consideration. Let's move on to doctrine of promissory or equitable estoppel. In simple terms, most contracts need something valuable to be valid. However, there's a rule called estoppel that helps in situations where common contract rules might be too strict. Estoppel means that if someone makes a clear and honest statement to another person and the second person relies on that statement to their detriment, the person who made the statement can't later deny it. The statement is legally binding even without consideration. So if you promise your friend that you won't charge them rent for a year, and then later you change you change your mind and demand rent for that year, it would be unfair. So there are 2 cases that show how estoppel works. So let's take the case of Central London property versus High Trees House, where the landlord agreed to accept lower rent during World War II when the flats were hard to rent out. Later they demanded full rent. The court said the promise to accept less rent was binding because it would be unfair to go back on it. The second case was Century Automobile versus Hutchings Bremer. The landlord promised the tenant that they wouldn't terminate the lease for several years. Based on the promise, the tenant spent money on renovations. When the landlord tried to terminate the lease, the court said they couldn't because of the promise. Okay, so let's move to the conditions that must be met for estoppel to apply. So A, there must be an existing contract between the parties for estoppel to apply. The promise made should be clear and not ambiguous. Number C, the person making the promise must have intended for the party to rely on it. Number D, the other party must have actually relied on that promise. Number E, the other party's reliance must have caused them some harm or loss. And the final one, F, it must be unfair for the person making the promise to go back on it. So however, estoppel has 2 limits. Roman 1, it can only be used to defend yourself like a shield and not to start a legal action against someone else like a sword. Number Roman 2, it's only available if the person using estoppel has acted fairly in the situation. For example, in the first case mentioned, the tenant acted fairly by reducing rent for their subtenants. Let's move on to the capacity to contract. This means the ability of people to make contracts legally. So for a contract to be valid, the people involved must have the capacity to make it. They must be old enough, mentally sound, and not prohibited by the law. If someone lacks the capacity to contract, the contract can either be voidable or unenforceable, depending on the situation. But usually the law assumes that everyone can make contracts. So let's move on to people who cannot enter into a contract. So these are minors or infants. Minors are people under 18 years old. They are protected by the law because they might not fully understand the contracts. In most cases, contracts with minors are void, which means they are not valid from the beginning. Even if a minor lies about their age, the contract is still void. However, a minor can benefit from the contract and the other party can enforce it if it benefits the minor. So the minors can, when they become adults, they can't just agree to a contract that they made as a minor. So they need to create a new contract with fresh consideration. So another thing is you can't force a minor to carry out a contract. But if a parent or a guardian makes a contract on behalf of a minor and it's for the minor's benefit, it can be enforced. So minors also cannot be forced to enter into partnerships, but they can be admitted to existing ones with everyone's consent. So minors can't be declared bankrupt also because they can't incur debts. Okay, minors can act as agents, but their parents or guardians aren't liable for their contracts unless they specifically authorize them. So, liability for necessaries. Minors are responsible for paying for things that are necessary for them. If it's their property, not them personally, but that is liable for payment. So minors can also be held responsible for the actions causing harm, but not if the harm rises directly from a contract. So if a minor receives goods or services that are essential for their well-being, they have to pay for those, but it's their property that is responsible for the payment, not the minor personally. So let's talk about necessary. So necessary services. These are services like education, training, medical care, and legal services that are considered necessary for a minor. If a minor contracts for these services, they are responsible for payment, but again, it's their property, not them personally, that is liable. Necessary goods. So these are items a minor needs for their condition in life, not just to survive. For instance, a suit might be necessary for a minor, while it's a luxury for a poor one. Okay, so in essence, minors are protected by the law when it comes to contracts because they may not fully understand the consequences, but they are still responsible for essential goods and services that they receive. So what we can conclude from that is, as you can see, if a minor tries to enter into a contract, maybe they buy something, they have to pay for it even though they are minors. Let's move on to number 2, which is persons of unsound mind. For someone to be considered mentally capable of making a contract, they must understand the contract and make a rational judgment about how it affects their interests. The law generally assumes that everyone is mentally capable of entering a contract unless proven otherwise. To determine if someone is mentally sound, the court looks at the following. Can the person understand what the contract is about and what it says? Can the person make a reasonable decision about whether or not to enter into the contract? Okay, so these are people who are not mentally sound and cannot enter into contracts. So the first one is lunatics. These are people who have periods of sanity and insanity due to mental issues. They can make valid contracts during their sane periods, but not when they are not in their right mind. So the second one is idiots. These individuals have completely lost their mental abilities and can't even understand basic things. Idiots are permanently unable to make contracts, and any contract they try to make is void from the beginning. Drunken person. So these are people who are drunk and under the influence, and they can't think clearly, so they can't make valid contracts. So let's move on to corporations. And so there are two main ways that a corporation can come into existence, and this is by an act of parliament and by registering under the Companies Act. However, in simple terms, a corporation is a legal entity created by the law, and it must follow specific rules when making contracts. If it breaks these rules, the contract is not valid. So if a corporation breaks the rules of a contract, the contract will not be valid. Okay, so let's move on to married women. So under the common law of England, a married woman could not enter into contract on her own without involving the husband. However, through the application of the English law, a married woman now can sue and be sued on all contracts entered into by her without making the husband liable. A husband is not liable for his wife's contracts unless the contracts were entered into on his behalf or at his request. Where husband and wife are living together, the wife is entitled by law to pledge his credit for necessary goods and services. A deserted wife can also secure necessary goods and services on behalf of the husband and make her husband liable to pay for them. So number 5, alien enemies. So an alien enemy is a person who is not the subject of the Republic of Kenya. He may be an alien friend or an alien enemy. An alien friend means an alien whose country is at peace with Kenya. Such a person can enter into a valid contract. However, an alien enemy is a person whose country is at war with Kenya. Such a person cannot enter into a valid contract during the period of war. So any contract entered into before the outbreak of war are either suspended or dissolved. Okay, let's talk about trade unions, number 6. So trade unions are incorporated associations established by the Labor Relations Act as bodies cooperate with the capacity to sue and be sued, enter into contracts and own property both immovable and immovable. Every trade union is liable on any contracts entered into it by an agent or acting on his behalf. However, there are certain actions which cannot be entertained in the courts. The trade union has immunity from prosecution for any act done by it or its officials while pursuing trade union objectives. So insolvents, these are people who have been declared bankrupt. In this case, when you're declared bankrupt, the official receiver gets your property, and it's only the official receiver and not you, the bankrupt person, that can enter into the contracts relating to the property. Unless the court passes an order of discharge, the insolvent suffers from certain disqualifications in participating in contracts. Let's move on to number 8, the final one, which is convict. So a convict is a person who has been tried by courts for criminal acts and sentenced accordingly. A convict is incapable of entering into a contract when he's undergoing imprisonment. This incapacity comes to an end when the sentence expires or when the convict is pardoned. So, yeah, if you have been in jail, you cannot enter into contracts. So, let's talk about vitiating factors, elements in a contract that can make it to be void. So, I hope you remember what void means. If you don't, you can go back to this video. Number 1, coercion or duration. So coercion takes place when a person is compelled to enter into a contract by the use of force. So coercion basically is about physically forcing someone to do something. So, for example, if a husband threatens to shoot his wife if his wife does not lend him money, and the wife lends him money, this is coercion. So, when consent to an agreement is obtained by coercion, the contract is voidable at the option of the party whose consent was obtained under coercion. So let's talk about undue influence. So undue influence is the opposite of coercion or duress. So undue influence is using power, is when one person has a lot of power or control of another person and uses that power to make the other person agree to do something. So the person has authority or some influence over that person, and the victim is in a trusting relationship with the person who is trying to finesse the person, and they take advantage of someone who is not in their right mind because of age, illness, or stress. So the law assumes that undue influence exists in certain relationship, like between a parent and a child, or a doctor and a patient. But there is no assumption of undue influence in relationships like between a husband and wife, or a landlord and a tenant. So the differences between coercion and undue influence. So coercion involves use of threats or force, while undue influence is more about using moral persuasion. So undue influence is about seducing someone. So coercion is physical, and undue influence is more about manipulating someone's feelings or thoughts. So coercion intention is to make someone do something against their will, while undue influence is about getting an unfair advantage through a position of power. Legal consequences. So coercion is a criminal act. However, undue influence is not a crime. It's just a moral wrong. So when someone agrees to something because of undue influence, they have the option to cancel the agreement. So if someone uses undue influence to get you to agree to something, you can choose to void the agreement. Okay, so let's move on to misrepresentation. So remember, we are still in the elements that can make a contract void. So these are basically elements that can make a contract to become useless. And so misrepresentation is when someone says something during negotiations to persuade the other person to make a contract. This can be a direct statement or something implied. Misrepresentation is when someone says something they genuinely believe is true or they don't know is false, and they say to make the other person agree to a contract. So what you should know about misrepresentation. So the first thing you should know about misrepresentation is it's about saying something important and factual. Number 2, the statement must be made before the contract is finalized with the aim of getting the other person to agree. Number 3, the person making the statement must want the other person to act based on what they said. Number 4, the statement should genuinely affect the decision of the other person and lead them to make the contract. What's going on here? Number 5, the intention of misrepresentation is not to deceive or trick the other person. When someone agrees to a contract because of misrepresentation, the injured party has two options. They can cancel the contract or choose to keep it but ask for compensation for any losses caused by the misrepresentation. So let's talk about fraud. So fraud can also make a contract void. So here are the things to understand about fraud. So it is about intentionally deceiving or cheating someone. So fraud involves making false statements. It is not just opinions or rumors. So the false statements must be about important facts, things that matter, not just personal opinions. These false statements must be made before the contract is finalized. The person making these false statements must want to fool the other for it to be called fraud. They must either know what they are saying is false, not believe it's true, or be careless about whether it's true or not. The other person has to believe these false statements, act on them, and suffer some kind of loss as a result. When a contract is based on fraud, the person who was deceived has some choices. They can cancel the contract as long as no third party has gotten involved, demand the contract to be fulfilled while asking for compensation for losses, or sue for damages. So let's talk about differences between fraud and misrepresentation. So in fraud, there's a clear intention to deceive, while in misrepresentation, there's no intention to deceive. The person providing false information in representation believes it to be true. Number 2, in misrepresentation, the person making the false statement genuinely believes it's true, while in fraud, they know it's false or don't believe it's true. When misrepresentation happens, the deceived party can usually cancel the contract or ask for compensation but can't sue for damages. In the case of fraud, the deceived party can cancel the contract, seek damages, or both. So the final one, if the deceived party could have easily find out the truth with some basic research, they can't cancel the contract due to misrepresentation. But in fraud, even if they could have found out the truth with some effort, they can still cancel the contract. So the big difference is that fraud involves an intentional effort to deceive, while misrepresentation doesn't have the intent to deceive. Let's move on to mistake. So So mistake is when someone believes something that isn't true. There are two types of mistake. So mistake of law means not knowing or misunderstanding the rules of law. Ignorance of the law is not an excuse, which means not knowing the law doesn't get you off the hook. Mistake of fact is when you are wrong about some important fact in a contract. There are two kinds of mistake of fact. Happens when both people in a contract are wrong about something. Unilateral mistake, this is when only one person is wrong about the facts. Let's move on to, so basically if you make a mistake because you didn't know the law, tough luck. But if you and the other person both make a big mistake about the facts, the contract can be cancelled. And if you're the only one who messes up, it's usually not enough to cancel the contract unless it's a really important mistake. So let's move on to legality of objects. So in any agreement, the purpose of the deal has to be legal, not immoral, and not against what's good for society. If any agreement breaks these rules, it can't be enforced. The law doesn't support illegal deals. There are different situations where the purpose of an agreement can be illegal or against the law. Number one, if it's against the law like a crime, the agreement is not valid. For example, if someone promises to get another person a government job in exchange for money, that's illegal if it defeats other law. For instance, if someone agrees not to use the defense of time running out in a lawsuit which is allowed by the law, is not valid because it goes against the law. Fraudulent. For example, if a person makes an agreement with creditors to avoid paying debts, that's not allowed. Harmful to others. For example, if a newspaper owner agrees with the printers to print false and damaging stories, that is illegal, immoral. If someone agrees to let their daughter be in an immoral relationship in exchange for something, it's not valid. Against public policy. If the agreement goes against what's good for society, it's not allowed. In these cases, the agreement can't be enforced by law. So agreements must follow these rules to be valid and enforceable. If they break any of these rules, they are not legal agreements. Unlawful agreements. Unlawful and illegal agreements are both not allowed by the law, but they have some differences. Illegal agreements are against the law, like planning to commit a crime. For example, agreeing to steal is illegal. Let's talk about unlawful agreements. They break some law, but not necessarily criminal law. They might not be fair or might harm someone's rights, but they don't involve direct criminal actions. So these are the points you should know about illegal agreements. They are always unlawful. Unlawful agreements may not always be illegal. They might just break other laws or be unfair. Now, what happens when an agreement is illegal or unlawful? Number one, it taints collateral transactions. This means that if an agreement is illegal, it makes other related transactions illegal too, even if they would have been legal on their own. Number two, no legal actions. You can sue to get back money or property involved in an illegal agreement or for breaking such an agreement. So basically, you cannot sue to get back money or property involved in an illegal agreement or for breaking an agreement. Equal guilt. Number three, equal guilt. If both parties are equally guilty in an illegal agreement, the person who breaks the agreement might have a better legal position than the one trying to enforce it. Agreements opposed to public policy. So agreements against public policy are those that go against what's good and right for the society. These agreements are not allowed by the law. Here are some types of agreements that are against public policy. Trading with the enemy. Making agreements with enemies during war is illegal because it can help the enemy. Number two, if you agree to do something illegal, the law won't enforce that agreement. Number three, agreements that try to interfere with the normal process of the legal system are not allowed. This includes trying to bribe judges. Maintenance and charm party. Number four, these are agreements to help someone with a legal case when you don't have a real interest in it. These are also not allowed. Number five, restraint of legal proceedings. If an agreement stops someone from using their legal rights, it's not valid. Number six, trafficking in public offices and titles. You can't make agreements about buying or selling public jobs. Creating interests opposed to duty. Agreements that create conflicts of interest with a person's responsibilities are not allowed. For example, if a newspaper owner agrees not to criticize a certain person, it's not allowed. Number 8, restricting parental rights. You can't make agreements that give up your rights as a parent. Number 9, restricting personal liberty. Agreements that limit a person's freedom are not valid. For example, an agreement that says you can't change your job without permission. Number 10, restraint of marriage. Agreements that try to stop someone from getting married are not allowed except for minors. So I think those 10 are enough. Let's move on to discharge or termination of contract. So discharge of contract means ending a contract. It happens when the things both parties promised to do in the contract are done and they no longer have to keep these promises. This can happen in different ways, such as performance and agreement. It can also happen through breach if one party breaks the contract, through frustration if something happens that makes it impossible to carry out the contract, like a fire destroying a venue. Operation of law if the law orders you to end the contract. So let's look at the discharge by agreement. Let's study it in depth. Just as people agree to make a contract, they can also agree to end it. This happens when both sides decide they don't want to continue the contract. They can agree to end it in a few different ways. So under discharge by agreement, you can start with the number 1, which is novation. Novation, this is when a new contract replaces the old one between the same people, or one person agrees to pay someone else instead of the original person. So that one is basically self-explanatory. So let's talk about number 2, which is rescission. If both parties agree, or if one person doesn't do what they promised, they can cancel some or all of the terms in the contract. For instance, if A promised to sell goods to B in 6 months, but those goods are no longer wanted, they can cancel the contract. Number 3, alteration. If both parties agree, they can change some parts of the contract. This change means the old contract is no longer in effect. Remission or accord and satisfaction. If one party accepts less than what was originally promised as full payment, it can discharge the whole debt. For example, if someone owes a debt, they might agree to accept a smaller amount as complete payment. So waiver. Number 5 is called waiver. When both parties decide to give up some rights they had under the contract, it means they no longer have to follow the contract. Merger. Sometimes a better right a person has under the same or another contract makes their previous rights less important. In this case, the old rights merge into the new and better ones. So this basically means that a person might find better rights in a newer contract and decide to accept that newer contract. So that is, we are done with the first one, which is discharge by agreement. So the second one is discharge by performance. So discharge by performance is when people fulfill what they agreed to do in a contract. It's called performance. A contract is finished or discharged when both sides do everything they promised. However, there are situations where doing part of what was promised can still end the contract. So the first one is divisible contracts. If the contract can be split into smaller parts, like separate agreements, each part can be discharged when it's completed. Number 2, prevented full performance. If one person in the contract is ready to do their part, but the other person stops them from finishing, the contract ends. The person who has stopped can sue for damages and ask to be paid for the work they did. Accepting partial performance. Number 3, if one party accepts part of what was promised as enough, it can end the contract. This is like agreeing that the job is done, even if it's not everything that was initially agreed upon. Number 4 is substantial performance. If someone does most of what was agreed upon but not everything, they can still get paid for the work they did minus what it would cost to finish the rest. Tender of performance. Number 5, if one side is ready to do what they promised but the other side refuses to accept it, the contract can end because of this refusal. Number 6, the final one, tender of payment. When someone offers the exact amount of money they owe at the right time and place and it's refused, they are no longer responsible for delivering goods. But if they offer money and it's refused, they still owe the money. To offer money properly, it has to be in the right currency, notes or coins. So completing everything in a contract usually ends it, but there are exceptions where partial or attempted completion can also finish the contract. So let's move to discharge number 3. This is discharge by frustration or impossibility. In simple terms, if you agree to do something in a contract but it turns out that it's impossible to do, then the contract is invalid from the start. This is because the law doesn't make you do things that are impossible. There are two kinds of impossibility. Number 1, if both parties know something is impossible when they make the contract, it's called absolute impossibility and the contract is void from the beginning. Number 2, if something becomes impossible to do after the contract is made, it's called supervening impossibility or frustration. In this case, the contract can be cancelled if something unexpected and beyond the control of both parties makes it impossible to carry out the contract. There are a few situations where a contract can be cancelled due to impossibility. Number 1, if the thing that the contract is about gets destroyed through no one's fault. For example, if a concert hall burns down before a concert, the contract to use the hall for concerts is cancelled. Number B, if someone's personal ability is crucial for the contract and they die, for instance, if a singer gets seriously ill and can't perform, the concert can be cancelled. Number C, if a contract depends on a specific event happening or not happening, and that event occurs or doesn't occur, the contract can be cancelled. For example, if someone rents a place to watch a parade but the parade gets cancelled, they might not have to pay rent. D, if the law changes or the government changes, or the government does something that makes it impossible to follow through with the contract can be cancelled. For example, if a contract relies on building something on land but the government takes the land for public project, the contract must be cancelled. And the final one, E, if a contract is made with an enemy during war, it is illegal and can't be carried out. Contracts made before the war might be put on hold during the war and reactivated afterward. For instance, if you agree to buy something to a foreign country, but your country goes to war with that country, the contract is cancelled when the war starts. Let's talk about effects of frustration. When something happens that makes it impossible to carry out a contract, the law in the Contract of Act of 1961 said that the contract doesn't continue in the future, but is not considered invalid from the start. Here's what else happens. A, if you've already paid money for the contract, you can get it back. B, if you are supposed to pay money as part of the contract, you don't have to pay it anymore. C, if you did some things that you are supposed to do in the contract before it got messed up, you might be able to get compensated for that part. So we are done with that discharge. So we move on to discharge number 4, which is discharge by expiry or lapse of time. So there's a law called the Limitation of Actions Act, which says that if you have a contract that has a time limit for when things should happen, you need to do those things within that time. If you don't, and you don't take legal action within a certain time limit, you lose the right to use the law to fix the contract. In that case, the contract is over. So let's talk about the 5th discharge, which is discharge by operation of law. So this is when the court ends the contract, and this can happen in the following situation. If someone involved in the contract passes away, the contract depends on their personal skills or ability, the contract ends. In other cases, the rights and responsibility of the person who passed away get passed to their legal representatives. Insolvency, if someone is declared bankrupt or insolvent, they are no longer responsible for any contracts they made before that declaration. Those contracts are cancelled. Alteration of contract, if one party requests a contract change without the other party agreeing, the other party can cancel the contract by merger of rights and responsibilities. If the rights and responsibility under a contract end up in the same person's hands, like when a bill is accepted, the other parties in the contract are let go. This is done to avoid complicated legal actions. So let's move on to number 6, which is discharge by breach of contract. So breach of contract means someone not doing what they promised to do in the contract. It happens when one party doesn't fulfill their part of a deal without a good reason. When this happens, the other party is no longer obligated to do their part and can take certain actions to fix the situation. So there are two main ways this breach can occur. So the first one is anticipatory breach of contract. This happens when one party in a contract says they want to do their part before it's time to do it, or does something that makes it impossible to do their part. For example, let's say A agrees to sing at B's restaurant on a specific date, but before that date, A signs a long-term contract to sing at another restaurant. In this case, the contract with A and B is cancelled. But here is the key. The contract isn't automatically cancelled when there's an anticipatory breach. The other party has to decide if they want to cancel it or not. They can choose to say the contract is cancelled and they don't have to do their part, take legal action like suing for money or asking a court to stop the breaching party from breaking the contract. Number B, or number 2, actual breach of contract. This happens when during the contract or when it's time to do what the contract says, one party doesn't do what they're supposed to. This refusal can be clear, like saying it out loud or in writing. For example, in a case where a court agreed to supply a railway company with 3,900 tons of railway chairs, and the company said they didn't need more after getting only 1,787 tons. That's an actual breach of the contract by the company. When there's an actual breach, the party that's been hurt can take the various actions like cancelling the contract, suing for money, asking the court to make the other party to do what they promised, and more. So remedies for breach of contract. So when you have a right, you also have to make sure that the right is respected. In a contract, both sides have certain rights and responsibilities. These rights and responsibilities wouldn't mean much if there weren't ways to make sure they are followed when someone breaks them. So a remedy is like a tool given by the law to protect the rights and responsibility. You use this tool through the legal system, like going to court. When someone breaks a contract, the person who's been hurt can choose from the following actions. So let's start with the first one, which is rescission or cancellation of a contract. So rescission is RESCISSION. So when someone breaks a contract, the other person can go to a court and ask to cancel the contract. If the court agrees, it means the contract is no longer valid and both parties are freed from their obligations. For example, let's say A promised to give B 10 bags of corn on a certain day, and B promised to pay them when they arrive, but A doesn't deliver the corn. In this case, B doesn't have to pay for the corn anymore. So the court can order cancellation of the contract when the person who wants to cancel the contract can prove it's their right to do so, or when the contract is illegal for reasons that are not obvious at first, and it's mostly the other person's fault. However, the court might not cancel the contract if A, the person wanting to cancel the contract already agreed to it either directly or indirectly. B, it's impossible to put both parties back in the same position they were in before. C, other people who didn't know about the cancelled contract have gained rights through it in good faith and for a fair price. D, only a part of the contract is being cancelled and that part can't be separated from the rest of the contract. Okay, so when someone cancels a contract, they usually have to give back any benefits they received from the contract to the other person. However, if someone rightfully cancels a contract, they can also ask for compensation for any losses they faced because the other person didn't fulfill the part of the contract. Let's move on to number 2, which is you can sue for damages if someone breaks your contract. So damages are like money compensation given by the court when someone breaks a contract. The idea is try to put the person who got hurt who got hurt by the broken contract back in the same financial position they were in before the problem happened. We call this the doctrine of restitution. There are different types of damages. So number A, ordinary damages. So these are damages that naturally happen because of the contract breach. For example, if someone promised to sell wheat at a certain price and then didn't, the other person might get damages for the extra costs they had to pay. Number B or number 2, special damages. These are damages that both parties could have thought about when they made the contract. They can only be claimed if the special circumstances causing a special loss are told to the other party. For instance, if someone sent goods for an exhibition and they arrived late, causing a loss of profit, they might get special damages if they told the transport company the goods had to be there by a specific day. Number C or number 3, vindictive or exemplary damages. These are more like punishment. Usually damages in contracts are meant to make up for losses, not to punish someone. But sometimes in specific situations, like when a bank wrongly dishonors a check, the court might give this as a form of punishment. Number D or number 4, nominal damages. When someone didn't really lose anything because of the broken contract, but they still prove their case in court, they might get a very small amount of money called nominal damages. It's more like a recognition that they were right. Number E or number 5, liquidated or unliquidated damages. Sometimes in the contract itself, it says that if the contract is broken, one of the parties has to pay a certain amount of money. If this amount is a fair estimate or of the likely loss, it's called liquidated damages. If it's meant to make sure the contract is followed and not to estimate losses, it's a penalty. And liquidated damages, on the other hand, aren't specified in the contract. The court decides how much they should be when the contract is broken. So let's move on to number 3. When someone breaks a contract, you can sue for injunction. So an injunction is like an official order from a court. It tells someone to either stop something. It tells someone to either stop doing something they are not supposed to do or start doing something they should do according to a contract. It's a way that the court can prevent someone from doing a harmful thing. For example, if someone promised not to sing at any other theatre except one and then broke that promise, the court might tell them not to sing at any other theatre through an injunction. So there are different types of injunction. Number 1, mandatory injunction. This tells someone they have to do a specific action according to the contract. It can be temporary. Number 2, prohibitory injunction. This tells someone not to do something. Number 3, interlocutory injunction. This is a temporary order the court gives when the case is still being decided. Number 4, perpetual injunction. This is a permanent order that comes after an interim or interlocutory injunction. Number 5, coitimate injunction. This is when the court acts to stop a problem before it even happens based on plaintiff's fears. Number 6, mareva injunction. This prevents someone from moving certain property outside of the court's jurisdiction, usually outside of the country. So let's move on to number 4. So your 4th option is to sue for specific action. Specific performance, So specific performance is like a special court order that tells someone who broke a contract that they have to do exactly what they promised to do in the contract. But this order is not always given. It depends on certain conditions. When an order for specific performance can be crowded when an order for specific performance can be granted is when the thing that was supposed to be done in the contract is so unique that money can't really make up for it. Number 2, when it's hard to figure out how much money can compensate for not doing what was promised. Number 3, when it's unlikely that you can even get money to make up for not doing what was promised. So this is when an order for specific performance won't be guaranteed. When giving money is enough to fix the problem, as you can see here. When the contract is not clear or fair to either party. When the contract can be cancelled or changed. When trustees, people responsible for taking care of something, break the trust. When it's personal contract like a marriage. When a company goes beyond its power in making the contract. The final one, when the court can't effectively make sure the contract is carried out, like in the case of a building contract. So let's move on to the 5th one, which is If someone doesn't break your contract, you can sue upon quantum merit. So quantum merit means getting paid for the work you did when there's no formal contract in place. It's not about compensation for a broken contract like damages, but rather payment for the actual work you did. You can only ask quantum merit if you are the one who did the work and the original contract has ended. So these are the instances where you can ask for quantum merit. So number one is when an agreement is found to be void. If a contract is declared to be void or becomes void and you've received benefits from it, you need to give back those benefits or compensate the person who gave them to you. For instance, if someone worked for a company but later it's discovered they shouldn't have been hired, they can still get paid for the work they did. Number two, when something is done without expecting it to be free. If you do something for someone without intending to do it for free and they benefit from it, they have to pay you for it or return what you did. Okay, let's move on to number three. When there's no agreement on payment. If there's a contract to provide services but there's no agreement on how much you should be paid, the court can decide a fair amount as quantum merit. For example, if you provide services to someone but you didn't agree on the price, the court will decide what's fair. Number four, when one party prevents contract completion. If one party in a contract stops the other from completing their part, the party not at fault can claim quantum merit. For example, if you had someone to write a book but you stopped them from finishing it, they can still get paid for the work they've done. Number five, when the contract is divisible. If a contract can be divided into parts and one party benefits from the part of it, the other party can claim quantum merit for the part they completed. However, if the contract must be fully completed for payment, quantum merit won't apply. For example, if you hire someone to do several tasks and they complete some but not all, they can still get paid for the tasks they finished. Number six, when an indivisible contract is poorly performed. If you have a contract where you are supposed to get paid a set amount for the entire job but you do it poorly, you can still claim the full payment. However, the other party can deduct money for the poor quality. For instance, if you are hired to repair a house for a fixed amount but the repairs are done poorly, you can still claim the full amount minus the cost to fix the mistakes. So number six is restitution of benefits. So restitution means giving back something or returning it. If an agreement or contract is found to be worthless or becomes worthless, anyone who gets something good out of it has to give back or compensate the person who gave it to them. This rule applies to worthless contracts that are discovered or become worthless, but not to contracts that everyone already knows are worthless. For instance, if person A gives person B money to kill person C, A can't ask for the money back because that contract is known to be worthless, and B is not obligated to return that money. Number seven, rectification or cancellation. So if a contract or written document doesn't show what people involved actually agreed to because of lies or a mistake, anyone involved can go to court or fix it. The court can change the document to match what everyone really wanted if they find that there was a lie or a mistake. However, they can only do this if it won't hurt someone who wasn't part of the original agreement and got involved honestly and fairly. Sometimes a written document can cause serious problem for someone if it's not changed. In that case, they can ask the court to say the document is no good and should be cancelled. For example, if person A lied about their ship being safe and person B gave them insurance money because of that lie, person B can ask the court to cancel the insurance policy. So let's move on to quasi-contracts. Quasi-contracts, sometimes a person might get something that the law says really belongs to someone else. even if there is no agreement between them. This kind of situation is called a quasi-contract. Even though there is no official contract, the law treats them as if there were one. So technically, quasi-contracts aren't real contracts because real contracts come from agreements where both parties freely decide to do something. Quasi-contracts are different because they are created by the law without any formal agreement. In simple terms, they are made by the law to make sure things are fair. So, in English law, the idea behind them is that it's not fair for someone to unfairly benefit at the expense of another person just because they didn't have a contract. Quasi-contracts are all about making things fair. So, let's move on quickly to the instances of quasi-contracts. So, number one, supply of necessaries. If someone provides essential things to a person who can't make contracts, like a mentally ill person, and those things are suitable for their needs, the provider can get their money back from the person's property. Number two, payment by an uninterested person. If someone pays money on behalf of another person who is legally required to pay for it, the person who made the payment can ask for reimbursement from the one who should have paid. Number three, obligation to pay for non-gratuitous acts. If one person does something for another person or give them something with the expectation of being paid and the other person benefits from it, they have to pay for it. Number four, responsibility of finder of goods. If someone finds another person's belongings and takes care of them, they have to take good care of those items and try to find their owner. They can sell the items in certain situations, like when they are about to be damaged. Number five, claim on quantum merit. If someone does work for another person without a specific agreement on how much they'll get paid, they can ask for a fair payment for their services. Number six, action for money had and received. If someone gets money through fraud or dishonest means that belongs to someone else, they have to give it back. Number seven, money paid on the total failure of consideration. If someone pays money for something but they don't get what they paid for because the deal completely falls apart, they can ask for their money back. Number eight, payments made by mistake or coercion. If someone receives money or something else by mistake or because they are forced to, they have to return it to the person who gave them. However, if the money was supposed to go to a different person, the mistaken receiver doesn't have to pay the real recipient. In the modern business world, things can get so complicated that it's impossible for one person to handle everything on their own. That is why we have agents. An agent is someone who helps out with business tasks for another person or represents them when dealing with others. Think of it this way. Imagine you need someone to do something for you or represent you in a deal. That person is your agent. The person they are working for or representing is called the principal. An agent can make a contract between the principal and someone else. They are like a bridge that connects the principal and the other person. But once the bridge is built, the contract is made. The agent isn't part of the contract anymore. The contract is now between the principal and the other person, just as if they had made it themselves. Usually, as long as someone is of legal age and mentally sound, they can hire an agent. This means that even a young person can be appointed as an agent because they're just the middle person connecting the principal and others. However, certain people like lunatics, minors, or those who are drunk can't be agents because they might not make responsible decisions. Classification or kinds of agents. Classification of agents as per extent of authority. General agent. This type of agent has the power to do almost anything related to a specific trade, business or job. For example, a manager of a company can make decisions and take actions that are necessary for running the company. They have a wide range of authority. Number two, a special agent is an agent hired for a specific task or job. For instance, if you are an agent to sell your house, the authority is limited to selling the house. Once the job is done, the authority ends. Number three, universal agent. This agent has almost unlimited authority to act on behalf of the principal. They can do a wide range of legal actions and make decisions on behalf of the principal. However, the actions must still follow the laws of the land. They have broad authority, but is not entirely without limits. Classification of agents according to the natures of the work. Brokers, these are people who help others buy or sell things like goods. They don't actually have the stuff they are dealing with, and they can't also own the work. They are just there to make deals between buyers and sellers. They get paid a fee for their service. Factor agent. Factors are agents who take care of goods for selling. They can do all the usual things needed to run this kind of business. They sell the goods as if they own them, decide the terms of sales, and can even give credit. They also have the right to keep the goods until they get paid. Auctioneer, these are people hired by sellers to auction off their stuff to the highest bidder. They earn a fee for this. At first they work for the seller, but once the sale happens, they also become agents for the buyer. If they are told to sell without a minimum price, they can sell to the highest bidder. They can also keep this stuff until they get paid their fee. The fourth one is commission agent. This agent helps others buy things. They get paid a fee or commission for their work. The other agent is the crederic agent. These agents sell stuff for someone else and promise to cover any losses if the buyers don't pay up. For this extra responsibility, they get a higher commission. Bankers mostly lend and hold money for their customers, but they also act as agents when they follow their customers' orders to pay money to someone else. Forwarding agents. These agents help importers and exporters by collecting and delivering goods on their behalf. They know a lot about customs and rules for international trade. Number 8, non-commercial agents. This category includes lawyers, attorneys, legal advisors, legal representatives, advocates, and insurance agents. They provide services in legal and insurance matter but are not involved in buying or selling goods. Creation of agency relationship. The relationship of principal and agent may be created by express agreement, by implied agreement, by necessity, by ratification, or by operation of law. Agency by express agreement. Usually when a boss will call them the principal, gives their worker, the agent, the power to do certain things for them, it's pretty clear. They either talk about it or write it down. Sometimes they use a special paper called a power of attorney to make it official. The paper says, I'm giving you the authority to represent me. In simple terms, the boss tells the worker what they can do, and they both agree on it either by talking or writing down on a special paper called a power of attorney. Number 2, agency by implied agreement. Implied agency happens when it's not explicitly stated but can be understood from how people act or the situation. It's like when you can tell someone is doing a job for another person even though they did not officially say so. For instance, let's say two brothers A and B live in different cities. A, without being told, takes care of B's house, collects rent and sends it to B. Even though nobody said A is B's agent, it is clear from the actions that A is helping B in that way. Implied agency can also happen when the boss acts in a way that makes it seem like someone is the agent, even if they didn't say it. There are 2 types. Agency by estoppel. This means the boss has said or done things that make someone else believe they have an agent. For example, if an agent A tells a third party T that they work for the boss P and P doesn't disagree, then P has to pay T for things A buys on P's behalf. The second one is agency by holding out. This is similar to the first one. If the boss often lets someone buy things on their behalf and then pays for them, even if one time they give that person money to buy things but the person doesn't and buys on credit, the boss still has to pay because they made it seem like a person was their agent before. Number 3, agency by necessity. Sometimes in urgent situations, the law allows a person to make decisions for someone else because there's no time to ask that person for permission. This is called agency by necessity. To make it valid, these conditions must be met. The situation has to be urgent, that waiting to talk to the person in charge isn't possible. Communication is impossible. It must be clear that there is no way to reach the person in charge quickly. The person acting has to do it honestly and in the person's best interest. The person making decisions on behalf of someone else must do it honestly and with that person's best interest in mind. This kind of agency comes up in a few situations. If someone is given fruit to deliver to another place, but the fruit won't survive the trip, they can sell it to avoid it going bad. This is okay if it's done in an emergency and with the best intentions. If someone is in charge of another person's things and there's an accident or emergency, they can sell or use the things to save their value even if they weren't told they could do this. Number 3, if a husband leaves his wife without giving her the means to survive, she can use his credit for necessary things, even if he doesn't agree. In this case, she is acting on his behalf because she has no other choice. Number 4, agency by ratification. Ratification is like giving a thumbs up to something that was done without permission. So if someone does something for you without you telling them to, and you find out about it later, you can either say yes, I'm okay with it, or no, I don't want it. For example, if A buys 5 bags of maize for you even though you didn't ask them to, you can later decide if you are okay with the purchase or not. If you say yes, I'm okay with it, that means you are ratifying or approving the action, and A becomes your agent by ratification. The essentials of a valid ratification include the person acting on your behalf. The agent must clearly say that they are acting as your agent when making a deal. An unknown boss can't suddenly show up and approve of what someone else did on their behalf. The second one is you, the principal, must exist at that time of contract. If you don't exist yet, like a company before it's officially formed, you can't approve contracts made on your behalf. Number 3, you must be legally capable of making contracts both when the original contract is made and when you decide to approve it later. If you aren't legally capable when the contract was made, you can't suddenly make it valid by approving it later when you are capable. When you approve the contract, you should know all the important details about it. However, if you are willing to take the risk of not knowing everything, you can still approve it without all the facts. Number 5, you should approve the contract within a reasonable amount of time after it was made. Waiting too long makes the approval invalid. Number 6, the contract you want to approve must be legal and not against the law. You can't make a void or illegal contract valid by approving it later. Number 7, you have to approve or reject the entire deal, not just parts of it. You can't pick and choose which parts you like. Number 8, communication. You need to tell the other party involved that you are approving the contract they made on your behalf. Number 9, you can only approve acts that you had the power to do in the first place. You can't make something valid if you didn't have the authority to do it. Number 4, your approval should not harm. Number 10, your approval should not harm someone else or take away their rights or interests. It shouldn't put another person in a bad situation. Let's move on to the 5th type of agency, which is by operation of law. This is when a company is being set up, the people who get everything ready become agents of the company without anyone formally appointing them. They act on behalf of the company during the formation process. Number 2, in a business partnership, each partner is automatically considered an agent of the entire partnership. This means that when a partner does something that's part of the normal business activities of the partnership, it is as if the whole partnership is doing it. So their actions legally bind the entire partnership. The agent and a servant. An agent is not a servant of the principal. Agents and servants are different in several ways. An agent's main job is to make deals and create legal relationships between their principal and others. A servant's job doesn't necessarily involve creating legal relationships for the employer. An agent has to follow the lawful instructions of the principal, but they are not closely watched and directed by the principals in their day-to-day work. A servant, on the other hand, follows direct supervision and control by the employer, and they have to follow all reasonable orders related to their job. Number 3. If an agent does something wrong within the scope of the authority, the principal is responsible for it. For a servant, the employer or the master is responsible for any wrongs committed while they are on the job. Number 4. An agent can work for multiple principals at the same time, serving different people or companies. A servant, however, typically works for just one master. Number 5. The relationship between an agent and their principal is known as principal-agent. On the other hand, the relationship between a servant and the employer is called master-servant. Move on to the duties of agents. So, the first duty is to follow instruction. The agent must do what the principal tells them to do within the authority given. If there are no specific instructions, they should follow common practices in that line of work. Number 2, they must work with care, skill, and diligence. If they are careless, unskilled, or neglect their duties, they may have to compensate the principal for any losses. Number 3, the agent must keep accurate records of the principal's money or property and show these accounts when asked by the principal. Number 4, if there are problems or difficulties, the agent should promptly communicate to the principals and ask for instructions. Number 5, they cannot do business for themselves in the same area without telling the principals and getting permission. If they do, the principal can choose to cancel this deal and or take its benefits. Number 6, any money received on behalf of the principal must be given to the principal. They can deduct what they spent on business expenses and their agreed upon fee. Number 7, if the agency ends because the principal dies or becomes incapacitated, the agent must take steps to protect the principal's interests on behalf of their representatives. Number 8, information obtained during the agency must be shared with the principal. Using such information against the principal is not allowed, and if done, the agent must compensate the principal. Number 9, agents should not make extra money beyond the agreed upon fee without the principal's consent. They must act in the principal's best interests and should not put themselves in a position where their personal interests conflict with their duty to the principal without the principal's knowledge. Number 11, the final one. Agents cannot pass their responsibilities on to someone else unless they have permission. Let's move on to rights of agents. Number 1, the agent can keep some of the money they receive on behalf of the principal to cover their own fees, expenses, and advances made for the work they are doing. Number 2, they are entitled to the payment they agreed upon with the principal. If there is no agreement, they still have the right to receive a reasonable payment for their services. Number 3, the agent can hold onto the principal's goods, papers, or other property until they get paid their commission, expenses, and fees. Number 4, the agent has the right to be protected by the principal for any legal actions they take while doing their job. However, this doesn't cover the actions the agent knew were illegal. Number 5, if the principal's actions like neglect or lack of skill cause harm or injury to the agent has the right to be compensated. For example, if the principal sets up an unsafe scaffolding and the agent gets hurt as a result, the principal has to compensate the agent. In 2 situations, the agent can stop goods. If the agent personally bought goods for the principal and used their own money, they can stop the goods until the principal pays them back. If the agent owes the principal money for the price of goods sold, they can stop the goods from being delivered to the buyer. Duties of the principal. Number 1, the principal must protect the agent from any legal consequences that arise from the agent's lawful actions while doing the job. the principal assigned. Number 2, if the agent acted in good faith, honestly, and with good intentions but faced negative outcomes, the principal should still provide support and protection. Number 3, if the agent gets hurt or faces harm because of the principal's negligence or lack of skill, the principal must take responsibility and compensate the agent for injuries. Number 4, the principal needs to pay the agent the agreed upon commission or other payment for the work they did. Rights of the principal. Number 1, if the agent makes mistakes due to not having the necessary skills, care, or diligence, the principal can claim damages for any losses. The principal can investigate and recover any profits the agent made secretly. Number 3, if the agent asks the principal to cover their costs for something they did, the principal can dispute these claims. Number 4, the principal can provide instructions to the agent and expect them to be followed. Number 5, the agent should give the principal accurate records of the work they've done and the money involved. Number 6, if the agent behaves badly, the principal can withhold their payment or remuneration. Number 7, the principal can anticipate that the agent will work with reasonable care, skill, and diligence. Number 8, in case of an emergency, the agent should consult the principal for guidance. Number 9, if the principal becomes unable to handle their affairs, the agent should return their property or any money from the agency to their representatives. The doctrine of a named principal. The named principal rule comes into play when the agent tells others that they are working for someone else, but they don't reveal the principal's name. In this case, if the agent admits they are acting for a principal even without naming them, the contract they make still binds the principal. The agent kind of steps aside even if they don't say who the principal is. When the principal's identity eventually comes out, it's just like when the principal's name was known from the start, unless there's a special rule or tradition that makes the agent responsible instead. However, if the agent refuses to say who the principal is, they become personally responsible for the contract. The doctrine of undisclosed principal. When an agent keeps both the principal's identity and the agent's status a secret, it leads to the concept of undisclosed principal. In this situation, the agent makes it seem like they are making the contract on their own, not as someone's agent. In such a contract, since the agent appears to be contracting on their own, they are personally responsible to the third party. The third party can sue the agent for any issues with the contract, and the agent can also sue the third party. If the third party finds out about the principal before getting a judgment against the agent, they can choose to sue either the principal or the agent or both. The principal can step in and sue the third party for not following through on the contract, but they can't use this right to harm the third party. Number 4, if the principal reveals themselves before the contract is fully carried out, the third party can refuse to continue the contract if they can prove that knowing the principal's identity or that the agent wasn't the principal would have made them decide to not enter into the contract. Extent of agent's authority. The authority of an agent is like their permission or ability to make decisions for the person they represent, the principal. They can only make decisions that fall within this permission. The authority can be of two types: actual or real authority. This is authority the agent gets from the principal, either through clear words or by implication. For example, if a principal tells an agent, "You can sign contracts on my behalf," that's express actual authority. If it's not explicitly stated but understood from circumstances, then it is implied actual authority. Ostensible or apparent authority. When someone hires an agent for a specific job, people who deal with that agent can assume that they have the authority to do everything necessary for that job. This assumed authority is called ostensible authority. The important thing to note is that The scope of an agent's authority is determined by the ostensible authority. If an agent does something beyond the actual authority but still within the assumed authority, the principal is responsible for it. This concept is based on the idea that if someone hires an agent for a particular role, they can't secretly take away that authority later. However, if the third party knows about limitations on the agent's authority, the principal won't be held responsible for actions that go beyond those limits. Personal liability of agents. The general rule is that only the person the agent represents, the principal, can enforce or be held responsible for a contract made by the agent. However, there are cases where the agent can be personally liable. Number 1, when the contract explicitly says so. If someone making a contract with the agent clearly says in the contract that they will hold the agent personally responsible for any breaches, and the agent agrees to this, then the agent becomes personally liable. Number 2, when the agent acts for a foreign principal. If the agent makes a contract for buying or selling goods on behalf of a person who lives in another country, the agent is personally liable. But this personal liability can be avoided if the contract specifically states otherwise. Number 3, when the agent acts for an undisclosed principal. If an agent works for someone secretly without revealing the principal's identity, the agent is personally responsible for the contract. However, once the third party discovers the principal, both the agent and the principal can be held liable. Number 4, when the principal if the principal is legally unable to enter into the contract, e.g. they are minor or mentally incapable, the agent becomes personally liable. This is because the credit is assumed to have been given to the agent, not to the principal. Number 5, when the agent signs a contract in their own name. If an agent signs a contract without any indication that they are representing someone else, they are considered to have made the contract personally unless the contract itself suggests otherwise. Number 6, when the agent acts for a principal who doesn't exist yet. For example, when the organizers of a company makes contracts on behalf of the company before it's officially formed, they are personally responsible. In such cases, because the company does not legally exist yet. Number 7, when the agent's authority is linked to their own interest. If an agent has a personal interest in the contract, the authority is tied to that interest. They can sue and be sued, but only for matters related to their own interest in the contract. Number 8, when the agent goes beyond the authority. If the agent exceeds the powers they were given, both actual and apparent, they become personally liable for the part that goes beyond their authority. Number 9, when there is a trade custom. If there is a customary practice in a particular industry or trade that makes agents personally liable, then they are, unless there is a different agreement in the contract. Number 10, when there is a mistake or fraud with money. If an agent receives money from a third party due to a mistake or a fraud, they are personally responsible to the third party. Likewise, if they mistakenly or fraudulently pay money to a third party, they can sue the third party to get it back. Delegation of agent's authority. The general rule is that an agent cannot pass on the authority to someone else without the permission of the person they represent. This is because of the saying delegation non potest delegare, which means the person given the authority cannot pass it on to another. However, there are some exceptions to this rule. Number 1, sub-agent. An agent can appoint a sub-agent and let them do some work if there is a customary practice or tradition for it, or if the nature of work requires it. A sub-agent is someone who is employed by and under the control of an original agent. Unforeseen emergencies. When unexpected emergencies come up and appointing a sub-agent becomes necessary. Principal's awareness. If the principal knows about the agent's plan to appoint a sub-agent and does not object to it. Ministerial tasks. When the task is simple and does not require much skill, discretion, or trust, the agent can delegate it. Number 5, if the principal allows the appointment of a sub-agent. Co-agent or substituted agent. A co-agent is or substituted agent is a person named by the agent with the principal's authority either expressed or implied to act on behalf of the principal. They are not sub-agents but agents of the principal for the specific part of the agency's business they are responsible. They are agents of the principal even though the agent named them at the principal's request. Differences between sub-agent and substitute agent. Number 1, control. Sub-agents work under the control of the agent, while substituted agents follow the principal's instructions directly. Number 2, there is no direct contract between the sub-agent and the principal, but there is a contract between the principal and the substituted agent. Number 3, the agent is responsible to the principal for what the sub-agent does, but the agent is not responsible for the actions or mistakes of the substituted agent. Termination of agency. Agency can come to an end in 2 ways. Number 1, termination or agreement by the 2 parties. Just like any other agreement, the relationship between a principal and an agent can be ended if both parties agree to it. They can decide to stop working together. Number 2, termination by act of law. Sometimes the law itself can end the agency relationship in the following situations. Number 1, completion of the tasks. For example, if a lawyer is hired to handle a lawsuit, the agency ends when the court makes the final decision. Expiration of time. If the agent was hired for a certain period of time, the agency ends when the time is up. Death or insanity. This one is self-explanatory. Bankruptcy. If the principal goes bankrupt, the agency ends. Destruction of subject matter. If the agency is about something specific like insuring a house and that thing is destroyed, like the house burning down, then the agency ends. Company dissolution. If either the principal or the agent is a company, the agency ends when that company is dissolved or ceases to exist. Principal becoming an enemy. If both the principal and agent are from different countries and war breaks out between the countries, the agency ends. Termination of sub-agents. If the main agent's authority ends, it also ends the authority of any sub-agents they may have appointed. Remember that the agency ends when the agent, principal, or the other parties involved find out about the termination. It doesn't end immediately when the event happens. People need to be informed for it to take effect. Let's talk about irrevocable agency. When an agency cannot be terminated or put to an end, it's said to be an irrevocable agency. An agency becomes irrevocable when it can't be cancelled or ended. Here are 3 situations where this happens. When the agency is coupled with interest, this means that the agent has a personal interest or benefit beyond their regular payment. For example, if A tells B to sell B's land and use money to pay debt A owes to B, A can't change their mind and cancel B's authority. Even if A becomes mentally ill or passes away, B's authority stays because B has a personal interest in it. Number 2, when the agent has personal liability. If the agent takes on personal responsibility or liability, the agency can't be revoked. If the principal cancels the agency, the agent will still be on the hook for the risk or responsibility they have already taken. Number 3, when the agent has already started acting. Once the agent has started doing what they have told, the principal can't suddenly cancel the authority for those specific tasks. For instance, if A tells B to buy 1,000 bales of cotton using A's money, and B buys the cotton on his own name, making himself responsible for the payment, A can't change their mind and cancels B's authority for paying for the cotton. Chapter 3, sale of goods. Nature of contract of sale. The sale of goods is a crucial part for business contracts, as people buy and sell goods in every society. In Kenya, there are laws about selling goods, and they are found in the Sale of Goods Act. When you make a contract to sell goods, it follows general contract principles like making an offer, accepting it, or having the ability to make a contract, having legal reason for the contract, agreeing on a fair price. Sale of goods is when a seller agrees to give the buyer ownership of goods in exchange for money, which is called the price. Goods refer to things you can move like products, stocks, crops. However, things like debt, claims, or money itself are not considered goods. Property in goods means ownership. You don't need any specific legal process to make a contract for selling goods. You can do it orally by talking, in writing, or even just through your actions and the relationship you have with the other party. But if the value of the goods is 200 shillings or more, you should have a written record of the contract or some evidence in writing. Essential elements of a contract of sale. Number 1. Regulation by contract. Selling goods involves making an agreement. So it follows the basic rules of contract law, like agreeing on terms, having the ability to make an agreement, being fair and legal. Number 2. Two parties. When you sell goods, there are two different sides involved. One is the seller and the other is the buyer. These can be individuals or businesses, but they must be separate from each other. Number 3. Movable property. The things being sold must be the items that can be moved around like products or objects. Land or buildings which can be moved easily can be sold as goods. Number 4. Money payment. In a sale of goods, payment is made with money. This means using cash or coins. If exchanging goods for other goods is not a sale of goods, it's called barter trade. Number 5. Ownership transfer. The contract should transfer the ownership of the goods from the seller to the buyer. Ownership means having the right to own or use the goods. Sale and agreement to sell. When you talk about selling goods, it covers both selling, where the ownership passes immediately to the buyer, and cases where ownership transfers at a later date, as agreed upon in the contract, is called an agreement to sell. Let's move on to the classification of types of goods. There are existing goods. These are goods that the seller already has at the time of the sale. There are two types: ascertained or specific goods. These are goods that can be easily identified, like a painting or a ring. Unascertained, specific, or generic goods. These are goods described but not individually identified. Number 2. Future goods. These are goods that the seller will acquire, make, or produce in the future after the sale has been made. For example, if someone agrees to sell all the corn they will grow in the garden next year, these are future goods. Contingent goods. These are goods that depend on something uncertain or conditional. For instance, if someone agrees to sell 200 bags of corn, only if their crops grow successfully, these are contingent goods. Contingent goods fall under the category of future goods. Sale and agreement to sell. Sale is a contract whereby the property and goods ownership is transferred from the seller to the buyer. Immediately, the contract is concluded. In this case, the ownership of goods passes to the buyer immediately, even if the price is to be paid at a later date or delivery is to be given in future. Agreement to sell is a contract whereby the transfer of property and goods is to take place at the future date or subject to some condition to be fulfilled. The following are difference between agreement to sell and sale. In a sale, the ownership of goods immediately moves from seller to the buyer when the contract is made. A sale typically involves existing or specific goods. The buyer bears the loss if the goods are lost without any fault. If the buyer breaches the contract, the seller can sue for both the price and the damages. If the buyer goes bankrupt before paying, the seller must deliver goods to the official receiver. If the seller goes bankrupt, the buyer can recover the goods if they have paid for them. The seller can't resell the goods, and if they do, the subsequent buyer doesn't get any rights to them. Sale creates rights against everyone. Let's move on to the agreement to sell. In an agreement to sell, ownership of the goods will transfer at the future date or upon certain conditions being met. It involves future or contingent goods. If the goods are lost without any fault, the seller bears the loss. If there's a breach, the seller can sue for damages, not the price. If the guy goes bankrupt before paying, the seller doesn't have to deliver the goods. If the seller goes bankrupt, the buyer can only claim a share of what's left. The seller can resell the goods and pass title to another buyer. Agreement to sell creates rights against the seller personally. Implied terms in contract of sale, conditions and warranties in sales contract. These are like unwritten rules in every goods selling deal. Conditions are super important terms. If they are broken, the deal is cancelled. Warranties are not as critical. If they are violated, you can't cancel the deal but can ask for compensation. Conditions and warranties can be agreed upon when the deal is made or added automatically by law or tradition. Buyers can choose to ignore a condition or treat it as a warranty. Some conditions and warranties are set by law to protect consumers. Implied conditions in a sale of goods. Condition as to title. The seller must have the right to sell the goods. This protects the buyers from purchasing stolen goods. Sell by description. If goods are sold based on description, they must match that description. Number 3. Condition as to quality. Goods must be reasonably fit for the purpose the buyer wants them for. This applies when the buyer relies on the seller's expertise and makes known their specific purpose for their goods. Number 4. Condition has to be merchantable. If goods are sold by description from a seller who deals in such goods, they must be of merchantable quality, suitable for the intended purpose. However, if the buyer examines the goods and should have noticed defects, this condition does not apply. Number 5. Sale by sample. When goods are sold by sample, the bulk of the goods must match the sample in quality, and the buyer should have the chance to compare them. The goods should also be free from these defects. Condition as to wholesomeness. Edible foods is an implied condition that they must be safe for human consumption. Implied warranties in the sale of goods. Warranty of quiet possession. The buyer is assured that they will have peaceful and undisturbed possession of the goods they purchase. If someone challenges their right to buy the goods, the buyer can sue the seller for damages but cannot cancel the contract. Warranty of freedom from encumbrances ensures that the goods are free from any claims or rights held by third parties. It protects the buyer from undisclosed defects in the seller's title at the time of the contract. Warranty as to quality or fitness is an implied warranty that the goods must be of good quality and suitable for the intended purpose, especially when there is a customary expectation in the trade for such quality. Disclosure of dangerous nature of goods assures the seller that the goods being sold are not dangerous. They must provide warnings about potential hazards in the case goods are dangerous. Failure to do so can lead to the seller being held liable for damages. Let's move on to transfer of property in goods. Definition. Property means ownership of goods. Knowing when ownership passes from the seller to the buyer is important because it determines when the risk shifts, when the seller can sue for damages or price, and in cases of bankruptcy or insolvency. Rules of transfer of ownership. For ascertained goods, ownership is transferred when both parties intended to pass, as stated in the contract, or inferred from their conduct or trade or custom. As for generic or as unascertained goods, ownership isn't transferred until goods are identified or specified. As for specific goods in deliverable state, if there is an unconditional contract for specific goods in a deliverable state, ownership passes to the buyer immediately upon contract formation, regardless of delivery or payment. As for specific goods not in deliverable state, if the seller needs to do something to make goods deliverable, ownership passes when that action is completed and the buyer is informed. As for specific goods that need to be measured or tested, that are in a deliverable state but need measurement, ownership passes when the required action is done and the buyer is notified. As for goods sent on approval, ownership transfers when the buyer approves. When an agreed time elapses without approval or when the buyer takes actions against the seller's interests. As for unconditional appropriation, ownership passes when one party unconditionally identifies the specific goods with the other party's consent, either before or after the appropriation. These rules determine when the ownership of goods moves from the seller to the buyer in a sale of contract. Let's move on to performance of a sale of contract. For the seller, the seller's performance in a sale of contract involves delivering the goods to the buyer. For the buyer, the buyer's performance means accepting the delivered goods and paying for them as per the contractual terms. For the contract terms, the parties can set their own terms in the contract, including details about when, where, and how the goods will be delivered, accepted, and paid for. Default rules: if the contract doesn't specify these terms, the Sale of Goods Act provides default rules. Delivery of goods. This means willingly transferring possession of goods from one person to another. It must result in the goods being in the buyer's or agent's possession. Number 6. Types of delivery. Actual delivery, which is handing over the physical goods. Symbolic delivery for bulky goods like giving a key to a warehouse. Constructive delivery, when goods are with a third party, the third party acknowledges holding them for the buyer. In simple terms, for sellers, it's about giving the goods, and for buyers, it's about accepting them and paying. All following contractual terms. If the contract doesn't say how, the Sale of Goods Acts provide this rule. Rules of delivery of goods. Number 1. Type of delivery. Goods can be delivered in different ways: actual, symbolic, constructive, or by a third party. The aim is to put the goods in the buyer's control. Usually, delivery and payment happen at the same time unless the contract says otherwise. If the contract specifies a place, goods must be delivered there during business hours on a working day. Otherwise, it's where goods are when the sale happens. Time of delivery. No delivery time is set. The seller must send the goods within a reasonable time, depending on the situation. Delivery costs. Unless stated otherwise, the seller covers all expenses related to the delivery, including making goods ready for delivery, but the buyer pays for getting the goods delivered to them. Delivering part of the goods is like delivering the whole unless there's a different agreement. The seller usually isn't obliged to deliver until the buyer asks. If the buyer delays, they might have to pay for storage. If someone else has the goods, it's not considered delivery until they acknowledge they hold them for the buyer. If the seller can't deliver by installments unless the contract allows it, if they do, the buyer doesn't have to accept them unless the contract says so. Goods must match the contract exactly. If too much or too little is delivered, the buyer can accept all, reject all, or accept some and reject the rest. The buyer accepts goods when they say they have accepted them. They treat the goods as their own against the seller's rights. They keep the goods for a long time without rejecting them. Buyer rejects goods. If they reject goods, they must tell the seller they don't have to return them. If the buyer delays, they may be liable for damages and storage costs. Rejecting goods doesn't cancel the contract. The seller can offer the correct goods again, and the buyer must accept. If the buyer accepts less than the contracted quantity, they can claim damages for it. Let's move on to memo dat quadnan habit rule. Imagine this: you buy something from someone who doesn't really own it. Well, you won't magically become the real owner either. There's a saying in law, memo dat quadnan habit, which means no one can transfer a better title than they have. It's like saying you can't give what you don't have. In simple terms, when you buy something, the purpose is to transfer ownership from the seller to you. But the seller didn't really own it. Your ownership will also be in trouble because the ownership was a problem. The law follows this rule. It says that if someone sells goods they don't own and they didn't have permission from the real owner, you as the buyer won't get better ownership rights than that seller had. Unless, of course, the real owner somehow acted like they gave permission for the sale. This rule here is to protect real owners from people selling their stuff without their permission. But there's a twist. Sometimes the law has to decide whether to protect the real owner or the person who bought the item honestly, not knowing about the problem with the seller's ownership. In those cases, two principles come into play. Protect the real owner. The law wants to make sure that the real owner's rights are safe. For instance, if someone steals something and sells it to you, even if you didn't know it was stolen, you won't get the real ownership because the seller had a problem with the ownership. To protect honest buyers. On the other hand, if you buy something in good faith for a fair price, without knowing about any ownership issues, the law might give you better ownership rights even if the seller had issues. So in short, the law tries to balance the rights of real owners and people who buy stuff honestly to keep those sides happy. Exceptions to the nemo dat quad non-habit rule. Imagine you're buying something from someone. You want to make sure you are really getting what you're paying for. Well, there are certain situations in the law where you can be sure you're getting a good title to what you buy. So the first one is a sale by a versatile agent. If you buy something from a person who as part of their regular job can sell or consign goods or raise money using goods as security and they have the authority to do so, you'll get a good title. For example, if a car salesman sells you a car, you will own it for real. Sales by one of several owners. If there are a bunch of people who own something together and one of them sells it with the other's permission, you can get a good title as long as you buy it honestly for a fair price and didn't know about any problems with the seller's ownership. If a seller hasn't been paid for the goods they are selling and they still have them, you can get a good title to those goods when you buy them. Number 4, sell in a market overt. This one doesn't apply in Kenya, but it's worth knowing. In some places, if you buy something in a public market on certain days and times, and you didn't know about any issues with the item's ownership, you can get a good title. Sell under avoidable contract. If someone sells you something that they got through a contract that could be cancelled but hasn't been cancelled yet, you can get a good title as long as you buy it honestly for a fair price and didn't know about any problems with the seller's ownership. Sell by a court order. If a court or law allows someone to sell goods and you buy those goods legally, you get a good title. Title by estoppel. If the owner of the goods makes you believe that the person selling them has the right to do so through their words or actions and you buy in good faith, you'll get a good title. The owner can't suddenly say you don't own it. Sell by seller in possession after sale. If a seller who had already sold something still has the goods and sells them again to you, without you knowing about the first sale, you get a good title, but the seller must act as a seller, not just as a hirer or keeper. Seller by buyer in possession. If a buyer has already bought something and has it in their possession with the seller's consent and you buy it in good faith without knowing about any other claims, you get a good title. Sell under a statutory power of sale. Sometimes the law gives special power to sell goods under certain circumstances. For example, the Disposal of Uncollected Goods Act allows for the sale of goods left uncollected. If you buy such goods legally, you get a good title. So these rules help make sure that when you buy something, you really own it and don't have to worry about someone else's ownership claim. Let's move on to rights and duties of buying and sale of goods. Rights of buyer. These are the rights you have as a buyer when you purchase your goods. So the first one is you got what you agreed to. You have the right to get the goods you bought and they should match what you agreed upon in the contract. You have the right to reject bad goods. If the goods are not in the right quantity or quality, you can say no and not accept them. You have the right to check the goods. You can look at the goods to make sure that they are what you expected and meet the contractual terms. Unless you agree to it, the seller can suddenly deliver you goods in pieces without your say so. If the seller doesn't deliver the goods as promised, you can ask for compensation. If the goods are specific or well defined in the contract and the seller doesn't deliver, you can take them to court or make them follow through the deal. Ask for a refund. If you paid for the goods but they aren't delivered, you can ask for your money back. If you don't get your money back, you can also ask for extra money, which is called interest on top of the refund. These rights help make sure that when you buy something, you are protected and get what you want. Let's move on to the duties of the buyer. So when you buy something, these are your duties. You have to pay. Your main job is to accept the goods when they're delivered and pay for them. Ask for delivery. Unless you've agreed differently, you should request delivery of the goods when you are ready. Choose a good time. You can ask for the goods to be delivered at a reasonable time that suits both you and the seller. Be timely. Once the seller offers delivery, you should accept the goods within a reasonable time frame. Say no properly. If you decide not to accept the goods, you need to tell the seller. Pay as agreed. You should pay the price as laid out in the contract. Pay for refusing. If you wrongly refuse to accept and pay for the goods, you may need to pay for damages. Risk of damage. If you choose to accept delivery at your own risk, you will be responsible if the goods get damaged. So, this responsibilities help ensure that both you and the seller can complete the transaction fairly and smoothly. So, when a seller rights of an unpaid seller in a sale of goods. So, when a seller is unpaid, these are your rights. Imagine you are selling something like a phone and you are considered unpaid when you are not fully paid. The buyer hasn't paid you the full price for the phone. If you got a check like a payment slip which later turned out to be no good, you are still unpaid. So if this happens, this is what you can do as the seller in this situation. So you can take action against the goods that you sold by taking them back. So you can also go after the buyer personally to get the money back that they owe you. So these rights help the seller make sure they are treated fairly when they haven't been paid for what they sold. So rights against the goods. So these are the seller's rights when the buyer does not pay. So the first one is right of lien. This means the seller can keep the goods and refuse to give them to the buyer until they get paid. But once the buyer pays, the seller has to hand over the goods. Number 2, right to stoppage in transit. If the buyer goes broke, insolvent, and the goods are on their way but not delivered yet, the seller can stop the delivery until they get paid. Right of withholding delivery. If the buyer hasn't fully paid, the seller can hold on to the goods until they are paid, even if the goods are still with the seller. Right of resale. If the goods are perishable, if the contract says the seller can resell in the case of default, or if the seller gives notice and the buyer still doesn't pay, the seller can resell the goods. If they make a loss, they can ask the buyer to cover it. But if there's extra money from the resale, the seller can keep it. These rights help sellers when buyers don't follow through with payment for the things they agreed to buy. Let's move on to rights against the buyer. These are the seller's options when the buyer doesn't pay or accept the goods. You can sue for price. If the buyer already owns the goods and refuses to pay, the seller can sue the buyer for the price. Even if the goods haven't been delivered, you can sue for damages. If the buyer refuses to accept or pay for the goods, the seller can sue for damages caused by the buyer's refusal. This is a way to get compensated for the trouble. You can sue for breach of contract. If the buyer breaks the contract before the delivery date, the seller has 2 choices. They can wait until the delivery date and see if the buyer changes their mind, or they can treat the contract as cancelled and sue for damages for the buyer's breach. Number 4, you can sue for interest in price. If the contract says the buyer has to pay interest on the price from a specific date, the seller can claim that interest. If there is no such agreement, the seller can charge interest starting from a date they notify the buyer. So, as you can see, these options help sellers get compensated when buyers don't follow through on their part of the deal. Remedies for breach of contract. So, for the seller, you can sue for price. The seller can take legal action to get the agreed upon price from the buyer. Number 2, sue for damages for non-delivery. If the buyer doesn't take the goods, the seller can sue for damages caused by the non-delivery. Sue for damages for early contract termination. If the buyer cancels the contract before the agreed upon date, the seller can sue for damages resulting from this breach. Sue for interest. If the contract specifies interest on the price from a certain date, the seller can claim that interest. Let's move on to buyer's remedies. The buyer can sue for damages for non-delivery if the seller doesn't deliver the goods. The buyer can demand that the seller follows through with the contract and delivers the goods as agreed. If the seller breaches any warranties related to the goods, the buyer can take legal action. If the seller cancels the contract before the agreed upon date, the buyer can sue for damages resulting from this breach. Sue for recovery of price. If the buyer has paid but didn't receive the goods, they can sue to get their money back. Sue for interest. Just like the seller, if the contract specifies interest on the price from a certain date, the buyer can claim that interest. Rejection of goods. If the goods don't meet the contractual terms and are rejected by the buyer, they can return them. Let's move on to the doctrine of caveat emptor, which means buyer beware. Caveat emptor is a concept that says when you're buying something, it's your responsibility to be careful and check what you're getting. The seller doesn't have to tell you about every little problem with the item they're selling. You need to look closely and make sure it's what you want. If you end up with something you don't like or that doesn't work for your needs, you can't blame the seller or ask for compensation. That's because the seller isn't automatically promising that the item will be perfect for your specific use. So when you buy something, be smart and choose wisely. If you make a bad choice, it's on you, unless the seller lied or did something wrong. Exceptions to caveat emptor, buyer beware. So the first one, misrepresentation. If the seller lies or gives false information about the product and the buyer relies on these lies to make the purchase, caveat emptor doesn't apply. The buyer can cancel the deal. Number 2, fraud. If the seller tricks the buyer, for instance, by hiding a defect that the buyer couldn't reasonably find, caveat emptor doesn't protect the seller. Fraudulent actions make the contract invalid. Goods sold by description. When you buy something based on a description and it doesn't match that description, caveat emptor doesn't hold. If the goods are unfit for the intended use and you relied on the description, the seller is responsible. But if you checked the goods yourself, you are responsible for any defects you could have spotted. Goods sold by sample. If you buy goods based on a sample and the rest of the batch doesn't match that sample, or if there are hidden problems, caveat emptor doesn't apply. Relying on seller's expertise. If you tell the seller that you need what you need the goods for and you trust their expertise, but the goods turn out to be unsuitable for that purpose, caveat emptor doesn't protect the seller. They are responsible for providing goods fit for your specified purpose. Trade or usage conditions. When there are industry standards or common expectations about the quality or fitness of goods and the seller doesn't meet those standards, caveat emptor doesn't apply. Sale and a patent or trade name. If a product is sold under a patent or trademark or specific trade name, it must meet the specifications associated with that patent or name. If it doesn't, caveat emptor doesn't protect the seller. Sale by public auction. Certainly an auction is like a public competition to buy something. Many people come to bid and try to offer the highest price for the item they want. The person in charge of the auction is called the auctioneer. He works for the owner of the item. The auctioneer's relationship with the owner is like an agent who acts on their behalf. So this is how an auction works. So the first, they advertise the auction telling the people what's going to be sold. They set the time and the day for people who want to buy those things to gather there. The auctioneer shows the items one by one and asks for offers. People raise their hands or call out their offers. Each offer is like saying, I'll pay this much for it. The auctioneer keeps track of other offers. Highest bid wins. The item goes to the person who offers the most money for it. The auctioneer usually signals this with a special action, like hitting a hammer or blowing a whistle. A contract. This is the final stage, and in this point a deal is made. The person with the highest bid is now the buyer, and they are obligated to pay that amount. So there are rules of auction sales. So for goods sold in slots, if items are grouped into lots of sale, each group is treated as a separate sale. Sale completion. The sale is finished when the person in charge, the auctioneer, says so, usually by hitting a hammer or using another signal. Seller's right to bid. The person selling the items can also bid, but only if they say so in advance. Reserve price. Sometimes they say an item won't be sold for less than a certain price. If that price isn't reached, the item won't be sold. Fake bidding. Fake bidding. If the seller tricks people by pretending to bid and push up the price, the buyer can choose to cancel the deal. Knockouts. Sometimes a group of people agrees that only one of them will bid on an item and they'll sort things out privately. This is called a knockout. It is okay as long as they are not trying to cheat someone else. Let's move on to dumping. So dumping is when someone tries to stop a buyer from bidding at an auction in a dishonest way. This is against the rules, and the auctioneer can take the item off the auction if they catch someone dumping. Dumping can happen in a few sneaky ways, which include pointing out problems. Someone might try to discourage a buyer by pointing out flaws in the item. Messing with the price. They might do something to make it hard to figure out the real price of the item. Scaring people away. Sometimes they use tricks to make potential buyers leave the auction. Implied warranties in an auction sale. So, when an auction sells items, they promise to do these things. They promise they have the right to sell the items they put up for auction. This means they won't sell things that don't belong to them. Number 2, they promise they don't know about any problems with who owns the items. In other words, they won't sell something if they know someone else might claim it later. Number 3, they promise to give the items to the buyer after the buyer pays. Basically, they'll hand over the stuff once you've paid for it. Number 4, they guarantee that the buyer can use the items without any trouble. They promise that no one will bother you about the items you bought from them. Okay, hire purchase law. Introduction. A purchase agreement means buying without paying everything up front. So let's say you want to buy something like a phone, but you don't have all the money right away. So you talk to the person who owns that thing and you make a deal. So here's how it works. You agree to rent or hire the item from the owner with the plan to eventually buy it. There are rules for this deal, and these rules are controlled by a law called the Hire Purchase Act. The law only applies to deals where the item's value is not too high, like if it's worth less than a certain amount of money. This law doesn't cover companies or special government programs for buying things like cars. The law says a hire purchase agreement is when you get something like a phone but can choose to buy it later. Sometimes in this deal there's also a contract of guarantee. That's like a promise from another person to pay for the item if you can't. It's like having a backup plan. This deal is good because you don't have to pay all the money at once. You can take your time paying in smaller amounts. The owner still owns the item until you make all the payments. So a hire purchase agreement lets you get things without emptying your wallet right away. You rent it out for a while and then decide if you want to keep it or return it. The nature of a hire purchase agreement, a subtopic. Imagine you want a fancy gadget like a laptop, but you can't pay for it all at once, so you make a special deal with the store. So here is how it works. You agree to rent or hire the laptop from the store. You can decide to buy it later, but you don't have to. You'll pay for the laptop in smaller amounts like monthly payments. When you sign the agreement, you get to use the laptop, but you don't own it yet. The store still owns the laptop until you finish paying all the money. If you miss a payment, the store can take back the laptop. You can also choose to return the laptop and end the deal if you follow some rules. You only fully own the laptop when you make the last payments. So a hire purchase agreement lets you use something and decide later if you want to keep it. You pay in small parts until you own it completely. Let's move on to requirements for a hire purchase agreement. So hire purchase agreement rules that protect the hirer. Imagine you're renting something with an option to buy it later like a car. There are rules in place to make sure you understand the deal and are protected. These rules come from the Hire Purchase Act. So here's what you need to know. The first thing is know the prices. Before you sign anything, the seller must tell you in writing. You must know the full cash price of the item. You must know the hire purchase price, what you'll pay in total, including any initial payments. There has to be a written agreement. The whole deal must be written down in English and you need to personally sign it. You can't have someone else sign for you. Spoken agreements won't count. You also need to make sure it's properly stamped if it requires a stamp for legal purposes. You have to know what's in the agreement, and the written agreement must include all this info: cash price of the item, hire purchase price, how much each payment will be, due dates for each payment, your rights under the agreement, a good description of the item, limits on the seller's right to take back the item. So the other thing is you should get copies. You should get at least one copy of the agreement you signed. If you can end the agreement early, you should get 2 copies. They need to be sent to you within 21 days of making the deal, either by mail or by person. So the other thing is register the agreement. There's a public office with the registrar that handles hire purchase agreements. You and the seller must deliver the agreement for registration within 30 days of signing it. The registrar will issue a certificate to the seller. If it's not in English, not properly stamped, or you are late in registering, the registrar might not accept it. They can extend the registration period if there's a good reason for the delay. Consequences of not registering: if the seller does not register the agreement, these things can happen. They can't force you to follow the agreement. They can't use legal action to take back the item. Any security or guarantee provided isn't enforceable against you or the guarantor. So these rules make sure you are informed and your rights are protected when you are renting with an option to buy something. So void provisions in hire purchase agreement. So the Hire Purchase Act has certain rules to protect people who rent to buy. These include: number 1, the owner or their agent can't just come into a place and take back stuff you are renting. Number 2, the owner or the agent can't avoid being responsible when they come to your place to take back their stuff. Number 3, you can't be prevented from ending the rental agreement if you want to. Number 4, you can't be made to pay more than half of the total price if you decide to end the rental agreement. Number 5, the owner can't avoid being responsible for the actions of anyone working for them when making the agreement. These rules are there to make sure rental agreements are fair and protect your rights. Hire purchase and credit sale agreement. So a credit sale agreement is when you buy something and can pay for it in a few installments, usually 4 or 5. You own the item right away after the first payment. Hire purchase agreement, on the other hand, is more like renting something with an option to buy it or return it. It's regulated by different laws, and the people involved are called owners and hirers instead of sellers and buyers. Ownership of the item in a hire purchase agreement doesn't happen until you make the final payment. So here are some key differences. So number 1, the nature of agreement. In a credit of sale agreement is about selling goods on a payment plan. In a hire purchase agreement, it's about renting with an option to buy. Number 2, laws. The credit sale agreements follow the Sale of Goods Act, while the hire purchase agreements follow the Hire Purchase Act. Number 3, parties. In a hire purchase agreement, you have owners and hirers. In a credit sale agreement, you have sellers and buyers. Number 4, ownership. Ownership transfers right away in a credit sale agreement after the first payment. In a hire purchase agreement, it only transfers after the final payment. Number 5, risk of loss. If something happens to the item without anyone's fault in a hire purchase agreement, the owner is responsible. In a credit sale agreement, it's the buyer's responsibility. Repossession. Number 6, owners can take back the item in a hire purchase agreement if the hirer misses payments. In a credit sale agreement, the seller can't take back the item but can sue for unpaid amounts. Number 7, returning the item. In hire purchase agreement, the hirer can return the item at any time if they meet certain conditions. In a credit sale agreement, the buyer can't return the item unless there's a problem with it. Reselling. Hirers can't sell items in a hire purchase agreement. Buyers can sell items in a credit sale agreement. Number 9, number of payments. You can have as many payments as you want in a hire purchase agreement, but credit sale agreements are limited to 4 or 5 payments. Registration. Number 10. Hire purchase agreements need to be in writing and registered. Credit sale agreements can be in writing or even spoken, and they don't need registration. Hire purchase and conditional sale agreements. A conditional sale agreement is like a promise to buy something, but you pay for it in installments. You only fully own it when you meet certain conditions set by the seller or by the law. These conditions might be about making payments or other things mentioned in the agreement. Here's the difference between a conditional sale agreement and a hire purchase agreement. In a conditional sale agreement, you must buy the item. In a hire purchase agreement, you have the choice to buy it if you want. Both of these agreements are similar because you don't fully own the item until you meet certain conditions or pay all the installments. But they have different rules. Conditional sale agreements follow the Sale of Goods Act, while hire purchase agreements follow the Hire Purchase Act. Remember, most of the difference between hire purchase and credit sale agreements also apply to conditional sale agreements, except for things like when you own the item, who's responsible if it's damaged, and whether you can resell it. Implied terms in a hire purchase agreement. In a hire purchase agreement, there are 2 important things: conditions and warranties. Condition is like a super important rule that must be followed. If it's not followed, the whole agreement can be cancelled. A warranty is also a rule, but is not as important as a condition. If a warranty is broken, you can't cancel the agreement, but you can ask for compensation. So in every agreement, there are these rules, conditions, really important rules. If not followed, the whole agreement can be cancelled. Warranties, less important rules. If broken, you can't cancel the agreement, but you can ask for compensation. Implied condition in hire purchase agreements. In every hire purchase agreement, there are some important rules. Number 1 is the right to sell. The owner must have the right to sell the goods when the hirer pays the last installment. Number 2, good quality. The goods must be of good quality, except if they are second-hand and it's stated in the agreement. Number 3, fit for purpose. If the hirer tells the owner that what they need the goods for, the goods must be suitable for that purpose. Number 4, ownership. The hirer will own the goods once they pay the last installment. Implied warranties in hire purchase agreements. So number 1, peaceful use, which is quiet possession. The hirer is guaranteed peaceful and undisturbed use of the goods while they have them. Number 2, no hidden charges or free of charge. The goods must not have any hidden debts or claims against them, and the hirer is supposed to become the owner. Duties of owners and hirers of goods. The duties of the parties to a hire purchase agreement may be summarized as follows. Duties of owners of goods in hire purchase agreements. In hire purchase agreement, the owner who lets you hire the goods must: number 1, tell you the prices in writing before or when you make the agreement, reveal any hidden problem with the goods, give you the goods as agreed, register the agreement within 30 days, provide you the copies of agreement within 20 days, accept your payments on time, cover any losses or problems caused by defects in the goods or issues with the ownership of goods. Duties of hirers in hire purchase agreement. So number 1, sign the agreement yourself, not through someone else. Check that the goods you are hiring are suitable for your needs. Receive the goods at an agreed location. Take good care of the goods while they are with you. Make payments as agreed and on time. Stick to the agreed rental period unless you decide to end or complete the agreement early. Let the owner know in writing if you want to end or complete the agreement early. Inform the owner if your address changes. Pay for any repairs or damages if you don't take good care of the goods. Termination and completion of hire purchase agreements. Termination happens when the hirer decides to end the agreement early. Completion occurs when the hirer wants to meet all the agreement terms ahead of schedule, or when the owner takes back the goods and the hirer wants them back. There are specific rules for both termination and completion in hire purchase agreements. These rules are rules of termination of hire purchase agreement. Number 1, you should write a notice to the owner saying you want to terminate the agreement. Number 2, you should pay all due installments plus enough to cover at least half of the total price unless the agreement says less. If you didn't take good care of the goods, be ready to pay for any damages. Return the goods to the owner's place where you got them or where the owner tells you to. The owner must give you back any extra money you spent on to return the goods, like transport costs. So let's move on to rules of completion of hire purchase agreement. The hirer can complete the hire purchase agreement in 2 situations. A, anytime during the agreement. Write a notice to the owner saying you want to complete the agreement. Pay the remaining amount you owe on a specific day. Number B, within 28 days after the owner takes back the goods. You need to write a notice to the owner within 28 days of them taking the goods back. Pay the remaining amount you owe on a specified day. Pay the owner for the cost of taking back the goods. Cover expenses for storage, repair, and maintenance of the goods. Pay any extra interest according to the agreement. Recovery of possession of goods. The Hire Purchase Act allows the owner to take back the goods if the hirer misses payments or breaks the agreement. But there are rules to protect the hirer. Number 1, if the hirer has paid at least 2/3 of the total price, the owner can take the goods back. Number 2, there are exceptions. A, if the hirer ended the agreement but didn't return the goods. B, if the owner gets a court order to get back the goods. If the owner takes back goods against these rules, number 1, the agreement is considered ended. The hirer doesn't owe anything more. Any guarantor is released from their responsibility. Any security given is released. The hirer can sue the owner to get back all the money paid, including the deposit. A guarantor can also sue the owner to get back all the money paid under the guarantee. The owner can only take back the goods with a court order if the hirer has paid more than 2/3 of the price. If the owner goes to court, they might get orders to protect the goods, like stopping their use or returning them to the owner. The court can also set conditions for the hirers or guarantors to pay any remaining amounts. So these are the things you should note. Number 1, if the hirer refuses to return the goods after a written request from the owner, they can be liable for damages. Number 2, the owner can temporarily move the goods to protect them if two or more payments are due without it counting as repossession. Number 3, if the owner legally takes back the goods, they must sell them for a fair price and return any extra money to the hirer. Number 4, even if the owner goes bankrupt or liquidated, the agreement still stands and the trustee or liquidator takes over the owner's role. Request for information by hirer. If the hirer wants information about the agreement, they can ask for it in writing. The law says the request should be sent by registered email and the owner has to pay for the reply. The owner must respond within 14 days with a signed statement that includes the following. A, how much is left to pay on the agreement. B, a list of all payments made and when they were made. C, details about the unpaid installments and when they are due. D, the total cost of the agreement. E, information about future installments and when they are due. If the owner doesn't provide this information when asked, A, the owner can't force the agreement against the hirer or guarantor. B, the owner can't take back goods from the hirer. C, any security given by the hirer or guarantor can't be enforced. Also, it's important to know that giving false information when entering into a hire purchase agreement is against the law and can result in fines or even imprisonment. Protection of parties under the Hire Purchase Act. The Hire Purchase Act is a law that looks out for consumers. It has rules to protect both the people who own goods owners and the people who are buying them. Owners need protection because they give their goods to the hirers and can't always control what happens to them. Hirers also need protection because they are making payments for goods that still belong to the owners. Here are some of the protections that the Hire Purchase Act provides for both hirers and owners. Number 1. Protections of hirers of goods. The Hire Purchase Act has several rules to protect people who are buying goods using a hire purchase agreement. These rules make sure both buyers, called hirers, and the sellers, called owners, are treated fairly. Here are some of these important rules that protect the buyers. So, number 1, notification of cash price. Before a hire purchase agreement is signed, the owner must tell the hirer how much the goods cost in cash and how much it will cost if they choose the hire purchase option. This helps the hirer make an informed decision. Number 2, written and signed agreement. All hire purchase agreements must be written down and signed by the hirer personally, as well as by the owner or someone in their behalf. This written agreement is proof of what was agreed upon. Number 3, copy of agreement. The owner has to send the hirer a copy of the agreement by registered mail within 21 days after it's made. This allows the hirer to review the agreement and know the rights and responsibilities. Number 4, registration of agreement. The owner must register the agreement with a special office called the Registrar of Hire Purchase Agreements within 30 days of making it. If they don't, the agreement becomes unenforceable, meaning the owner can't make the hirer pay, take back the goods, or use any security given under the agreement. This protects the hirer. Implied terms. The Act automatically includes certain conditions and warranties in the agreement. This includes the right to sell the goods, that the goods should be in good condition, and that they should be fit for the intended purpose. This ensures the goods are of acceptable quality. Number 6, 2/3 payment rule. If the hirer has paid at least 2/3 of the hire purchase price, the owner can't take the goods back without going back to court, or unless the hirer ends the agreement. If the owner takes the goods unlawfully, the agreement is considered ended and the hirer is free from any obligations. Number 7, best resale price. If the owner legally takes back the goods, they must sell them at a reasonable market price and give the hirer any extra money made from the sale. This prevents the owner from making an unfair profit. Number 8, bankruptcy of owner. If the owner goes bankrupt or is in liquidation, the hire purchase agreement remains valid and is binding on the new person in charge. This ensures the hirer's rights are protected. Number 9, termination of agreement. If the hirer can end the hire purchase agreement at any time before its due date, this allows them to get out of the contract and avoid further obligations. Number 10, request for information. The hirer can ask the owner for information about the agreement, like how much they've paid and how much is left. The owner must provide this information. This keeps the hirer informed about the agreement. These rules help make sure that both hirers and owners are treated fairly and know their rights in hire purchase agreements. So let's move on to protections to owners of goods. The Hire Purchase Act has various rules that protect owners of goods as well. These rules include, number 1, contract of guarantee. The owner can ask for guarantee in the agreement. This means someone else, called a guarantor or surety, promises to pay if the hirer doesn't fulfill the obligations. Number 2, change of address. The owner can require the hirer to provide the addresses and notify any changes. Number 3, repossession of goods. If the hirer hasn't paid at least 2/3 of the total hire purchase price, the owner can take back the goods if the hirer misses an installment without needing to go to court. Number 4, implied terms. In some cases, the implied condition of goods being fit for use doesn't apply. For instance, if the goods are second-hand and it's stated in the agreement, or if the hirer could have found defects by examining the goods, the owner can also exclude the condition of fitness for purpose through an express agreement with the hirer. This protects the owner when selling different types of goods. Number 5, rights on termination. While the Act allows the hirer to terminate the agreement before its due date, there are rules in place to protect the owner. The hirer must follow specific termination rules, like giving written notice to the owner, paying a portion of the price, returning the goods at their own costs, and covering repair damages if the goods are damaged. Number 6, licensing and registration. The Act requires all business involved in a hire purchase to get a license from a designated office. This safeguards owners from unauthorized competition. Additionally, all hire purchase agreements must be registered with the registrar, making it easier for owners to prove the validity of the agreements in case of disputes. Number 7, false information. Anyone providing false information in documents related to a hire purchase agreement can be fined or imprisoned. This provision helps ensure that information exchange in these agreements are truthful, benefiting both owners and hirers. Number 8, removal of goods out of Kenya. The owner can specify in the agreement that the hirer cannot take the goods out of Kenya without the owner's written consent. This ensures that the goods remains within the reach of Kenyan courts and protects the owner's rights. Number 9, adverse possession by hirer. If the hirer refuses to return the goods after a written request from the owner, they can be held responsible for keeping the goods against the owner's rights and may be liable for damages. This provision safeguards the owner's property rights. This rule helps make sure that the owners of goods in hire purchase agreements are also treated fairly and have legal protections in place. Okay, let's move on to chapter 5, which is negotiable instruments. So we're going to be explaining the nature and the meaning of negotiable instruments, describing the characteristics of negotiable instruments, outline the types of negotiable instruments. So let's start with the nature and meaning of negotiable instruments. So a negotiable instrument is like a special kind of document used in business and money dealings. If it meets certain conditions, it can be easily transferred from one person to another in exchange for something valuable, usually money. Think of it as a way to pass on a debt or a promise to pay. In Kenya, the laws about negotiable instruments are found in the Bill of Exchange Act and the Check Act. These laws are based on English law and court decisions. According to Justice Willis, a negotiable instrument is something that anyone who gets in good faith and in exchange for something valuable can own, even if the person who gave it to them had some problems with their ownership. A negotiable instrument is something that, number 1, can be passed to someone else by giving it to them or signing it over to them. Number 2, can be used in court by the person who has it without notifying the person who has the money. Number 3, the new owner gets full ownership of, even if the previous owner had some problems with it. So these are the important things to know about negotiable instruments. Number 1, negotiable instruments are easy to transfer. You can easily give it to someone else without a lot of paperwork. Just handing it over or signing it is usually enough. Number 2, clean ownership. If you get in good faith and for something valuable, you become the rightful owner, even if the person who gave it to you didn't have a perfect claim to it. Number 3, legal action. You can take legal action to collect the money it promises to pay, and you don't have to tell the person who has the money in advance. Presumptions. The law assumes certain things about negotiable instruments unless it is proved to the contrary, which is A, they were created for good reason. B, they were made on the date written on them. C, they were accepted or agreed to in a reasonable time. D, they were transferred before they were due. E, the endorsement signatures on the back were done in order. F, they had the right amount of tax stamps. G, the current holder is a holder in due course. H, if one is dishonored, it's presumed to be true until proven otherwise. In simple terms, negotiable instruments are like special documents that can be easily passed from one person to another, and the law assumes that they are made and used fairly unless there is proof otherwise. They are mainly used in financial transactions to promise payments and debts. So types of negotiable instruments. So number 1, negotiable by law or statute. These are negotiable instruments that the law recognizes, like the Bill of Exchange Act and Checks Act. The law identifies 3 types of these instruments: bills of exchange, promissory notes, and checks. Number 2, negotiable by custom. Some other documents become negotiable because of business customs or common practices. This can include things like treasury bills, share warrants, dividend warrants, bearer debentures, banknotes, and circular notes. But remember, not everything falls into this category. Money orders, postal orders, share certificates, letters of credit, and similar items are not negotiable instruments. Let's talk about bills of exchange. So a bill of exchange is a written document that's like a money order. It has three main people involved. Number one, the drawer. This is the person who creates the bill and orders someone else to pay money. The drawee, this is the person who is supposed to pay money on the bill. The payee, this is the person who should get money from the bill. Things to note is that if the drawer or the payee has the bill, they are called the holder. The holder has to show the bill to the drawee to get the agreement to pay. When the holder puts their signature on the bill, it's called endorsing it. The person they give the bill to is called the endorsee. So as you can see below, we have a specimen of a bill of exchange here. You can observe it. Let's move on to essential or rules or characteristics of a bill of exchange. So a bill of exchange must follow the following rules. Number one, it has to be in writing, it has to be written down. Number two, it should have an order to pay, not just a polite request. Number three, it should be unconditional, and the order to pay must be clear and not have any conditions. Number four, it should involve three people. The one creating it, which is the drawer, the one who should pay, which is the drawee, and the one who gets paid, payee. Number five, it should have certain parties. The people involved should be clear and definite. Number six, money only. It's for ordering payment of money and nothing else. Number seven, the amount of money should be specific. That is, it should be clear. Number eight, formalities. It usually includes details like the number, date, place, and reason, but these aren't always required by the law. However, it does need the right stamp. So advantages of a bill of exchange. So number one, a bill of exchange provides extra security. If the person who should pay doesn't, the one who created the bill can be held responsible for payment. Number two, if someone needs money right away, they can take the bill to a bank and get it exchanged for cash. Number three, a bill of exchange can be used to settle two different debts in a trade transaction. Let's move on to presentment of a negotiable instrument, a subtopic. So presentment of a negotiable instrument means showing the document to the person who needs to accept it, pay it, or acknowledge it. There are two types of presentment. Number one, presentment of bills of exchange for acceptance. This means showing a bill to someone so they agree to pay it later. Number two, presentment of promissory note for sight. This means showing a promissory note to someone to confirm its terms. Number three, presentment of a negotiable instrument for payment. This means showing a document to someone so they can make the payment it represents. So let's start with presentment of acceptance. Presentment means showing a document to the person who needs to accept it. In some cases, like bills of exchange, showing the document for acceptance is not required by law, but it's a good idea to do so. When the person agrees to pay the bill, they sign it, and this is called acceptance. They become the acceptor, and their liability to pay begins at that point. Rules for presenting a bill of acceptance include: number one, the holder of the representative must show the bill to the person who needs to accept it. Number two, presentment should happen within the specified time in the bill. or within a reasonable time if time is not mentioned. Number 3, it should be done on a business day during business hours at the place mentioned in the bill or at the person's business or home if no location is specified. Number 4, if there are multiple people who need to accept the bill and they are business partners, you can present it to any of them with the authority to accept. Number 5, if there are multiple drawees who are not partners, you need to present it to all of them unless one has the authority to accept all. Number 6, if the drawee has passed away, you present it to the legal representatives. Number 7, if the drawee is bankrupt, present it to the assignee, official receiver, or trustee in the bankruptcy. Let's look at instances when presentment for acceptance is excused or dispensed with. It's important to note that sometimes you don't have to show a bill of acceptance in the following situations. Number 1, when you can't find the person who needs to accept it. Number 2, when the person who needs to accept it has passed away or is bankrupt. Number 3, if the person who needs to accept it is not a real person or doesn't have the legal capacity to make contracts. Number 4, when despite trying your best you can't manage to show the bill of acceptance. Number 5, if even through the representation was done in an irregular way, the person refuses to accept it for some other valid reason. Let's move on to presentment foresight. So when it comes to promissory notes, there's no need for acceptance because the person who promises to pay the maker is the one responsible for it. However, if the note says it should be paid for a certain time after it's seen by the maker, then someone has to show it to the maker to set the due date. If the maker can't be found after a reasonable search, you don't have to show it and you can consider it as not being honored. This showing should happen during business hour on a regular work day. If someone doesn't show in time, they can't hold anyone responsible for the note. Presentment for payment. Promissory notes, bills of exchange and checks have to be shown by the person who's supposed to pay, either by the holder or someone on behalf of the holder. If they don't do this on time, the other people involved in the note can't be held responsible by the holder. But if there's an agreement or it's a common practice, you can send it by registered mail through the post office, and that counts as showing it. If a promissory note says it has to be paid whenever the holder asks and there's no specific date, then you don't have to show it to charge the maker. This is because in the common law, it's the debtor's job to find the creditor and pay them. So these are instances when presentment for payment is not necessary. So number 1, when the person who should pay the money deliberately avoids being shown the instrument. Number 2, when the instrument says it should be paid at a certain place but the place is closed during normal business hours. Number 3, when it's supposed to be paid at a certain place but nobody authorized to pay it is there during regular hours. Number 4, when there's no specific place for payment and the person who should get the money can't be found after looking for them. Number 5, when there's a promise to pay even without showing the instrument. Number 6, when the need to show the instrument for payment is either explicitly or implicitly cancelled by the person who has the right to show before or after it's due. Number 7, when the drawer wouldn't suffer any harm from not having it shown. Number 8, when the bill is already marked as not accepted. Number 9, when the drawer is a made-up person, not a real one. Number 10, when the drawer and the person who should pay are the same. Rules regarding presentment for payment. Number 1, you must show the instrument for payment during regular working hours, for checks during banking hours. Number 2, if a promissory note or bill of exchange is due after a specific date or site, it must be shown for payment when it's due. Any delay after that lets off everyone who isn't mainly responsible for the payment. Number 3, if a promissory note has installment payments, you should show it for payment on the 3rd day after each installment due date. Number 4, if a negotiable instrument can be paid on demand, you need to show it for payment within a reasonable time after you receive it. Number 5, you should show the instrument for payment in the place specified in it. If it doesn't say where, then it should be shown at the person's place of business or residence or where they can be found. Number 6, for checks, present them at the bank before your relationship with the bank and the drawer changes to the drawer's disadvantage. Number 7, you can show the instrument to the authorized agent of the person who should pay. If the person has passed away or is declared bankrupt, show it to other legal representatives or the bankruptcy trustee. Number 8, if circumstances beyond your control cause a delay in showing the instrument, that delay is forgiven. But once those circumstances are gone, you should show it for payment in a reasonable time. Endorsements in a bill of exchange. When you have a bill of exchange that's supposed to be paid to a specific person or whoever they choose, you can only pass it to someone else by signing the back of it and giving it to them. This signature on the back is called an endorsement. There are different types of endorsements. So, Roman 1, blank endorsement. So this happens when the endorser, the person signing, just puts their signature on the back of the bill. Once it's blank endorsed, anyone who holds it can get paid even if it was originally meant for a specific person. Roman 2, special endorsement. In special endorsement, the endorser not only signs but also writes the name of the person they want the bill to be paid to. This makes it clear who should get the money. Roman 3, conditional endorsement. So this type of endorsement adds conditions in or limits to the endorser's responsibility. For example, if someone writes sans recourse without recourse, it means they are not taking any responsibility for the bill. There's also sans frais without expenses, which means they are okay with paying the bill amount but not any extra costs. Roman 4, restrictive endorsement. This kind of endorsements puts restrictions on further transfers of the bill. For instance, if the bill is endorsed with pay X only, it means only one person named as X can receive the payment. Others can't pass it on to someone else. Let's move on to holder and holder in due course. So what is the meaning of a holder, class? A holder of a promissory note, bill of exchange or check is someone who has the right to have it and collect the money that's supposed to be paid on it. If the note, bill or check gets lost or destroyed, the holder is the person who has the right to it when it went missing. To be the holder in your own name, you must either be the person the instrument is made out to or someone it's endorsed to. If it's a bearer instrument, then you simply need to physically have it in your possession. So being a holder means you are the person who can rightfully have the document and get the money from the people who owe it according to that document. Meaning of a holder in due course. A holder in due course is someone who owns a promissory note, bill of exchange or check and met certain conditions when they got it. These conditions are: number 1, they got it in exchange of something valuable like money. Number 2, they got it before the date when it's supposed to be paid. Number 3, they got it in an honest and fair way without knowing about any problems with its ownership. Number 4, they got it without knowing it was previously rejected or dishonored. Number 5, they got it in exchange of something valuable. So to be a holder in due course means you need to follow these rules when you get one of these financial documents like a promissory note or a check. Writers of holders in due course. So, number 1, if you're a holder in due course, you can take legal action using the bill in your own name. Number 2, you have a clean and problem-free ownership of the bill without any issues from previous owners. Number 3, even if you had a problem with ownership and you pass the bill to someone else, they won't inherit your ownership issues. They get a clear title. Number 4, if you had ownership problems but still managed to receive the payment on the bill, the person who pays you won't have to pay again. They are considered clear of any bill-related obligations. Duties of holder in due course. Number 1, you should show the bill to the person who need to agree if it's a pay later kind of bill. Number 2, show the bill and get paid, or else the people who signed it before you won't be responsible anymore. Number 3, tell everyone if the bill can't be paid so they know it's not working out. Number 4, make a written record or formal announcement when the bill can be paid as proof that it didn't work. Let's move on to discharge of a bill of exchange. So, number 1, payment in due course. The most common way to clear an instrument is by the person who should pay it doing so, the person usually the maker or acceptor. Number 2, primary payer becomes holder. If the person who's supposed to pay the bill ends up owning it after it's due and they fully own it, the bill is cleared. Express waiver. Number 3, if the bill holder gives up their right to collect the payment from everyone involved in writing, the bill is cleared. Number 4, cancellation. If the bill is intentionally marked or destroyed in a way that's obvious, it's cleared. You can cross out signatures or physically ruin the bill. Alteration, changing important details on the bill like the amount or due date without everyone's agreement, clears the bill. Number 6, discharge as a simple contract. The bill can also be cleared like any other money agreement by doing things like replacing it with a new deal or when it's too old to be enforced. Let's move on to checks. So what is a check? A check is like a special type of money note. It's a bit like a regular bill of exchange, but there are two main things that make it different to a bill of exchange. Number 1, a specific bank. A check is always meant to be used with a particular bank, so you can't use it with just any bank. Number 2, immediate payment. A check is designed for instant payment, so you don't need to wait for someone to agree to pay you later. So all checks are a type of bill of exchange, but not all bills of exchange are checks. For a check to work, it must follow all the basic rules of a bill of exchange. That means the person who writes it needs to sign it, and it must have a clear and direct order to the bank telling them to pay a specific amount of money to someone named on the check or just anyone holding it. Unlike regular bills of exchange, checks don't need to be accepted. They're made for getting your money right away. So this is how a check looks like. You can observe it. Let's move on to differences between a check and a bill. So let's start on number 1, who it's drawn on. A bill of exchange can be drawn on anyone, including a banker. A check is always drawn on a banker, a specific bank. Number 2, acceptance. A bill needs to be accepted by the person it's drawn upon before payment. A check doesn't require acceptance, it's meant for immediate payment. Number 3, when it's payable. A bill can be payable on demand or after a certain period. A check is always payable on demand, meaning you get your money right away. Number 4, presenting for a payment. For a bill, you have to present it for payment to the person who needs to pay you. If you delay, the person who wrote the bill might not be responsible anymore. With a check, if you don't present it right away, the person who wrote it may only be off the hook for any damage you caused by waiting. Number 5, grace period. Bills not payable on demand usually get 3 days of grace. Checks don't get any grace period. Number 6, stopping payment. You can't stop payment on a bill. The person who writes a check can stop its payment if needed. Number 7, noting or protesting. Checks don't need to be noted or protested for dishonor. Bills may need to be noted or protested in some cases. Number 8, stamp requirement. Checks don't require stamps. Bills often need to be stamped except in certain cases. Number 9, crossing. Checks can be crossed to make sure they are paid into a bank account. Bills can't be crossed like this. So let's move on to liability of a banker and draw on a check. The relationship between a banker and a customer is like a contract. The banker owes the customer money and the customer trusts the bank with the money. It's a bit like the relationship between a helper and person they are helping. Here's what the banker must do. So the banker must honor checks. If the banker has enough money in the account, the banker must give it to them when they write a check. If not, the banker can get into trouble. The banker should also keep good records. The banker needs to keep accurate records of all the things they do with the customer's money. Follow instructions. If the customer tells the banker to do something related to their money, the banker must do it. Keep secrets. The banker can't tell anyone else about the customer's account. Sharing this info could hurt the customer's reputation or business. Tell about the account. The banker can't talk about the customer's account to others, as that could harm the customer. These are the rules and responsibilities for both the banker and the customer. So number one, right to keep staff or lien. Unless there's an agreement saying otherwise, the banker can hold on to things or valuable items that the customer gives them as a sort of guarantee until everything is settled. Number two, right to charge interest. The banker can ask the customer to pay for certain things and interest on borrowed money, but these charges and interest should follow the rules and terms that the banker explained when the customer opened the account. Right to combine debts. If a customer has two accounts with the bank, one has money and the other is in debt, the bank can use the money in one account to pay off what's owed in the other account. Number four, right to decide where payments go. If a customer owes money for different things and they don't pay enough to cover all of it, the banker can choose which debts gets paid first, unless the customer says otherwise. So, obligations of a customer. So here are things a customer should do in simple terms when dealing with their bank. And checks. If a check, so number one, tell if check bounces. If a check you received can't be cashed, inform the bank. Number two, sign checks properly. Sign your checks the way you showed your bank in the signature example. Number three, report lost checks first. If you lose your check, let your bank know as soon as possible. Number four, pay fees and interest. Make sure to pay any fees and interest that you agreed to in your banking agreement. So, termination of banker's authority. These are ways in which a banker's authority to pay on a check can stop. So, number one is when customer says stop. If a customer tells the bank not to cash a check, the bank can't cash it. Number two, customer's debt. If the customer dies and the bank knows they can't cash their checks anymore, bankruptcy notice. If the customer is in financial trouble and there's a notice of bankruptcy against them, the bank can't cash their checks. Number four, insanity notice. If the customer is declared insane, the bank can't cash their checks. Garnishee order. If the bank gets a legal order about the customer's money, they can't cash their checks. Not enough money. If the customer doesn't have enough money in the account, the bank can't cash their check. Number seven, notice of account assignment. If the customer tells the bank they've given the account money to someone else, the bank can't cash their checks. Number eight, holder has no right. If the bank finds out the person trying to cash the check doesn't have the right to it, they can't cash it. Number nine, account closed. Once the customer closes the account, the bank can't cash their checks, even if the check was written before the account was closed. So, crossed checks. Effects of crossing a check. So, let's first look at the types of checks, open versus closed. So, open check, this is like cash. You can take it to a bank and get the money across the counter, but if you lose it, someone else can find it and cash it. So, it's risky. A cross check. So, to prevent open checks from falling into the wrong hands, we use cross checks. These have two parallel lines on them, sometimes with the apostrophe, asterisk, and co-written. A cross check can only be cashed through the bank, not over the counter. It's a way to make sure the money goes to the right person and can be traced. So when you see those lines on a check, it means the money will be paid through a bank, making it safer and more secure. Kinds of crossing on a check. So, number 1, general crossing. When a check has 2 parallel lines on it, it's generally crossed. This means the bank won't give you the money over the counter. You have to go to the bank and cash it. Number 2, special crossing. If a check has the name of a specific bank on it, with or without not negotiable, is specially crossed. You can only get the money through that particular bank mentioned on the check. This adds security. Number 3, not negotiable crossing. When a check says not negotiable, it's still transferable, but it's not easy to transfer. This is done to protect the person who wrote the check from it being mishandled in transit. Number 4, account pay or restrictive crossing. In addition to the above types, there's one more called account pay. This means the money must be credited to the payee's account. If the bank credits it to a different account, they can be held responsible for the check's amount. These checks are still transferable, but they are safer for the payee. Protection to a paying banker. How check payments work and the roles of bank. When you deposit or cash in check, there are typically 2 banks involved. One that collects the check and another that pays the money. So the collecting bank is responsible for taking the check from the person who has it and making sure it gets the right place for payment. The paying banker, on the other hand, this is the bank on which the check is drawn, is the one that must give you the money when the check is presented for payment. Banks have certain protections to make this process smooth. These protections help them do their job without too much interference. These protections come into play when the paying banker has to pay the check, and they include specific circumstances. Number 1, forged endorsement. When a bank pays out money for a check in good faith and as part of its normal operations, it can charge the account of the person who wrote the check for that amount. This rule applies even if it later turns out that the endorsement, which is the signature of the person to whom the check was written, was forged. For example, let's say person C wrote a check to person D or order. Then person E stole the check and forged person D's signature. Person C's bank paid out the money in good faith. In such a case, the bank is not held responsible. They can take the money from person C's account. This rule is also valid for cross checks, but the bank must have acted without negligence. It's all about the bank acting honestly and responsibly in their usual booking procedure. Exceptions to bank protection from liability on checks. So, number 1, forged signature. If the bank pays out money on a check with a forged signature of its customer, it cannot escape liability. Banks are expected to know their customer's signature, and they have to reimburse the customer for any money paid out on a forged check, even if the forgery looked convincing. Number 2, assisting forgery or delays. Banks are not protected if they actively help or intentionally delay reporting a forgery after discovering it. Number 3, fraudulent increase. When the amount on a check is fraudulently increased, the bank must repay the customer any extra amount added to the original. However, the bank may not be liable if it can prove that the customer was partly at fault by leaving space for fraudulent changes. And endorsement or irregular endorsement. If a check is not endorsed, signed on the back, or is irregularly endorsed, a bank can still pay it out in good faith and without liability. This means the bank won't be held responsible for missing or incorrect endorsements. Protection to a collecting banker. So, number 1, no title or defective title. If a banker in good faith and without negligence receives payment for a customer for a certain type of document like a check, and the customer doesn't have proper ownership or has a flawed ownership claim, the banker won't be liable to the true owner of the document just for accepting payment. Number 2, crediting the customer's account. Similarly, the banker credits the customer's account with the amount from this type of document and the customer's ownership in question. The banker won't face liability to the actual owner of the document. In these cases, the banker isn't considered negligent just because they didn't pay close attention to the endorsements, signatures on the back on the document, as long as they acted in good faith. A prescribed instrument in this context can be a check, a document issued by a customer or a banker, not being a bill of exchange but meant to help someone receive a specified sum of money. a draft drawn by a banker on themselves and payable immediately at one of their bank branches. Promissory notes. So a promissory note is a written promise to pay a specific amount of money. It's like an formal IOU. Here is what you need to know about a promissory note. Number one, it has to be written down. It must clearly promise to pay, not just acknowledge a debt. This promise to pay has to be definite and not subject to any conditions. The person making this promise is called the maker, and the person receiving the money is the payee. The maker has to sign the promissory note. So this is how a promissory note looks like. Okay, let's move on to characteristics of or essentials of a promissory note. So it must be in writing. It must have a clear promise to pay. It should clearly state the promise to pay, not just admit a debt. It should be definite and unconditional. The promise to pay must be clear and without conditions. It should be signed by the maker. The person making the promise must sign it. It should have identifiable parties. The note must specify who the maker and the payee are. If this isn't clear, it's not a promissory note. It should contain a certain amount. The amount to be paid must be specific and cannot change based on future events. It's okay if it includes interest or it's paid in installment. The payment has to be in money. There has to be formalities like number, date, place, consideration. So, difference between a bill and a promissory note. The big difference between a bill and a promissory note is that a bill is like an order to pay, while a note is a promise to pay. So here are the key differences. So the parties, number one, the parties involved. In a note, there are two parties, the maker and the buyer. However, in a bill, there are three parties, the drawer, the drawee, and the payee. Number two, the nature of payment. The nature of payment in a note is an unconditional promise to pay. A bill contains an unconditional order to pay. The debtor and creditor. Number three, the maker of a note is the debtor who promises to pay. The drawer of a bill is the creditor who orders the drawee who owes money to pay. Number four, acceptance. The maker of a note promises to pay, so no acceptance is needed. A bill, especially if payable after a certain period, must be accepted by the drawee before payment. Number five, liability. The maker of a note has primary and absolute liability. However, the drawer of a bill has secondary and conditional liability. Number six, payee and maker. A note can't be made payable to the maker, but a bill can be payable to the drawee, to the drawer. So number seven, acceptance requirement. A note doesn't require acceptance. It's signed by the person who owes the money. A bill, especially if payable after sight or a certain period, must be accepted by the drawee. Number eight, bearer payment. A note can't be made payable to the bearer, but a bill can be made payable to the bearer. Relation with parties. In a note, the maker deals directly with the payee. In a bill, the drawer deals directly with the acceptor, not the payee. Number 10, notice of dishonor. When a bill is dishonored, not accepted or not paid, notice must be given to all liable parties, including the drawer and prior endorsers. For a dishonored note, no notice is required to be given to the maker. Okay, let's move on to insurance law. And introduction. In everyday life, we all face different kinds of risks and uncertainties, like getting sick or having accidents. Our stuff like our homes can also be at risk, such as from fires or thefts. Insurance is a way to help with these situations. You have to note that insurance does not make the risks go away, but it helps by spreading the cost of losses over many people who also have insurance. It's like everyone putting money into a pot, and when something bad happens to one person, they can use some of that money to help cover their loss. When you get insurance, you make a deal with an insurance company. They promise to help you if something uncertain and bad happens to you, like getting sick or your house catching on fire. In return, you pay them some money called a premium, either all at once or regularly. To get insurance, you fill out a form with questions from the insurance company. Your answers to these questions are like an offer to buy insurance. If the insurance company agrees, they give you a document called policy. This policy is proof that you have a deal with them to get help if something bad happens. The thing you are insuring, like your car or your house, is called the subject matter. The bad thing you are protecting against happening, like an accident or theft, is called the risk. And the reason you want insurance like yours is valid both to you is called insurable interest. Importance of insurance. So number one, insurance helps protect you in case something bad happens in the future. This bad thing must be uncertain, like an accident or illness. Number two, insurance is like a group of savings plan. People facing the same risk put money together in a pot. If one of them faces the risk, they can use the money to help cover their losses. Number three, insurance also sets a price based on how risky something is. Risky things cost more to insure, so it divides people into groups based on how risky the situations. For example, it is higher to rent a car that is on the right hand side drive than it is to rent a car that is on the left hand side drive here in Kenya. Okay, so number five, insurance collects money and it invests it wisely to help society grow. And number six, insurance reduces worries about losing things or getting hurt. This way people can focus on their goals. Number seven, banks won't lend money unless you protect what you are borrowing against. Insurance helps with this, and lenders also accept insurance as security. So insurance and wagering. So a wagering agreement is when someone promises to give money or property to another person based on something uncertain happening or not happening. Insurance might seem similar because it also depends on uncertain events. However, they are not the same. Here's why. So differences between insurance and wagering include, number one, indemnity principle. Insurance, except for life and personal accident insurance, is about replacing actual losses. Wagering agreements don't care about replacing losses because they are meant to cover any risk. Number two, purpose or objective. Insurance is meant to protect you from losses due to certain uncertain events. Wagering agreements aim to make speculative gains or benefits. Number three, insurance interest. In insurance, you must have a good reason to insure something. In wagering, this interest is often created just for the agreement. Number four, utmost good faith. Insurance needs honesty and good faith from both parties. If not, the contract is void. However, wagering arguments do not require this level of honesty. Number five, legality. Wagering agreements are often illegal and against public interest, so they are not enforceable. Insurance, on the other hand, is encouraged by the law because it benefits society. Number six, calculation of risk. Insurance calculates risk scientifically. The premium it pays based on careful analysis of all factors. Wagering agreements are more like gambling with no scientific basis. 7, degree of losses. In insurance, losses can vary. In wagering, it's all or nothing. You either win or lose completely. So let's talk about premium. Premium is the money you pay to the insurance company for them to take on the risk of something bad happening to you or your stuff. You can think of it like a payment for protection. The insurance company decides how much premium you should pay by looking at how often bad things usually happen and how many people are getting insured. They also add some extra money for their own costs and profit. For example, with fire insurance, they look at how often fires happen in your area and how many things need to be insured for you. Life insurance, they consider how likely it is that you might pass away. You have to pay this premium to keep your insurance going, and the insurance company has to give you a policy in return. It's like a two-way agreement. You can pay the premium all at once, or you can spread it out over time like monthly, quarterly, or yearly. If you don't pay the premium when you should or within a short grace period, your insurance can be cancelled. However, there are situations where you can get your premium money back. And these situations include A, if the thing you are insuring doesn't exist anymore, or if insured your item has already arrived safely when you brought the insurance. B, if your policy says you get your premium back when a certain event happens and that event occurs. C, if there was never really a valid insurance contract from the start, like if there was fraud involved or if the insurance company did not have the authority to offer that type of insurance. D, if you don't have a good reason to insure something while the insurance is in effect. Having a valid reason is crucial for all insurance contracts. E, if you accidentally pay too much for your insurance, they'll give you back the extra money. F, if you accidentally buy 2 insurance policies for the same thing and you didn't mean to, they'll give back the extra premium. So let's talk about a cover note. So a cover note is like a temporary document you get from an insurance company when you ask for insurance. It's like a placeholder until you get the actual insurance policy. Legally, this cover note is in the official insurance policy, and it's not a promise to give you insurance, but if it follows the legal rules, like having the right stamps, it can be used to make sure the insurance company follows through with the actual insurance policy. Just remember, if the insurance company says no to your request for your insurance, the responsibility and the cover note stops. Insurance and assurance. So in the past, assurance was used for life insurance, while insurance was used for things like fire or theft insurance. But nowadays, we often use insurance for both types. So differences between insurance and assurance. So number 1, certainty of events. Insurance deals with uncertain events that might or might not happen, like theft or fire. Assurance deals with events that are certain to happen, like death or reaching old age. Number 2, indemnity. Insurance follows the principle of indemnity, which means it aims to replace the actual loss you face. Assurance doesn't follow this principle because you can't replace a person's life. Number 3, valuation of insurable interest. In insurance, the value of what you are insuring can be calculated in money terms. In life assurance, you can't put a price on a person's life because it's priceless. Time of insurable interest. Number 4, for fire insurance, you need to have an interest in what you are insuring, both when you make the contract and when the loss happens. In marine insurance, you need an interest at the time of the loss. With the life assurance, you only need an interest when you make the contract, not necessarily when the loss occurs. Number 5, duration of contract. Insurance contracts can be made for different time periods, like monthly, halfly, yearly, based on the agreement between you and the insurance company. Life assurance is usually a one-time deal that lasts for a specified number of years until the person covered by the policy passes away, whichever comes first. Let's talk about reinsurance. So reinsurance is like insurance for insurance companies. Sometimes an insurance company might want to take on a big risk, but it's too much for them to handle on their own. So they share this risk with bigger insurance companies. So here's how it works in a nutshell. So the original insurance company insures someone or something, then they turn around and insure part of all of that same risk with other insurance companies. This is called reinsurance. The catch is the reinsurer only pays out if the original insurer has already paid out for a loss. They don't have a direct contact with the person who's insured, so they are not responsible to them. Reinsurance follows all the rules and conditions of the original insurance policy. So if the original policy ends for any reason, the reinsurance policy ends too. It's like a backup plan for insurance companies to handle really big risks. So double and over insurance. So double insurance is when you insure the same thing and the same risk with more than one insurance company. Over insurance is when you insure something for more money than it's actually worth. So why double and over insurance aren't good in some cases? In fire and marine insurance, where the goal is to replace actual losses, double and over insurance don't help much. They don't make you extra money, they just complicate things. The only advantage of double insurance is that if one insurance company goes broke, you can still get your claim paid by the other insurance. Double and over insurance in life insurance. In life insurance, it's different because life is priceless. You can take out as many life insurance policies as you want for any amount without worrying about double or over insurance. Life insurance isn't about replacing something, it's about taking care of your loved ones when you are gone. So rules for double insurance. So number 1, you can insure the same thing with as many insurance as you want up to its full value. Number 2, in case there is a loss, you can't get more money than what your thing was actually worth, because insurance is meant to cover your losses, not to make you rich. Number 3, if you do get more money than the actual value, you have to hold on to the extra amount of money for the insurance, like a trust. Number 4, the insurance who cover the same thing will share the loss based on how much they insured. If one insurer pays more than their share, they can ask the others to pay them back. Remember, in life insurance, you can have as many policies as you want because it's not about replacing something. It's about taking care of your family and loved ones. Let's now move on to types of insurance. Number 1, life insurance. Life insurance is a contract where an insurer promises to pay a certain amount of money when the insured person dies or after a specific period, whichever comes first. So life insurance is not about replacing something but providing financial support to the family or members. So let's move on to number 2, which is fire insurance. These types of insurance covers losses or damages caused by fires during a set time. The contract specifies the maximum amount the insured can claim, but this amount isn't necessarily the same as the actual loss. Let's move on to marine insurance. Marine insurance covers losses related to marine adventures like fires, wars, parties, and other risks at sea. It can also cover inland navigation, but the person insured must have a stake in the vessel, like being a lender, cargo owner, or mortgagee. Number 4, motor insurance. So this insurance covers damages to vehicle from accidents. Number 5, theft or burglary insurance. These types of insurance protects against losses caused by theft. Number 6, fidelity insurance. It safeguards employers from financial losses caused by trusted employees like cashiers mishandling money. Number 7, bad debts insurance. This insurance helps business when customers don't pay their debts, preventing financial losses. Employers' accident liability. This insurance protects employers from damage claims if their workers are hurt due to the employer's negligence or mistakes. These types of insurance offer different kinds of protection depending on the specific risks involved. So, what are the fundamental principles of general insurance? For an insurance contract to be valid, it must meet the standard rules for contracts, like any legal agreement. But there are also some special rules just for insurance contracts. So principles of insurance. So these are likely to come in an exam. So let's talk about insurable interests. Number 1, insurable interests, which means having a financial stake in the thing you are insuring. In life insurance, you must have it when you sign up. In fire insurance, you need it when you sign up and when the loss happens. For example, creditors have an interest in debtors, partners in each other, employers in employees, and spouses in each other. So, number 2, oberima fidei, utmost good faith. This means both the insured person and the insurance must be completely honest with each other. Failure to share important facts can void the entire insurance contract. You must disclose anything that might affect the insurance decision to insure you and how much to charge you. So, number 3, doctrine of indemnity. So this means that insurance is about replacing what you lost and not making a profit. You get paid the actual amount of loss and not more. Number 4, doctrine of subrogation. So after the insurance pays for a loss, they can step into our shoes and go after anyone who might be responsible. This prevents you from getting paid twice for the same loss. So doctrine of contribution. So number 5, doctrine of contribution. This applies when there's double insurance, insuring the same thing with the different companies. One insurance can pay the whole loss and then ask others to chip in based on their share of the coverage. Number 6, principle of proximate cost. The insured can only get paid if the proximate cost of the loss is what they are insured against. It is the most important direct and efficient cost of the event. Number 7, principle of mitigation of loss. If you have insurance and a loss happens, you need to do your best to reduce the damage. If you don't, the insurer might not pay for the extra loss caused by your negligence. Number 8, abandonment. It's giving up the damaged property to the insurer in return for payment. It's usually used when it's too expensive to recover the property and the insurer must agree to it. Number 9, attachment of risk. Insurance only works if the risk, like a fire or accident, hasn't happened yet when you signed up. If it has, the insurance might not cover it. Average clause. This applies when your property is underinsured and you have a partial loss. The insurer only pays a fraction loss based on how much you've insured compared to the property's actual value. This encourages people to fully insure the property. So let's move on to rights of the insurer. So the insurer can cancel the contract if you are hiding facts. If the insured person doesn't tell the truth or hides important information, the insurer can cancel the insurance contract. Number 2, take control of damaged property. If the insured property gets damaged or destroyed, the insurer can take control to protect their interests. Number 3, enter the property in case of fire. If there's a fire and the insured person tells the insurer, they can go into the insured property to check things out. Number 4, subrogation. If the insurer pays for a loss, they can take legal action on behalf of the insured against anyone responsible for the loss. Number 5, salvage damaged items. If the insured stuff is completely ruined, the insurer can keep whatever is left to recover some value. Number 6, replace instead of cash. Instead of giving the insured money for the loss, the insurer might replace or fix what was lost. Contribution for double insurance. Number 7, if the same thing is insured with multiple insurers and there's a loss, each insurer can share the cost based on how much they insured. Duties of the insured. So you have a duty to be honest. You must share all the important information honestly and openly about what you are insuring. Don't over-insure. Don't get insurance from multiple companies if one insurer says not to do it. Number 3, pay your premiums on time. Number 4, reduce the damage. If something bad happens, try to limit the damage as much as you can, just like you would if you wouldn't have insurance. Number 5, report problems quickly. If a risk you are insured against occurs, tell the insurance company as soon as possible. Number 7, take care of what's insured. Keep the stuff you are insuring safe and in good condition before, during, and after any risks. Number 7, tell the insurer if it's beyond saving. If the insured thing is so damaged that it can't be saved, let the insurance know you want to give it up. Law of torts. So the word tort means doing something wrong. It's like when you twist or break the rules. Tort is when someone does something that harms the other person, either on purpose or by accident. It's not related to a personal relationship or a contract. It's a type of civil wrongdoing that violates other people's individual and group rights. A person who does a tort is called a tort feasor, and if there's more than one, they are joint tort feasors. The main goals of tort law are: number 1, to settle disputes between people by getting a court to decide who is right. Number 2, to protect certain rights that the law recognizes, like a person's reputation. Number 3, to stop harm from happening again, like telling someone to stop trespassing. Number 4, to give back property to its rightful owner. So, elements of tort. Tort liability happens when someone breaks a legal duty set by law towards everyone. If this duty is broken and causes harm, the person who broke it must pay for the harm they caused. This payment is usually decided by a court and is not a fixed amount, but it depends on the situation. To make someone responsible for tort, you need to prove 3 things. Number 1, the person did something wrong or didn't do something they should have done. Number 2, the person's actions caused harm or violated the legal rights of someone else. Number 3, the type of wrong they did can be fixed by giving money as compensation. It's worth mentioning that in some cases you can take legal action even if no harm is done, like in trespassing. However, there are specific rules to decide if the person who took legal action has a case against the person they are complaining about. The following principles or factors will determine whether the plaintiff has any remedy against the defendant. So, number 1, damnum sine injuria. This means damage without industry. For example, let's say some company decided to lower the prices to compete with another business, and that competition caused the other business to lose money. In this case, even though the business suffered a loss, the law does not consider it a violation of rights because it's just normal competition. Let's move on to injuria sine damnum. So this means harm without actual loss. Let's say a situation where someone had the legal right to vote, but a returning officer wrongly denied them that right. Even if the vote wouldn't have changed the election outcome, the court can still make the person who denied the vote pay because they violated the person's legal right to vote. This rule is based on the idea that if you have a right, there should be a way to enforce it. The fault principle, number 3. So the fault principle is about showing that the person who did something wrong acted in a way that goes against what the law expects to prove this, you need to establish 3 things. Number 1, or let's say if the person did something wrong on purpose, knowing what would happen, they are at fault. Number 2, if they did something without caring about the consequences, it's also their fault. Number 3, if they did something because they weren't careful or didn't think about what could go wrong when they should have, that's another way to show fault. Number 4, motive and malice. Motive is the reason why someone does something. It can either be good or bad. Bad motive, which is legally called malice, means having will or wanting to harm someone. For example, if someone deliberately pollutes drinking water or throws garbage into their neighbor's path, that's malice. In most cases of wrongdoing, like in tort law, which deals with civil wrongs, the motive doesn't really matter. Whether someone had good or bad intentions doesn't excuse the actions. However, in some specific torts, especially those involving minors or people with mental health issues, the motive or malice can be important in proving the case. To simplify, most of the time, why someone did something wrong doesn't change whether they are responsible for it or not. But in certain situations, like when people intentionally harm others or conspire against them, their motives can be considered in the legal judgment. Tort and crime distinguished. So, in tort, number 1, the person who is affected. So, a tort harms an individual and that person can seek compensation from the wrongdoer. A crime harms society as a whole. Number 2, nature. So torts are civil wrongs dealt in civil courts. Crimes are criminal wrongs handled in criminal courts. So number 3, the purpose. So in torts, payment damages is meant to compensate the victim for their loss. In crimes, the goal is to punish and reform the offender. Parties involved. So in torts, harmed individual plaintiff brings the claim. In crimes, the state prosecutes the case on behalf of society. Number 5, burden of proof. In torts, the evidence must show the harm is more likely than not to have occurred. In crimes, the evidence must prove guilty beyond a reasonable doubt. Punishment. So, in tort, punishment involves financial compensation, whereas in crime, punishment can be severe, including imprisonment or capital punishment. A tort and a contract. So, a tort differs from a contract in the following respects. So, the nature of tort is a civil wrongdoing by itself and related to any contract. It leads to a legal action for uncalculated damages. A contract, on the other hand, is a formal agreement between two people defining their rights and responsibilities and can be legally enforced. Number 2, duties. In tort, duties are set by the law, like not being careless. In contracts, duties are decided by the parties involved. The person affected. In tort, the duty is owed to everyone in the world. In a contract, the duty is owed to specific people. Number 4, damages. Tort damages are always uncertain because they can't be precisely measured. Contract damages can be certain or uncertain. Number 5, time limit. In tort, the time limit starts when harm happens 3 years. In contract, it starts when the breach of contract happens in 6 years. Number 6, consent. Tort doesn't focus on consent. Even if there's consent, the wrong can't be excused. Contracts, on the other hand, are built on consent. Both parties must agree. Privity. In tort, privity, which is the direct connection between parties, isn't a big deal for determining liability. In contracts, privity is significant and must be assumed to exist. So, capacity of parties in torts. So, capacity in torts refers to whether someone is allowed to sue or be sued in a tort. Normally, anyone can sue or be sued for a civil wrong because everyone follows the same laws. But in some situations, there are specific rules that limit or even prevent someone from taking legal action or being taken to court. This means that certain people may not be able to file a lawsuit, while others might have special conditions for being sued. The capacity for various persons to sue or sued may be summarized as follows. Minors. So the usual rule is that a minor doesn't protect you. Being a minor doesn't protect you in cases of civil wrongs. So kids can sue or be sued in the same way as adults. However, age can matter in some specific situations. For example, if a young person doesn't fully understand the actions and does something wrong by accident, and they might not be held responsible for their mistake. In a case from the past, a young person rented a house for riding and accidentally hurt the animal. They got sued for the damage, but the court decided they weren't at fault because it was more like a contract issue than a tort. Usually, parents or guardians aren't responsible for their children's wrongdoings unless they somehow give permission for it. But if they can, they are careless and let the child do something harmful, they might be held responsible. For instance, if a parent lets their teenager have dangerous weapon like a shotgun and the teenager hurts someone with it, the parent could be held accountable. Okay, husband and wife. In simple terms, when a woman gets married, she is legally treated as if she was still single. When it comes to certain lawsuits, torts, this means she can sue or be sued just like an unmarried person. A wife has the right to sue her husband in tort if she needs to protect her property or seek justice for the wrong he did. In Kenya, husband can also be held responsible for any wrongs the wife commits. So both the husband and wife can be involved in lawsuits related to tort. However, in the past, according to common law, a husband couldn't sue his wife in tort, and a wife couldn't sue her husband in tort except if she needed to protect her own property. So the other one is the government. The government is a law that treats the government like the Government Proceedings Act is a law that treats the government like a regular person when it comes to lawsuits for wrongful actions. In other words, it holds the government accountable in the same way it would hold an individual accountable in certain situations. Here are the things for which the government can be held responsible under the law. Number 1, when its employees or representatives do something wrong, commit a tort. Number 2, when it fails to meet its responsibility as an employer to these employees. Number 3, when it doesn't fulfill its duties relating to owning, using, or controlling property. Number 4, when it breaks laws that impose certain duties on it, which are legal obligations set by statutes or regulations. So persons of unsound mind, people who are mentally unwell or are usually responsible for the actions in a legal sense. However, if a specific wrongful action requires intent and proven that they could not have had the intent due to their mental condition, then they may not be held responsible. In an example case, someone who was mentally ill attacked the hotel manager. It was found that this person had a mental illness but still understood what they were doing. However, they did not realize that the actions were wrong. In this case, the court decided that the person was still responsible for the attack because they knew what they were doing even if they did not know it was wrong. Judicial officers, judges and court officials are safe from being sued for civil wrongdoing when they are carrying out their duties related to the legal system. This means that if they make decisions or take actions as part of their job in their court, they cannot be taken to court themselves for those actions. Similarly, people who work in the legal system like court brokers are also protected from being sued for their actions as long as they are following the orders of the court. So if a court tells a broker to take someone's property, the broker can't be sued for doing so as long as they are following the court's instructions properly. So the Constitution protects the President of Kenya. It says that while the President is in office, they can't be taken to court for civil or criminal matters related to the actions as President. However, if there is a crime that the President can be prosecuted for under an international treaty that Kenya is part of, the immunity doesn't apply. So another one is heads of foreign states. So heads of foreign countries, diplomats from foreign missions, and some others who are linked to them are protected from being prosecuted or sued in local courts. But this rule doesn't apply to Kenyan people working for foreign embassies. It's essential to know that even though these diplomats and their staff can't be sued for civil wrongs like torts, the Ministry of Foreign Affairs can declare diplomat as persona non grata, meaning an unwelcome person, and ask them to leave Kenya. So trade unions. So a registered trade union is seen as a legal entity with ongoing existence, having the ability to take legal actions and be taken to court. Trade unions can file lawsuits for civil wrongs, but there are limitations on suing them. According to the Labor Relations Act, you cannot take legal action against a trade union for civil wrongs committed by its members or officials during a labor dispute. However, you can sue a trade union if it breaches a contract. Let's talk about corporations. These are legal entities created by the law. They can take legal action and can also be taken to court. However, if an employee of a corporation does something wrong that goes beyond their job duties, the corporation might not be held responsible. Also, there are types of wrongs like personal insults or physical attacks where corporations are not held responsible. Let's move on to the defenses in torts. So, the first one, number 1, volunteering and fit injury or consent. So let's talk about this. The general rule is that if someone willingly agrees to take a risk, they can't later complain about any harm that comes from it. For example, if a person chooses to play a sport like boxing, football, or rugby, they can't seek compensation if they get hurt during the game because they knew the risks and agreed to them. To use this defense, the person who caused the harm must show that the injured person knew about the danger, understood it completely, and decided to take the risk voluntarily. An example of this defense in action is a case where a passenger insisted on continuing a bus journey despite knowing that the road was flooded and risky to cross. When the bus eventually got stuck and the passenger died, the court ruled that the passenger's family could not sue the bus company because the passenger had willingly taken the risks. In simpler terms, if you know the risks and agree to them, you can't later complain if something goes wrong. Number 2, inevitable accident. So, inevitable accident means an accepted and unforeseeable injury that couldn't have been prevented, even if the person responsible tried their best to be careful. It's like when something goes wrong but nobody was negligent or careless. To use this defense, the person being sued must show that they couldn't have done anything more to prevent the accident. In total law, where the focus is on fault, an injury resulting from an inevitable accident isn't something you can sue for. For example, in a case where a person was carrying ammunition for a shooting party and the bullet accidentally hit someone due to an accepted bounce after hitting a tree, the court ruled it as an inevitable accident and the shooter wasn't liable because they couldn't have foreseen it or prevented it. So the next one, number 3, vis major. For example, in a case where heavy rain caused a person's man-made lake to overflow and destroy some bridges, the court said it was an act of God because nobody could have predicted or prevented such an unusual and powerful natural event. Therefore, the person who owned the lakes wasn't held responsible for the damage. So, an act of God is something that happens due to natural forces like storms, earthquakes, or floods without any human involvement. So, number 4, necessity. Necessity happens when someone has to interfere with another person's rights to avoid harm to themselves or their property. So normally you shouldn't mess with someone else's stuff or person, but in urgent situations where there is real and immediate danger, the defense of necessity might apply. It is based on the idea that the well-being of the public is more important. For example, in a case where someone trespassed on another person's land to prevent a fire from spreading, even though the fire didn't actually damage anything, the court ruled that it was okay because the danger of the fire spreading was real and immediate, and a reasonable person would have done the same thing. Number 5, self-defense. Every person has the right to protect themselves. If someone attacks you, you don't have to run away. You can defend yourself. But when you defend yourself, you should use a reasonable amount of force, not more than what the attacker is using. For example, in a case where a dog was attacking a person's sheep and the person shot the dog to stop the attack, the court said it was okay. That's because it was the most practical and reasonable way to stop the dog from hurting the sheep. Number 6, statutory authority. So when you do something because a law allows you to do it, that's a good defense. It means the person who got hurt can't sue you. For example, in a case where a railway company was allowed by a law to run trains through someone's land and a fire accidentally started from the train sparks, the railway company wasn't held responsible because they followed the law and took precautions. The law allowed them to run the train, so they weren't liable. Number 7, mistake. In most cases, if you make a mistake, whether it's about the law or facts, it's not a valid excuse in a tort case. For example, if a police officer arrests someone they genuinely believe is about to commit a crime, but it turns out that the person is innocent, the officer wouldn't be held responsible because they made an honest mistake about the situation. So let's move on to vicarious liability. This is when one person is held responsible for the wrongs or harm caused by someone else. For this to happen, there needs to be a specific kind of relationship between these two people. Some examples of these relationships are master and servant, principal agent, government and servant, firm and partners, company and directors. Let's move on to master and servant. A servant is a person who works for someone else under an employment contract. The master has control over how the work is done. The legal concept is based on the idea that if the master benefits from the work of the servant, they should also take responsibility for any harm caused by the servant's action. It's a fair way to ensure that injured parties can seek compensation from the employer, who typically has more financial resources. So even if a servant goes against the employer's explicit instruction, it doesn't act in the master's interest, the master can still be held liable. An example of this is the case of Olympus versus London General Omnibus, where a bus driver caused an accident by disobeying instructions and obstructing a rival bus company. In this case, the employer was held liable regardless of the driver's wrongful actions being against the company rules. So independent contractor. Let's move on to independent contractor. An independent contractor is someone who is hired to achieve a specific result, but they have the freedom to decide how to accomplish that result without direct control or supervision from the person who hired them. The reason why a master can be held responsible for the actions of a servant is because the master typically directs and oversees how the work is done. However, when it comes to independent contractors, because the employer doesn't have direct control over them, the employer is usually not held responsible for any wrongful acts committed by the independent contractor. There are exceptions to this rule where the employer may still be held liable for the independent contractor's action. This is when the employer retains control over the contractor and actively participates in the act that causes harm. Number B, this is when the contract work itself is inherently a wrongful act, like in a case where a contractor creates a hazardous situation. Number C, when the contracted work is likely in the normal course of events to cause damage or create nuisance. Number D, when the independent contractor performs a legal duty but does it poorly. In this case, the employer has a responsibility to ensure the work is done properly, and if they fail to inspect the work and it causes harm to someone else, the employer can be held liable. Number E, when there's strict liability, meaning liability without having to prove negligence, as seen in the case of Rylands versus Fletcher. So let's talk about strict liability. So strict liability means that someone can be held responsible for their actions without needing to prove they were at fault or negligent. So strict liability is not the same as absolute liability. With absolute liability, you can bring a legal action without having to prove any fault on the part of the wrongdoer, and there are no defenses available to the wrongdoer. In cases of strict liability, you don't need to prove fault, but there may still be some defenses that the wrongdoer can use. Strict liability can apply in various situations, including the rule in Rylands versus Fletcher. This legal principle holds someone strictly liable if the activities result in damage to another person, even if they took reasonable precautions. Number 2, liability for fire. In certain situations, individuals or entities may be held strictly liable for the fires they cause, regardless of whether they were negligent. Number 3, liability for animals. In cases involving harm caused by animals, strict liability may apply, meaning the owner or keeper of the animal can be held responsible for any harm it causes, regardless of their fault. So rule in Rylands versus Fletcher. So the rule in Rylands versus Fletcher is a legal principle that says if someone brings and keeps something on their property that could cause harm, if it escapes, they are responsible for any damage it causes if it does escape. This rule comes from the famous case in 1866. In that case, Rylands had hired a contractor to build a reservoir on his land next to Fletcher's land. Due to the contract's mistake, some old mine shafts connecting to Rylands' land to Fletcher's were not properly blocked. When the reservoir was filled with water, it escaped through these shafts and flooded Fletcher's mine, causing significant damage. The court decided that Rylands and Fletcher were responsible for the damage, even though they hadn't done anything wrong for themselves. They had brought the water onto their land for their own purposes, and it was something that could cause harm if it got out. So when it did escape and cause damage, they were held responsible for it because it was a natural result of the water escaping. In simple terms, if you bring something onto your property that could be dangerous, if it gets loose, you have to make sure it doesn't escape, or you could be held liable for any damage. Limitations to the rule. So number 1, the rule applies when someone uses their land in an unusual or unnatural way. This means they have accumulated something on their land that doesn't naturally belong there. Number 2, for the rule to be relevant, the thing that might cause harm must actually escape from the defendant's land and go outside of it. Number 3, the rule only applies to things that are likely to cause harm, like acid or fire, or something that can shake or vibrate the ground. Number 4, if the land is used in a way that is considered normal and natural, the rule doesn't come into play. If it's designed for situations where the use of land poses an increased danger to others. Number 5, if the thing brought into the defender's land doesn't escape from there, the rule doesn't apply. In simple terms, the rule in Rylands versus Fletcher is about holding someone responsible when they use the land in an unusual way, and something potentially harmful escapes from the land, causing harm to others. If the land use is normal, if nothing escapes, the rule doesn't apply. So, defenses for two rules in Rylands versus Fletcher. So, number 1, act of God. This means that if the escape of the harmful substance or thing was caused by an unpreventable natural disaster like a massive flood, earthquake, or storm, it's considered an act of God. In such cases, the defendant isn't held responsible because it's beyond human control. Number 2, things naturally on land. The rule applies to dangerous things that were intentionally brought onto the land by the owner or occupier. It doesn't apply to things that naturally grow on the land without human intervention. Number 3, act of stranger. If the escape is caused by someone who isn't authorized by the defendant isn't liable. This includes unknown persons who aren't supposed to be there. Number 4, plaintiff's faults. If the escape happened because of something the plaintiff did wrong, the defendant isn't liable. In this case, the plaintiff essentially caused the harm. Number 5, consent and benefit. If the plaintiff agreed to and benefited from the dangerous thing that caused harm when it escaped, the rule doesn't apply. In other words, if the plaintiff willingly accepted the risk, they can't hold the defendant responsible. Statutory authority. If the defendant was allowed by the law to keep, collect, or store the dangerous things that escaped and caused harm to the plaintiff, the rule doesn't apply. So let's move on to liability for fire. So, liability for fire. This rule applies to situations where fires or flammable substances escape and cause harm. If someone intentionally sets fire to another person's property or starts a fire on someone else's land, it is considered trespass and they are responsible for the damage. Starting a dangerous fire. If someone starts a big dangerous fire, they might be liable under this rule because they are creating a nuisance. When starting any fire, they must be careful to control it. Liability for negligence. If a fire starts without negligence, meaning it wasn't due to carelessness, but then someone is careless and lets it spread, they can still be held liable for the damage. Liability for animals. So when it comes to harm caused by or to animals, there are two categories: dangerous animals like lions and leopards, and non-dangerous animals like common pets. Dangerous animals. If you own or keep a dangerous animals and it causes harm to or damage to other people, you are responsible, regardless of whether you are careful or not. For example, if someone is scared by your normally calm tiger and suffers a heart attack, you are liable for the injury because it's reasonable to be afraid of such an animal. So for non-dangerous animals, if your cattle wander into a neighbor's land and cause damage, you are liable. As simple as that. So let's talk about specific torts. So let's start with the first one, which is trespass. This means an unlawful interference with a person, his land, or goods without any lawful justification. So there are 3 types of trespass. So number 1, trespass to land. This involves entering someone else's land or interfering with their property without their permission. For example, if your animals damage another person's land, it is treated as if you did it yourself. So, defenses against trespass to land. So, Roman 1, prescription. Land acquired through long-time possession can be claimed by the possessor. Number 2, Roman 2, entry by license. If the owner allows you to enter, it's not trespass unless you abuse that permission. Roman 3, act of necessity. Trespass can be justified if it was necessary, like entering someone's land to put out a fire. Roman 4, statutory authority. Certain professionals may have the legal right to enter property. Roman 5, involuntary act. If an act occurs without your negligence, like a house escaping into another's land, you might not be liable. So Remedies for trespass to land. So number 1, damages. This means getting money from the person who trespassed on your property. Number 2, injunction. This is like a special order from court that tells the trespasser to stop or not start the trespass. Number 3, ejection. You have the right to use reasonable force to kick out or remove the trespasser from your property. You can also ask the court order for their removal. Number 4, action for recovery of land. If someone has taken your land without your permission, you can sue them to get your land back. Number 5, distress damage pheasant. If animals trespass on your property and cause damage, you can seize and keep those animals until the owner pays for damage they caused. So the second trespass is trespass to person. This means messing with somebody's. Trespass to person means messing with someone's body without a good reason. It's not allowed unless there's a good excuse. There are 3 kinds of trespass to persons. Number 1, assault. So assault is when someone makes another person scared of getting hurt right away. For example, if someone shakes their fists or points a dangerous object at another person in a threatening way. To prove an assault, the person who got hurt has to show there was some kind of threatening gesture. The gesture or action was serious enough to make the person being threatened feel like they were in immediate danger. The person doing the threatening had the means to actually hurt the person. In simple terms, assault is when someone makes you really afraid that they are about to hurt you right away and they have the ability to do it. So let's talk about battery. Battery is when someone purposefully and actually uses force on another person's body without a good reason. It doesn't matter if the force is applied directly like punching or indirectly like throwing something and thing, but there must be real physical contact between the person who did it and the person who got hurt. To prove battery, you have to show 2 things. The force used affected their body, like a push, a hit, or even throwing something at them. Number 2, the use of force was on purpose and done willingly. It means the person who did it intended to harm or make contact with the other person. So, battery is when someone intentionally and physically hurts another person without a good reason, and it's not just any accidental bump or push. False imprisonment. False imprisonment happens when someone completely takes away another person's freedom or liberty without a good reason. It doesn't matter how long it lasts, even a brief period of restriction can count. What's interesting, for example, if someone locks another person in a room while they're asleep and then unlocks the door before they wake up, is still considered false imprisonment. The person who was locked in can still sue for it even if they were unaware of what happened. In simple terms, false imprisonment is when someone wrongly takes away another person's freedom or locks them up without a valid reason, and it doesn't matter if the person realizes it or not. Defenses against trespass to person. So, number 1, voluntary non-fit injury. If you willingly agree to engage in a physical activity or sport where bodily contact is expected, you can't later complain if someone accidentally touches or bumps into you during a game. It's like saying I knew the risks, so I can't blame others for it. Number 2, private defense. You have the right to protect yourself, your property, and your family. If you use reasonable force to defend yourself in a situation where you are under threat, you are not legally responsible for harming the other person. It's like saying I had to defend myself or my loved ones and I did it reasonably. Number 3, statutory authority. Some people, like police officers, have the legal power to do certain things to maintain public order. If they use reasonable force while exercising their legal authority, they can't be sued for trespass to a person. Number 4, forceful entry. If someone wrongfully tries to enter your property, you are allowed to use force to stop them or regain control of your property or belongings. It's like saying I can protect what's mine from trespassers within one reason. Number 5, parental authority. Parents and teachers can discipline children for their benefit as long as it's reasonable and not abusive. Let's move on to the other trespass, which is trespass to goods. Trespass to goods is when someone intentionally messes with or damages things that belong to someone else without a good reason. To prove this in a legal case, number 1, the person must have directly interfered with the stuff, not with the person who owns them. Number 2, at the time of the trespass, the owner should have had control over the things. Number 3, the person doing the interference must have done it on purpose, not by accident. And this is divided in 2 types. So, conversion. This is when someone treats stuff in a way that goes against the owner's rights, like selling someone else's things without permission. Number 2, detenure. This happens when someone wrongfully keeps stuff that they are supposed to give back to the owner. It's like saying, I want to return this, even though I showed defenses to trespass of goods. So, Roman 1, right of lien. This is like having permission slip to hold on to someone else's stuff until they pay you what they owe. For example, if you sell something to someone, you can keep that thing until they give you all the money they owe you. Roman 2, statutory authority. Sometimes the law allows certain people to mess with someone else's thing without getting into trouble for it. It's like having a legal pass to take someone else's things. So Roman 3, judicial authority. Courts and judges can also say it's okay for someone to touch or take another person's property in specific situations, like when auctioneers need to take and sell someone's things as ordered by the court. It's like the court giving them permission to do it. Remedies against trespass of person. So, repossession. If someone takes your things without permission, you have the right to take them back. Roman 2, court order to return. Sometimes you may need to ask a court to order the person who has their things to give them back to you. This happens when just asking doesn't work and simply getting paid for the loss isn't enough. Number 3, compensation. If someone takes your things, you can also ask for compensation, which means they have to pay you back for the full value of what they took, plus any extra money to make up for any trouble that they caused while you didn't have your stuff. Roman 4, misleading the public. If someone tries to trick people into thinking their goods are actually yours and it harms your business, they can get into trouble for that too. This is called passing off. So let's move on to nuisance. So we move on to nuisance. So nuisance is when someone wrongfully disrupts another person's use or enjoyment of their land or related rights. This disruption can be physical, like a structure hanging over someone else's land, or allowing unpleasant things like smoke to go into their land. Nuisance typically happens when neighboring landowners don't fulfill their responsibility. It is based on the idea that no one should use their property in a way that might affect or bother their neighbor's use of their land. This interference can involve discomfort, health problems, safety issues, and more, like noise, vibrations, heat, smoke, and smells. Nuisance usually applies when the wrongdoing is ongoing. The law of nuisance protects regular or normal people. In a nuisance lawsuit, is not a defense to say the plaintiff went near the source of the problem themselves, or that the action causing the nuisance is for the public's benefit. Nuisance are of two types, namely private nuisance. So, private nuisance happens when someone wrongfully interferes with another person's private rights in their land. It's a wrongful action that affects specific individuals, not the whole public. Examples of private nuisance is blocking someone's right to pass through or use an easement, letting unstable structures dangle precariously over someone else's land, allowing things like smoke, gas, noise, and so on to spread onto someone else's land. So public nuisance, also known as general or common nuisance, is when something interferes with the rights of everyone in a community. It's an action or a lack of action that causes harm, danger, or annoyance to the public or a group of people in general. It affects the comfort or convenience of a group, but not necessarily every single person. So public nuisance is treated as a criminal offense and is handled by the Director of Public Prosecution. So it doesn't automatically lead to a civil lawsuit for an individual unless the person can prove three things. A, they've experienced a specific unusual harm that's beyond what the rest of the public has suffered. B, the harm they have suffered is significant, not something minor. C, the harm is directly caused by public nuisance, not just an indirect result. So, difference between public and private nuisance. So, Roman 1. For the nature of harm for public nuisance is that it affects many people, while private nuisance only harms one person or a specific group. Roman 2. Anyone with a land affected by private nuisance can sue, but public nuisance usually can't be sued by private individuals except in special cases. Roman 3. Public nuisance can't become legal over time, but a right to continue a private nuisance can be acquired through prescription. Roman 4. You can claim damages for private insurance. You can claim damages for private nuisance, but for public nuisance, you typically seek a declaration and injunction. Roman 5. You can remove a private nuisance yourself, but you can't do that for a public nuisance. Roman 6. For public nuisance, you can seek remedies in both the civil and criminal courts, while for private nuisance, you usually go to civil court for remedy. So, defenses to nuisance. So, Roman 1. Gaining rights over time or prescription. You can get permission to cause a private nuisance if you've been doing it for more than 20 years, but you can't claim the same for public nuisance. Roman 2. Legal permission or statutory right. If the law allows what the defendant is doing, they won't be responsible for any disturbance it causes. For example, people near an airport can't sue because the law permits noisy aircraft. Roman 3. Giving permission or consent. If you let someone unreasonably use your property and then change your mind, you can't complain unless you tell them you've changed your mind. Roman 4. Significant damage needed or triviality. Nuisance matters only if the harm is substantial. If it's tiny and is insignificant, it might not be a problem. Roman 5. Reasonable use. The defendant can argue that what they are doing is lawful and reasonable on their property. Roman 7. Roman 8 or 7. Yes. Roman 6. Permission through grant is usually a valid defense if the defendant can show they were allowed to cause the alleged nuisance through a grant or license. So, remedies against nuisance. Compensation. The plaintiff can get money to make up for the damage caused by nuisance. Roman 2. Self-help abatement. You can fix the problem yourself without a court order, like cutting overhanging tree branches on your side, but you have to give a notice first. Roman 3. Court order to stop. If the nuisance is still happening or going to happen, the court can order the defendant to stop. If this happens when you alone want to fix the issue. Roman 4. Criminal charges or conviction. If the nuisance is also a crime, the person responsible can be charged or sentenced. So let's move on to number 3, which is negligence. So negligence means not doing what a reasonable person would do, or doing something a reasonable person would not do, which leads to harm. It's when the defendant doesn't take proper care or skill when they owe the plaintiff a duty to do so. So to sue for negligence, the plaintiff needs to prove the following. So number 1, the defendant had a legal duty to be careful. Number 2, this duty was owed to the plaintiff. Number 3, the defendant didn't meet this duty, meaning they were careless. Number 4, the plaintiff suffered harm because of this carelessness. So let's talk about legal duty of care. The defendant must have had a legal duty to be careful, because negligence only happens when someone breaks legal duty. This duty can come from common law. It means not doing something that you are legally obligated to do. So for example, a man bought a bottle of ginger beer for his girlfriend. The drink was in an opaque bottle, so its contents couldn't be seen. When she poured it, she found a decomposed snail inside and got sick. She sued the manufacturer for the harm. The court said the manufacturer was still responsible because they had a duty to make sure the bottle didn't have anything gross like a snail inside it. So duty towards plaintiff, number 2. So the duty of care must be directed towards the person who is bringing the lawsuit. If the defendant didn't have a legal obligation to be careful towards that specific person, they can't be held responsible. For example, a pregnant woman had a road accident from a distance, went to the scene, saw blood, got really upset, and later had a miscarriage due to seeing the blood there. The court said that she couldn't sue for negligence because the harm she suffered and how it happened couldn't have been predicted. In this case, the defendant didn't owe her any duty of care, so they weren't responsible. But for example, in 1901, a pregnant woman was sitting in her husband's bar when suddenly a house crashed in. She got scared, suffered nervous shock, and had a premature baby. The court ruled the defendant was responsible in this case. So in this case, they had a duty towards the plaintiff, and that's why the defendant was responsible in this case. So the third one is breach of duty of care. Once it's clear that the defendant had a legal duty of care towards the plaintiff needs to prove that this duty was not met. In other words, it was breached. Breach of duty means the defendant didn't meet the expected standard of care. This standard is like a measuring stick for the defendant's action. It helps determine if the defendant did what a reasonable person should have done. So, to figure out if there was a breach of duty, we use a guideline described by Judge Anderson. He said negligence is when someone doesn't do what a reasonable person acting with ordinary common sense would do in the same situation. So a reasonable person, like an average person on the street, someone with everyday judgment, but it can change depending on the specifics of each case. So the final one is injury to the or damage to the plaintiff. To win a negligence case, the plaintiff must show that they were harmed because the defendant didn't meet the duty of care. In other words, the plaintiff has to prove that the defendant's actions or omissions directly caused the injuries. If negligence is proven, the plaintiff can only get compensation for injuries they suffered. The defendant is responsible if a reasonable person in their shoes should have known that the actions could harm the plaintiff. So if the injury wasn't something a reasonable person could have seen coming, is considered too distant or remote, and the plaintiff can't claim damages for it. So burden of proof in negligence. In most cases, it's the plaintiff's job to prove that the defendant was negligent, that they had a duty to be careful, they didn't meet that duty, and the plaintiff got hurt because of it. But sometimes this can be tough for the plaintiff, especially when the real cause of the accident is known only to the defendant. In such situation, there's a anti-legal concept called res ipsa loquitur, which means the thing speaks for itself. It kicks in when an accident shouldn't have happened unless someone was negligent. It's like when something falls from a warehouse for no apparent reason. In cases like this, the plaintiff doesn't need to prove negligence because the circumstances clearly point to it. Res ipsa loquitur is like a tool that helps the plaintiff in proving negligence, but for it to work, these conditions must be met. Number one, the thing causing the injury must have been under the control of the defendant or someone the defendant was responsible for. Number two, the event should be the one that wouldn't happen if the defendant had been careful. Number three, there should be no evidence or explanation of why or how the event occurred. For example, in case of Bryan versus Broden, a barrel of flour fell from a warehouse and injured a passerby. The court decided that the injured person didn't have to show exactly how the accident happened because, based on facts, it was reasonable to assume, and res ipsa loquitur applied. Let's move on to defenses to negligence. So, Roman 1, contributory negligence. This happens when the injured person This happens when the injured person's own actions or behavior played a part in causing the injuries. It means they didn't take reasonable care for their own safety. In such cases, the court might decide to reduce the damages they can receive or share the responsibility between the injured person and the defendant in a fair way. Roman 2, this major act of God. When something unexpected and uncontrollable occurs, like natural disasters or other events beyond human control, and it leads to the incident that the plaintiff is complaining about, the defendant isn't considered negligent. They can't be held responsible for such actions. Inevitable accident. This is an accident that can't be avoided. Let's move on to remedies against negligence. So the first one is damages. This is the money that is given to the person who was harmed because someone else was negligent. The other one is injunction. This is a court order that tells someone to stop doing something wrong. It's like a legal stop doing that command. So the final one, which is defamation. Defamation is when someone says false and harmful things about another person without a good reason. A person's reputation is really important and valuable, even more than their possessions. So whether a statement is defamatory or not depends on how a reasonable and a fair-minded person in a society would see it. So it's all about whether the statement could make people think less of the person it's about. So Essentials of defamation. To prove defamation, you need to show 4 important things. Number 1, the statement made by the person accused of defamation is false. Number 2, the statement is harmful and can damage someone's reputation. Number 3, the statement is about the person who is complaining, the plaintiff. Number 4, the statement was shared or made in public in some way. So let's talk about number 1, which is false statement. So defamation involves saying something false about someone that can harm their reputation. When someone makes a defamatory statement, it's assumed to be false unless proven otherwise. The person making the statement must prove that it's true. If it turns out to be true, it won't be considered defamation, no matter how damaging it may seem. The other one is defamatory statement, and a statement is considered defamatory when the words used have the potential to harm the reputation of person it's about. This can happen if the statement, number 1, makes the other people think poorly of the person, makes the person a target of hatred, including ridicule or contempt from the public. Number 3, harms the person's professional or business reputation. Number 4, causes others to fear, avoid, or dislike the person. Number 5, lowers the person's standing or respect in the eyes of the public. Statement referring to the plaintiff. For defamation to be valid, the statement must be connected to the plaintiff in some way. If a defamatory statement is made about a large group of people like lawyers or doctors, it's not automatically a defamation case. Only if a specific individual within that group can prove the statement applies to them can they bring a defamation suit. You can't defame a whole category of people, it has to be specific individuals. However, if a statement defames a board of directors, it is considered defamation for each member, even if they are not individually named. So any one of them can sue. Publication of statement. Defamation only becomes a legal issue when it's shared with someone other than the person it's about. This sharing or spreading of the defamatory statement is called publication. So if someone sends a defamatory message, in a sealed envelope directly to the person it's about, it doesn't count as defamation. It is important to note that each time a defamatory statement is repeated or shared, it's considered a new act of publication. This means that not only the person who originally made the defamatory statement, but also anyone involved in sharing it, like an editor, printer, or publisher, can be held legally responsible. They can be sued together or separately for defamation. So types of defamation. Number 1, slander. Slander refers to spoken or non-permanent defamatory statements, like when someone says harmful things about another person. In most cases of slander, you can only take legal action if you can prove that the slander caused you some harm or damage. However, there are some special situations where you can sue for slander even without proving harm. These include when the slanderous statement accuses you of a crime punishable by imprisonment, claims you have a contagious disease, accuses a woman or girl of being unchaste, accuses you of being incompetent in your job or trade. So let's move on to the other type of defamation, which is libel. Libel refers to defamatory statements made in a permanent form, like writing, printing, or broadcasting on a radio or television. For example, if someone says something harmful about another person and then a secretary writes it down, the spoken words are slander, but the written version is libel. The difference between slander and libel. So slander is a civil wrong, while libel is both a civil and. Slander is temporary and usually involves spoken words or gestures, while libel is permanent and typically involves written or visual forms like writing or images. Number 2, proof of damage. In slander, the plaintiff must prove actual damage because the harm is not long-lasting. In libel, no actual damage needs to be proven because it is seen as more serious and long-lasting. Number 3, intent and malice. Slander may occur spontaneously or unintentionally, often in the heat of the moment due to sudden provocation. Libel usually involves greater deliberation and can imply the presence of malice or ill intent. Number 4, responsibility for publication. Every time slander is spoken, it suggests that the person saying it acted personally and voluntarily, making them potentially liable. In libel cases, the actual publisher may be an innocent party like a news reporter, so they may not be held responsible. So what are the defenses to defamation? So the number one defense to defamation is justification. Claiming that the statement is true is a strong defense against defamation. If the statement is true but has minor inaccuracies, it can still be defended as long as the main part is true. Fair comment. Number two, making honest, relevant, and non-malicious comments on matters of public interest is a defense against defamation. Fair comments are opinions on facts, not false statements. Number three, absolute privileges. On certain occasions, individuals are legally protected from defamation claims, no matter how damaging the statement. These occasions include statements made during parliamentary or court proceedings, confidential communications like between spouses or attorney clients. Number four, qualified or conditional privilege. This defense applies when someone makes a defamatory statement in the discharge of social or moral duty without malice. The statement must be made to someone with a corresponding interest or duty to receive it. An example is providing a reference for a former employer to a potential employee. Number five, apology or offer of amends. A defendant can offer to correct a defamatory statement and apologize. If the plaintiff accepts this offer, the defendant may be released from liability. To use this defense, the defendant must show that the statement was made without malice and that they did not know it was defamatory at that time. Consent or assumption of risk. Consent from the person affected or the implied agreement to the publication can serve as a complete defense. For instance, if someone willingly provides false information about themselves, they can't sue for defamation when that information is published. These defenses help protect individuals and organizations from defamation claims when specific criteria are met. So, remedies against defamation. So, number one is damages. The plaintiff can receive monetary compensation for harm to their reputation. The amount of damages depends on how serious the defamation is, how widely it spreads, and the plaintiff's status. So injunction is a court order to stop or prevent publication or continued publication of a libel. Number three is apology. Apologizing is another way to remedy defamation. An apology helps correct the negative impression created by the defamatory statement. So these remedies aim to repair the damage caused by defamation, whether through compensation, stopping further harm, or correcting the record. Let's move on to arbitration. So commercial arbitration. So arbitration is an old way to resolve disputes outside of court. Instead of going to court, people agree to let a neutral third person decide the matter. This method avoids complex legal procedures and ensures fairness within the boundaries of the law. The rules of the arbitration are in the Arbitration Act. So let's talk about terminologies. So the first one is arbitration agreement. This is a written agreement to use arbitration to settle current or future disputes, even if it doesn't specify the arbitrator. The arbitrator. So the arbitrator is the person chosen to settle the disputes. Arbitration is the process of resolving the issues with the arbitrator's help. So an award is the decision made by the arbitrator. It's the outcome of the arbitration. So let's move on to essentials of arbitration agreement. So the first thing, it's the agreement to use arbitration must be in writing. Even though signatures aren't always necessary, it should be clear that both parties agreed to settle the dispute through arbitration. So number two, it should have essential contract elements. So both parties must understand and agree to the terms. If it's unclear or uncertain, it won't be legally valid. So the other one is number three, which is the arbitration agreement should involve a current or future disagreement between the parties. So number four, if a contract with an arbitration clause becomes void for some reason like frustration or fraud, the arbitration clause itself can still be binding and enforceable. So effects of arbitration clause. When two parties agree to resolve their dispute through arbitration, the court must respect this agreement. If one party starts a legal process related to the dispute, the other party can ask the court to halt those proceedings. The court will grant this request if it finds that there is a good reason refer the matter to the arbitration instead. For the court to stop legal proceedings and allow arbitration, several conditions must be met. So let's start with number 1. There must be a valid written arbitration agreement in place before the legal proceedings started. The subject of the dispute in legal proceedings should match what's covered by the arbitration agreement. In other words, they should be about the same issue. Number 3, the request to stop the proceedings should come from a party involved in the arbitration agreement or someone connected to them, like heirs or legal representatives. Number 4, the applicant shouldn't have taken any significant steps in the legal proceedings. They need to make this request at the very beginning before filing any official documents or progressing too far. Number 5, the request should be made to the same court where the legal proceedings are happening. Number 7, the applicant must show that they were willing to and prepared to fully participate in the arbitration process from the start of the legal proceedings. Number 7, finally, the court must not find any other compelling reason why arbitration shouldn't be used. It's important to note that even if all these conditions are met, the court can still choose whether or not to stop the legal proceedings and allow arbitration. So let's move on to matters which can or cannot be referred to arbitration. This is a subtopic. So arbitration is a way to resolve disputes between parties when it comes to private rights or obligations that civil courts can typically handle. However, there are certain conditions that need to be met. Here is what can be taken to arbitration. Determination. Number 1, determination of damages. When there's a dispute about the amount of compensation due in a case of contract breach, this can be resolved through arbitration. Personal rights. So matters, number 2, personal rights. So matters concerning personal rights, like who should hold a religious office in a church, can also be subject to arbitration. Number 3, compliment and dignity. Disputes related to respect and honor can be settled through arbitration. Number 4, time-barred claims. Even claims that might be considered too old to be pursued in regular courts can be taken to arbitration. So these are the things that cannot be taken to arbitration. So the first one is matrimonial matters. These include issues related to divorce or the right to conjugal life. Number 2 is testamentary matters. These are matters regarding the validity of a will, which cannot be decided through arbitration. If you're dealing with cases of will, you cannot decide it through arbitration. So another one is insolvency. So cases involving bankruptcy or insolvency are not suitable for arbitration. Number 4, public charities. Matters related to public charities and charitable trusts should not be arbitrated. Number 5, guardianship of minors. Disputes about who should have guardianship of a minor child are typically handled by courts. Number 6, lunacy proceedings. Legal proceedings related to mental health or insanity are not appropriate for arbitration. Number 7, criminal or illegal matters. Any issues related to criminal activities or illegal transactions are not suitable for arbitration. Number 8, execution proceedings. Matters regarding the enforcement of legal judgments are usually handled by the regular courts. Keep in mind that these are general guidance and there may be specific laws and regulations that apply in your jurisdiction. Arbitration is flexible and it is an efficient way to resolve disputes, but it's important to understand its limitations and consult legal experts when needed. So who can refer to disputes to arbitration? So the arbitration agreement is essentially a contract. Here is a breakdown of who can and cannot participate in arbitration. So the first types of people who cannot participate in arbitration are minors and lunatics. So minors are people under the age of 18, and individuals that are declared legally insane are called lunatics and cannot engage in arbitration. However, a natural guardian like a parent can enter into an arbitration agreement on behalf of a minor, but only if it benefits the minor. So number 2, attorneys and counsel. So lawyers have the authority to handle legal matters, including deciding whether to use arbitration on behalf of their clients. They can do this as long as it is in the best interest of their clients. So number 3 is partners. A partner in a business can agree to arbitration only if they have explicit authority from the partnership agreement or if it's a customary practice in their case. They cannot do this without proper authorization. So Number 4 is representing others. If a person tries to submit a dispute to arbitration on behalf of themselves and others who have a shared interest in the matter but without the explicit authorization, only the person making the submission will be bound to it. However, with the express consent and authority of others involved, that person can represent them in arbitration. So number 5, authorized agents. An authorized agent is someone with the legal power to act on behalf of another, can refer a dispute or to arbitration. This includes agents with proper authorization from the principal. Trustees, these are individuals entrusted with managing assets for the benefit of others, can also initiate arbitration. Insolvent individuals, so individuals facing insolvency, financial inability to meet debts, cannot personally engage in arbitration. However, if there is an official receiver or assignee appointed by the court, they may engage in arbitration, but only with the court's permission. It's important to note that these rules can vary depending on the legal jurisdiction and specific circumstances. In all cases, proper legal advice and guidance are essential to ensure that arbitration agreements are made correctly and within the bounds of the law. Implied provisions in an arbitration agreement. So these are assumed provisions that every arbitration agreement has to have, and they include number 1, a single arbitrator. So by default, unless the agreement says otherwise, the dispute will be handled by one arbitrator. Number 2, even number of arbitrators. If the agreement specifies an uneven number of arbitrators, they must choose an umpire within 1 month from the latest date of the appointment. The umpire serves as a neutral decision maker in the case the arbitrators cannot agree. So number 3, time limit. The arbitrators are expected to reach a decision within 4 months from the start of arbitration process. Number 4, umpire's deadline. If the arbitrators fail to make a decision, the umpire must issue the award within 2 months of being appointed. Number 5, oath and examination. The parties involved in the arbitration agree to be examined by the arbitrators or the umpire and oath. This allows them to provide evidence and answer questions during the arbitration process. Number 6, final and binding decision. The award made by the arbitrators or umpire is considered final and legally binding on all parties involved. Number 7, cost determination. The arbitrators or umpire have the authority to decide how the costs associated with the arbitration, including their fees, will be allocated among the parties. They use their discretion to determine these costs. So these provisions serve as a standard framework for arbitration agreements, providing clarity and fairness in the arbitration process unless the parties explicitly state otherwise in the agreement. So appointment and removal of arbitrators and umpire. An arbitrator is a person chosen to settle disputes between 2 or more parties outside of a regular court. However, the arbitrator's appointment isn't final until they agree to and accept the responsibility. If the parties can't agree on an arbitrator, or if the chosen arbitrator can't or won't fulfill their duties, the court has the authority to step in and appoint one. In cases where the arbitration agreement states that each party should choose an arbitrator, and those 2 arbitrators should then select a third one, this is essentially the same as appointing an umpire. This third person helps resolve the disputes if the initial 2 arbitrators can't reach an agreement. Once an arbitrator or an umpire is chosen and accepts the role, the authority can't be revoked unless the arbitration agreement specifically allows for it. However, if an arbitrator or umpire fails to make a decision or behaves improperly during the process, any party involved can ask the court to remove them from their position. This ensures that the arbitration process remains fair and effective. Powers of arbitrators and umpires. So number 1 is administering oaths. This means making people promise to tell the truth when they come to court. Number 2, asking for court's opinion. This is like asking the judge for help or advice in a specific situation. Number 3, conditional or alternative awards. Conditional or alternative awards is like saying, if this doesn't work, try this instead in a legal decision. Number 4 is fixing mistakes, correcting any small errors or typos in a legal decision. Number 5 is questioning parties, asking the people involved in a legal case some questions to get more information. So, duties of arbitrators and umpires: checking appointments, make sure the people chosen for specific roles in a case are the right ones. Number 2 is ensure that disputes being addressed are within the scope of the agreement so that the decision won't be invalidated due to lack of authority. Number 3 is making an award. This is issuing a final decision on the matter being discussed. Number 4 is being fair and impartial. This is acting like a judge and treating all sides equally and fairly. So number 5 is avoiding personal interest and making sure they don't have any financial stake in the outcome of the case. Number 6 is conducting properly, which means behaving appropriately and professionally throughout the process. Number 7 is staying within authority, which means not making decisions that go beyond the powers granted in the arbitration agreement. Number 5 is providing a final decision on all issues unless you have permission to make multiple decisions. So let's move on to an award. So what is an award? An award is like the final decision made by an arbitrator or by like a judge on all the issues they were asked to settle. It's the result of the parties choosing their own decision maker. The decision is just as binding as a court's ruling. So what makes a valid award? So for an award to be valid, it must have the following characteristics. Number 1, it must be written down. Number 2, it has to stick to what the parties agreed upon. It can't decide things outside of that agreement. Number 3, it has to be the final say on all the matters brought up. Number 4, it has to be clear, reasonable, and doable. Number 5, it has to have a date and be signed by all the arbitrators at the same time in front of each other. Number 6, it has to follow the law and the powers given in reference. So this is how an award works. So an award is like a weapon sword, because the winning party can use it to get a court judgment in their favor. Once it's that judgment, it leads to a decree, and there's usually no way to appeal the decree unless it's considered too excessive based on the award. An award also acts like a shield because it can be used as a defense in a lawsuit that goes against it. It is the final word on the issues it covers unless it's set aside or sent back for reconciliation, modification, reconsideration, and setting aside of an award. This is a subtopic. So after an award is made, once a decision is made in a case, it's final and binding. However, there are some situations where it can be corrected, adjusted, or cancelled. So these are the people who can make changes to an award. So changes to an award can be made by the arbitrators or the court depending on the situation. Arbitrators can make changes when, number 1, there's a simple mistake in the award, like a typing error. Number 2, the award is sent back to them for a second look. The court can make changes when, number 1, part of the award is about something that wasn't part of the original dispute. Number 2, the award has clear mistakes that can be fixed. Number 3, there are clerical mistakes or errors in the award due to accidents or omissions. The court can send the award back for review when the award doesn't decide some of the issues it was supposed to. The award decides issues that weren't part of the dispute. Number 3, the award is so unclear that it can't be carried out. Number 4, there is something obviously wrong with the award even just by looking at it. So these are the cases where the court can cancel an award. So the court can cancel an award when, number 1, the arbitrator or decision maker acted badly during the process. Number 2, the award was made after a court order to stop the arbitration. Number 3, the award was obtained improperly or is not valid. So advantages of arbitration. So number 1, privacy. The process is private and not in the public eye. Number 2, simplicity. The way things are done are simple and informal. Number 3, there are no appeals. There are no long and uncertain appeals because the decision is final. Number 4, lower costs. It is usually cheaper. Number 5, it is quicker than a regular court trial. Number 6, it is if it's a technical issue, an expert in that field is chosen as the decision maker. Number 7, it is concept based and the decision is based on what both parties agree. Number 8, confidentiality. People feel comfortable sharing information because their business competitors aren't present to learn their secrets. And so disadvantages of arbitration. Number 1, the person making the decisions might not know enough about the industry or the law related to the dispute. Biased arbitrator. The decision maker could be influenced or unfair in their duties. Number 3, lack of public hearing. Because the process is private, it may not follow the fairness of a public hearing. Number 4, limited appeals. Since the arbitrator decisions are final, it limits people's ability to appeal. Number 5, no criminal cases. Arbitration only deals with the civil cases, not criminal ones. Number 6, informal process. The less formal way things are done in an arbitration can sometimes lead to unfairness or injustice. Powers of courts in relation to arbitration proceedings. So, number 1, revoking authority. This means allowing a party to take back their choice of arbitrator. Number 2, appointing arbitrator, so the court can choose an arbitrator or umpire in specific cases. So number 3, it can cancel a sole arbitrator by removing a single arbitrator chosen by one party. Number 4, it can replace arbitrators. Number 5, it can give an opinion in a unique situation where it is presented by an arbitrator. Number 6, it can fix the award, which means changing or correcting the decision that was made. Number 7, it can file the award, which means officially recording the decision made by the arbitrator. Number 8, it can review the decision of the arbitrator and return it to the arbitrator or umpire for reconsideration. Number 9, the court can issue judgment and make a legal decision based on the award and create an enforceable order. Number 10, it can make temporary decisions to counter actions meant to delay or block the execution of a decree based on the award. Number 11, it can cancel the arbitration by stopping the arbitration process. It can, number 12, give more time for the award to be made. Number 13, it can halt legal proceedings by pausing any lawsuits or legal actions related to the matter covered by a valid arbitration. Number 14, it can resolve disputes about how much arbitrators should be paid and who covers their expenses. Number 15, it can be used to order witnesses to appear before the arbitrators. Number 16, it can punish non-cooperation by taking action against parties or witnesses who do not cooperate or show disrespect during the investigation. So let's talk about intellectual property law. So first, let's define what intellectual property is. So intellectual property is basically what you have created with your mind. So examples of intellectual property include books, arts, conventions, copyrights, trademarks, and more. So it's all about safeguarding the things that we create using our minds and efforts. So importance of protecting intellectual property. Number 1, encourage investment. Encourages people to share the creations with the public without worrying about exploitation. So they are more likely to invest their time and money. Number 2, it ensures fairness by protecting the products of a person's hard work and skills. Number 3, it serves as proof of ownership, that something belongs to a specific person or company, and keeps away people who might try to copy it without permission. Number 4 is brand recognition by helping you distinguish one person's or company's products from others by building trust and loyalty. Number 5 is it helps in creating and maintaining strong brand identities and quality. Number 5, it allows business to cater to different groups in society with various market strategies. Number 7, it prevents your profits from being stolen from people who are trying to make money from your work. Number 8, it makes it easier for consumers to choose products by providing recognizable brands, simplifying their decision making. So types of intellectual property. So number 1 is copyright. So what is copyright? Copyright is like a protective shield for someone's creative work, such as writing, art, music, or broadcasts, to prevent others from copying it for business or personal gain. It's a legal right automatically given to the creator and you don't need to register it. So let's move on to types of works protected by copyright. So literary works, so these are novels, books, stories, poems, plays, biographies, and dictionaries. Number 2, these are broadcasts. This includes things like sounds, images, signs, or signals that are transmitted. Number 3, musical works. This covers compositions with music, lyrics, or actions meant to be sung, spoken, or performed with word. Number 4 is artistic works. These are drawings, sculptures, or architectural designs or more. So copyright is like a legal shield that guards creative works from being copied and used without permission. It applies to different forms of artistic impression, infringement of copyright. So what is copyright infringement? So this means breaking the rules of copyright by doing something with the creative work without getting permission from the owner. This can happen if someone, number 1, copies the work in any way. Number 2, shares or publishes the work as if it was not published before. Number 3, performs the work in public. Number 4, broadcasts the work. So In simple terms, it's like using someone else's creative stuff without their permission, and that's not allowed under copyright law. So remedies for copyright infringement. So if someone steals your work, these are the actions you should take. So you can ask for money as compensation for the damages that the person has brought to by using your work. So number 2, you can get infringing copies taken away or confiscated. This is called interdict. So number 3, the owner can demand that the violator hands over the infringing copies either to them or someone they authorize. So number 4, injunction. So the owner can ask the court to order the violator to stop further copyright violations. So number 5 is criminal prosecution. In some cases, the violator might face criminal charges and punishment in court. So let's move on to number 2, trademark. So what is a trademark? A trademark is like a symbol, a special symbol, word, or design, or a combination of these things that a person or company uses to make their products or services stand out from everyone else's. It's how they tell the consumers this is our stuff. So trademarks are important because they help regular folks, consumers recognize and tell apart products or services from one person or company compared to others in a market. If every trademark for a company was the same, you wouldn't be able to distinguish maybe a different company from the other. So to make sure that a trademark is legally recognized and protected, it must be officially registered with the Kenya Industrial Property Office as required by the law. Okay, so let's move on to infringement of a trademark. So what is trademark infringement? Trademark infringement means breaking the rules of trademark rights for goods or services. Goods or services are considered to be infringing a trademark if the packaging looks exactly the same or similar to a registered trademark. Number B, the labels or advertisements would break the rules of a registered trademark. Number C, the way they are meant to be used would violate a registered trademark. In simpler terms, it's like using a logo or a name that's very similar to a registered trademark without permission, which is not allowed. So what are the remedies against infringement of trademark? So here the actions the owner can take if someone violates their trademark. So you can prosecute the criminal. Number 1, criminal prosecution. This is the owner can involve the public authorities to take the infringer to court, where the court can give a suitable punishment. Number 2, statutory damages. The court can order the infringer to pay a certain amount of money or compensation to the owner, even if the owner can't prove exactly how much they lost. Number 3, they can account for profits. In addition to damages, the court can tell the infringer to give back the money they made from the infringement. Number 4, injunction. The court can issue a temporary or permanent order that stops the infringer from using the trademark in question. Number 5, removing the offending mark. If someone is found guilty of trademark infringement, the court can order them to erase or get rid of the trademark that they used wrongly. Number 6, returning infringing goods. The trademark owner can ask the court to make the infringer hand over any goods, materials, or items that break the trademark rules to either the owner or someone they authorize. So number 3 is patents. So patent is like a special permission given to an inventor. It allows the inventor to be the only person who can make, use, and sell the invention for a certain period, usually a limited time. This means no one else can do these things without the inventor's permission. So during that time, it's like having a legal monopoly. The government gives this monopoly to the inventor to stop others from using or selling the invention without the inventor says so. However, the inventor can choose to sell or share this monopoly to others. So requirements for getting a patent. So the first requirement is novelty or newness. So this means the invention must be something brand new, not known to anyone before the inventor created. It must be original and not something that already exists in the community or society. Number B or number 2, the invention must be a bit of a creative leap, not something obvious to someone skilled in that field. It can't just be a small logical progression from something that's already known. Number C or 3, it can be it has to be, you can say, industrial application. The invention should be something useful in the industry, like farming, medicine, or fishing. It should benefit society in some practical way. Number D or Or number 4, patentable subject matter. To qualify for patent protection, the invention must not be something that the law says can't be patented. This includes things like natural discoveries, scientific theories, certain types of plants, surgical methods, mathematical processes, and more. Infringes and remedies for patents. So what is patent infringement? Patent infringement happens when someone makes, sells, gets rid of, or brings into a country an invention without the inventor's permission. What can an inventor do? If someone violates a patent, the inventor can take these actions. Number 1, damages. They can ask for compensation as in monetary terms for the violation. Number 2, they can interdict, which means getting the infringing products taken away or confiscated. Number 3, injunction. They can ask the court to order the violator to stop doing more patent violations. So number 4, the inventor can request the violator to give back the money they made from the violation, which wasn't considered while calculating damages. Number 5, returning of infringing products. The inventor can apply for a court order that makes the violator hand over the infringing products or items to either the inventor or someone authorized by them. So let's move on to passing off. So what is passing off? Passing off is a legal way to protect and register trademark rights. It happens when a person misrepresents or copies the reputation of another person's goods or services. It is used to prevent confusion about where a product or service comes from. So passing off helps business protect the positive reputation associated with their brand. It's not about protecting the logo or name itself like trademarks do, but rather the good reputation connected to. Its aim is to stop someone from fooling the public by pretending their goods or services are from another person. Differences between trademark and passing off. So, number 1, trademark registration. Trademarks must be registered to take legal action for infringement. Passing off is used when the trademark isn't registered. Number 2, proof required. In a trademark infringement case, showing the trademark is registered is usually enough. In passing off, you need to prove that you have good reputation and goodwill associated with your goods or services. Number 3, basis of law. Trademark infringement is governed by statutory law, laws made by the government, while passing off is based on common law, legal principles developed through court decisions. Scope. So number 4, scope. Trademark infringement deals only with the specific goods or services covered by the registration. Passing off is concerned with the general reputation of the plaintiff's goods or services. Remember, passing off is a remedy when trademark registration isn't possible, and it's used to protect a brand's good reputation. Let's move on to bankruptcy law. So bankruptcy law comes into play in a market economy when people face financial problems and can't pay their debts. It's there to balance the interests of creditors and debtors. So the reason why bankruptcy law exists: number 1, to protect debtors. It safeguards innocent debtors from being harassed by creditors. To help embarrassed debtors, it provides the relief to debtors who can't pay their debts. Number 3, fair treatment. It stops creditors from taking a debtor's assets unfairly. Number 4, protect everyone's interests. It looks out for both creditors and debtors. Number 5, prevent fraud. It investigates if there's any cheating or bad behavior by the debtor and punishes them if needed. Number 6, fairly share assets. It ensures that debtors' assets are divided fairly among creditors. Number 7, fresh start. It helps debtors to start fresh without the burden of their debts. So bankruptcy process. This is a legal procedure where a court takes a debtor's property, sells it, and uses the money to pay off creditors based on how much they are owed. So who is a bankrupt person? So a person is called bankrupt when a court officially declares them as one. This declaration is known as an adjudication order. So bankruptcy law exists to make sure that when people face financial problems, the process is fair to both those who owe money and those who are owed money, and it allows people to make a fresh start. Acts of bankruptcy. So what is an act of bankruptcy? This is something a debtor does or experiences that shows they are in financial trouble and can't pay their debts. It's like a red flag that allows the court to declare the debtor bankrupt. Bankruptcy proceedings can only start if it's proven that the debtor committed an act of bankruptcy. So examples of acts of bankruptcy. So number one, transferring of property. If a debtor gives away or transfers a big part of their property to someone else for the benefit of all their creditors, it is a sign of financial trouble. Any creditor who isn't part of this transfer can ask for bankruptcy. So number two, fraudulent transfer. For example, if they give one creditor an advantage over others, in the sense that if a debtor moves their property to cheat or delay their creditors, it is fraudulent. Number three, fraudulent preference. So fraudulent preference, if a debtor gives priority to one or more creditors over others by transferring property or making payments with the intention to do so, it's a problem. Number four, living or hiding. If a debtor leaves Kenya, their home or business, or isolates themselves to avoid their creditors, it's a sign of trouble. Number five, property sale after attachment. If a debtor's property is sold or taken away to pay a court-ordered debt after being attached for 29 days, it's considered an act of bankruptcy. Number six, if declaring inability to pay. If a debtor files a statement in court saying they can't pay their debts or starts a bankruptcy petition against themselves, it's an act of bankruptcy. Number seven, suspending debt payments. If a debtor tells a creditor they are stopping or about to stop paying their debts, is another sign. Number eight, ignoring court order. If a creditor has a court order for the debtor to pay money and the debtor doesn't follow it or has a good reason not to, it can be seen as an act of bankruptcy. In short, acts of bankruptcy are actions or situations that can indicate financial trouble, and they can lead to bankruptcy proceedings. So this is the bankruptcy procedure. So the first one is bankruptcy petition. So starting bankruptcy proceedings. When someone wants to begin a bankruptcy proceedings, they do it by filing a petition in the court. The petition can be filed by a creditor or the debtor. The petition must say that the debtor can't pay their debts and ask the court for a receiving or adjudication order. Conditions for a creditor to file for a petition include, so A, the debt must be at least 1,000 shillings. There has to be a clear debt amount, so it should be a specific amount. And number C, the debtor must have done something that shows they are in financial trouble. Number four, or number D, this act of bankruptcy must have happened in the last 3 months before the petition is filed. So the final one, number 5, or E, or letter E, the debtor must have lived or had a place of business in Kenya or been a resident in Kenya in the year leading up to the petition being filed. So if a creditor wants to start bankruptcy proceedings, they need to make sure these conditions are met. Number 4, hearing of petition. Number 2, hearing of petition. Creditor's petition hearing. When a creditor files a petition hearing, she is scheduled 8 days after it's served to the debtor. During this hearing, the creditor needs to prove these 3 things. Number 1, the creditor must show that the debtor owes them money. Number 2, they have to prove that they are properly delivered the petition to the debtor. Number 3, the creditor has to demonstrate that the debtor did something that shows they are in financial trouble. So after the hearing, the court can do one of these 3 things. So letter A is dismiss the petition. So if the creditor doesn't provide enough evidence for any of the 3 requirements, if there are no good reason for the petition, the court can throw it out. Number B, make a receiving order. If the court is convinced that the debtor is indeed in financial trouble and the creditor proved their case, they can issue a receiving order. This is a legal step towards bankruptcy. Number C, determine the debtor can pay debts. If the court believes the debtor can pay the debts, they can dismiss the petition. Number 3, interim receiver. So before the court officially declares someone bankrupt, they can appoint an interim receiver if it's needed to safeguard the debtor's property. This is especially true when the debtor filed the bankruptcy petition themselves. Usually the official receiver takes on this role. The court can also issue an order to pause or stay any actions like legal proceedings or efforts to take the debtor's property until they decide what to do with the bankruptcy petition. This helps ensure a fair process and protects the debtor's order. So number 4 is receiving order. So making a receiving order it says that if the court doesn't dismiss or oppose the bankruptcy petition, they will issue a receiving order. When this happens, the official receiver takes charge of the debtor's property. So important things to know is that the receiving order doesn't take away the debtor's ownership of their property. They still legally own it. It doesn't automatically make the debtor bankrupt. It just means they can't control or use their property for now. The other one is the receiving order is published in the Kenya Gazette and a local newspaper to inform the public about the situation. So a receiving order puts the debtor's properties in the hands of the official receiver temporarily, but it doesn't change who owns the property, and it's not the same as declaring bankruptcy. So let's move on to settlement of debtors affair, which is number 5. So debtor settlements affair means when the receiving order is issued, the debtor has to give the official receiver a document called the Statement of Affairs. The document has information about the debtor's financial situation. Here are the key points. So number 1 is timing. The debtor must submit the statement within 3 days if they initiated the bankruptcy process themselves. If a creditor started it, they have 14 days to submit it. Number 2, contents. The Statement of Affairs includes details about what the debtor owns, what they owe, and information about the creditors. It also lists any property used as collateral by those creditors. Number 3, importance. If the debtor doesn't provide this statement, it could lead to them being declared bankrupt. So let's move on to number 6, which is creditors' first meeting. After the receiving order is issued, the official receiver has to organize the first meeting of creditors within 60 days. This meeting has 2 main purposes. So the first purpose is to decide bankruptcy. This means creditors decide whether to officially declare the debtor as bankrupt. Number 2 is considering options. Creditors also discuss and choose between 2 options. The number A, this means number A is composition, which means the debtor can keep the assets but has to pay a specific amount to the creditors from those assets. Number B is scheme of arrangement. In this case, the debtor's assets are handed over to a trustee who then manages the assets and makes payments to the creditors. So at this meeting, the creditors decide the debtor's fate and which financial arrangement to follow. So number 7 is public examination of debtor. So once a receiving order is issued, the official receiver sets up a public examination of the debtor, which includes number 1, the purpose, or A, the purpose. Let's go with A. The purpose, the examination is to find out more about the debtor's behavior, financial dealings, and property. Number B is the debtor has to answer questions while under the oath, which means they have to tell the truth. Number C, the official receiver, the trustee in bankruptcy, creditors, and even the court can ask the debtor questions during this examination. So let's move on to number 8, which is the adjudication order. So as we said, when the receiving order is not cancelled and creditors don't agree on a composition or arrangement, the court declares the debtor bankrupt. There's a significant step and it's published in the Gazette notice, which is a public record. Here is when it happens. Circumstances for bankruptcy means the court makes these decisions in various situations. A, if creditors during their first meeting decide that the debtor should be declared bankrupt. B, if not enough creditors show up for the first or any subsequent meetings. If creditors can't reach any decision. D, if creditors don't meet at all. E, if the agreed upon composition or arrangement falls through. F, if the court cancels a composition agreement. G, if the debtor asks to be declared bankrupt or agrees to it. H, if the court believes the debtor has disappeared or has no intention of reaching an agreement with creditors. I, if the public examination of the debtor is indefinitely postponed. J, if the debtor doesn't provide the financial statement without a good reason. K, if the debtor misses payments for an agreed upon composition or arrangement. So in short, bankruptcy is declared in these situations if no other solution is found. So effects of receiving a bankruptcy order. So when the court declares someone Number 1, when the court declares someone bankrupt, the official receiver takes control of their property. The bankrupt person can't do anything with their property without any official receiver's permission. Number 2, the bankrupt person must regularly update the official receiver with the address, job details, and income every 3 months. Number 3, no one can take legal action against the bankrupt person or their property without the court's permission after the bankruptcy order. Number 4, if there were ongoing legal actions against the bankrupt person, they might continue the court's permission and under certain conditions. Number 5, the court may appoint a special manager to assist the official receiver, especially if the bankrupt had a unique business. Number 6, the court can issue a protection order to prevent the bankrupt person from being arrested or detained by creditors. Number 7, disqualifications. After bankruptcy, a person can't: Number 1, hold public office. Number 2, become a judge or magistrate. Number 3, get elected to parliament or government. Number 4, hold certain offices in county government. Number 5, deal with property worth cash 200 or more without considering the creditors. Number 5, start a business under a different name without disclosing their bankruptcy. Number 8, act as a company director without the court's permission. So these rules and restrictions are in place to manage the situation and protect both the creditors and the person who's declared bankrupt. So let's talk about discharge of a bankrupt. So a bankruptcy can be discharged in the following ways. Let's move on to number 1, which is application for discharge. After being declared bankrupt, you can ask the court to release you from bankruptcy, but this can only happen after your public examination is done. Number 2, types of discharge orders. The court has the following options when it comes to discharge orders. So the first one is absolute discharge, which means you are completely released from most debts except for a few special ones. Number 2 is suspended discharge, which means you are released, but this release is delayed for a set time. Number 3, discharge with conditions, which means you are released but you have to meet certain conditions. Debts not cleared in absolute discharge means that you are still responsible for some debts, which include number 1, debts to the government, debts due to fraud or breach of trust, certain judgment debts related to seduction and marital matters. So the court can say no to discharge in the following situations. So number A, your assets can't pay at least cash 10 for every cash 1 you owe. Number B, you didn't keep proper business records for 3 years before bankruptcy. Number C, you took on debt without any realistic way to pay it. Number D, you can't explain where your assets went. Number E, you caused your own bankruptcy through risky behaviors, overspending, gambling, or neglecting your business. Number F, you spent money fighting legal actions against you when you didn't have to. Number G, you gave special treatment to one creditor within 3 months of the bankruptcy, especially if you couldn't pay your debts on time. So these rules help make sure that the bankruptcy is fair and that people don't take advantage of the system. So let's move on to powers and duties of official receiver. So powers of official receiver, these are the actions that the person in charge of handling a bankrupt person's affairs can take. So the first one is where is it? So the first one is to sell property. They can sell any or all of the bankrupt person's belonging. Number 2 is divide money, which means they can distribute the money they get from selling things among the creditors. Number 3 is managing the business. If needed, they can run the bankrupt person's business for the purpose of settling debts. Number 4, handling legal matters by dealing with legal cases related to the bankrupt person's property. Number 5, accept payments for the sale of property under terms approved by the court. Number 6 is mortgage the property by using some of the bankrupt person's property as collateral to borrow money to pay debts to keep the business going. Number 7, they can use arbitration to resolve disputes arising from the bankruptcy through arbitration. Number 8, they can negotiate debts with creditors to settle debts on agreed terms. Number 9, they can divide non-sellable property if there are items that can't be sold easily and divide them among the creditors. So, what are the duties of official receiver? So, number 1 is to take control, which means they need to collect and keep safe all the important papers, records, and belongings of the bankrupt person. Number 2 is sell the stuff. If there are things that can be sold, they should do it as quickly as possible in a way that makes them the most money to pay the creditors. Number 3, they should be fair when they have money from selling things. They have to be honest and treat all the people owed money, creditors, fairly and without favoritism. Number 4, they have to keep records of all the money they get and how it's used. Number 5, they have to arrange meetings with creditors and talk to them and listen to what they have to say during these meetings. So let's move on to priority of payment of debts. So when the person in charge of handling bankrupt affairs distributes their property, they must follow a specific order of priority of payments. Here's how it works in simple terms. So number 1, taxes and rates. First, any taxes owed to the government and local rates need to be paid. Second, government rents, which means if the bankrupt owes rent to the government, that comes next, but only if it's not more than 5 years overdue. So number 3 is the workers' wages. The money owed. This is the money owed to the employees as wages for the 4 months before the bankruptcy order is issued. Should be paid, but it should not exceed 4,000 shillings. Number 4, work injury benefits. Any amounts due as compensation under the Work Injury Benefits Act should be paid. Number 5, social security, which means contributions under the National Security Fund Act also need to be settled. This is an NSSF. Number 6, secured creditors, which means if there are any creditors who have security or collateral for their loans, they get paid next. So number 7, ordinary creditors, which means any remaining creditors without security get paid. These are often called ordinary or unsecured creditors. So let's move on to bankruptcy offenses. These are actions that go against the rules and laws related to bankruptcy. Here are some bankruptcy offenses explained. So number 1 is not disclosing property. If a bankrupt person does not reveal or hand over all the property they are supposed to, it's an offense unless they can prove they didn't mean to cheat anyone. Number 2 is withholding documents, which means failing to give the trustee all the documents or papers related to their property or financial matters is another offense unless there was no intention to defraud. Number 3 is hiding valuable property, which means if the bankrupt person hides or takes away part of their property worth at least 200 shillings within 2 years before filing for bankruptcy, it's an offense unless they can show they didn't intend to cheat anyone. So number 4, continuing to do business. This means if the bankrupt person knows they can't pay their debts but still runs a business within 2 years before declaring bankruptcy, it's an offense. So number 5, fraudulent actions, which means committing fraud to get credit or transferring property fraudulently to deceive creditors is a bankruptcy offense. So number 6 is using a different name. If the bankrupt person conducts business under a different name than the one they used when they declared bankrupt without telling the people they do business with about their bankruptcy, it's an offense. Number 7, not disclosing bankruptcy is also an offense, especially if you're not informing the creditors. Number 8 is leaving out important information like statements related to your financial situations is an offense unless you can prove you didn't mean to deceive anyone. Okay.